Hello, everyone, and welcome back to Uncivil Law, where we learn through the misfortunes of others. I am your host, Uncivil Law, a licensed attorney in Texas, Virginia, and before the United States Supreme Court, and we are here with your continuing coverage of the Ken Paxton impeachment trial. Ken Paxton is the Attorney General of Texas and is being impeached for misconduct relating to Mr. Paul, a real estate developer, who the allegations are that Ken Paxton used his office to benefit Mr. Paul in various ways, and then tried to cover it up, retaliated against whistleblowers, and other related conduct. So far, we've heard from two witnesses. We just finished the cross-examination of witness number 2, who, at least in my judgment, was fairly credible for the prosecution. So the prosecution is making some inroads, in my humble opinion. And we are going to see what is going on as we continue on in the court of impeachment, which is just the Senate, because of course it is, of Texas, of course. So that is what's going on. I'm getting better at summarizing this case in fewer words. I'm getting better and better at summarizing this case in fewer words. The trial is supposed to be 27 hours per side, so I think we're sometime into next week before this resolves. And we'll take it from there. We had some spirited disagreement, but respectful disagreement from the chat, which I always appreciate, on the relative credibility and weight of witness number 2, which I think goes to show, as always, how different people look at different things, which is always, helpful. How much do you believe this witness? How much do you not believe this witness? How much weight do you give this witness? I tend to think he's pretty credible, and I give him a significant amount of weight. Although I've only had 2 witnesses, so in the relative weighting of things, I think even the detractors would agree that he's entitled to more weight, although they might not agree that's very much in the end. Yeah, I saw that the clerk in the Murdaugh trial unsurprisingly lawyered up. One of the smarter decisions she's made recently. Get a lawyer. Yeah. If she couldn't see the writing on the wall, she was not paying attention. The Murdaugh case is, I was watching Ian Runkle from Runkle the Bailey cover it, and he was basically commenting that, if he was working at Hollywood and someone had scripted it, they tell him to tone it down because this is too unrealistic. I'm like, yeah, that's basically what's going on. Reality is too unrealistic. Not for the first time. Hopefully we'll get a lot more witnesses from the prosecution. Apparently there were something like 8 lawyers that defected, which is a lot of lawyers. 8 senior members of an administration leave. I'm going to take that seriously. Just a friendly reminder, if you haven't already retweeted the pinned link, to please do so. And we do appreciate everyone who's here. We could read more from her book. I'm not sure how much time we have. It looks like they're getting ready to get back together. So I'm not sure we really have time to read from her book. The Clerk of Court's book, which we've been reading from time to time as I look for ways to torture you. Let me read a little bit more from, I think it was chapter 19, the last chapter in the book, which we decided to skip to, of the clerk of court book, who decided to lawyer up in the Murdaugh trial because she probably did the witness tampering. Apologize, not witness tampering, jury tampering. I keep making that mistake, but at least I catch myself every time, so that's nice. The clerk of court wrote, "After the session, I had my chance to gossip with my girls, some of the other female clerks of court in the Palmetto State. Questions ranged from whether there could have been two shooters to what it was like having Alex and his family in the courtroom under those circumstances. They also wanted my opinion as to whether an appeal was likely. Yes. We all compared notes, and they empathized with what I felt was a bumpy start to my reading of the verdict. None of my colleagues had ever read directly from an indictment, which I did per Judge Newman's orders. Before my staff and I headed back to Walterboro at the end of the week, we grabbed a bite to eat at a place called The Land Shark, a newish restaurant in North Myrtle Beach, Barefoot Landing. Patty Zimmerman was our waitress. And immediately we struck up a conversation, which led to why we were in town. Once we told her about the clerk of court convention and that we were from Walterboro, we went from talking about today's specials to the nitty-gritty, the Murdaugh specials." They're speaking? Okay, I don't have volume. I guess I muted them. I did mute them. I apologize.
I'd be happy to offer it as AG 1005. If it's not being introduced to evidence, I don't objection to what we're doing, I don't think. I just don't know what...
My bad. Sorry.
If the court has it, I don't know whether the court has it.
Okay, we do have it. I thought I heard you just say if it's not being offered as evidence, you have no objection.
That's correct. That's correct.
Okay. So?
At this time, I don't intend to offer it into evidence. Mr. Bangert, are you
We're on the same
aware?
page?
Yeah.
Okay.
All right. So did you just say now that you are offering it?
No,
You're not offering.
I wasn't offering it at this time.
Thank you.
I might change my mind here in a second. We'll see.
All right. Fair enough.
Mr. Bangert, you are somewhat familiar with non-judicial foreclosure law, correct?
Did you ask, am I familiar with non-judicial foreclosure law?
Yes, I asked you if you were familiar with non-judicial foreclosure law.
It's been a while.
Okay. Well, you did write a memorandum about it and issue an informal legal opinion on the matter, correct?
If you're referring to the August 1st letter, I did assist Mr. Vassar in putting that together.
Okay. And in doing so, you probably had to research the law on non-judicial foreclosure opinions, true?
Not necessarily.
Okay. You're aware of when non-judicial foreclosures take place, correct?
Based on the document that I prepared, I believe it was the first Monday or Tuesday of every month, but
Okay.
that's my recollection.
Okay. If we said it was Tuesday, would you agree with that?
I would have no reason to disagree.
Okay. Now, the fact that that occurs every single Tuesday, that singular Tuesday of every month, that's a reason that Ken Paxton could have said, Mr. Banger, we need to get these done this weekend. True?
Yes, that could have been a reason.
Okay. And to be fair, Nate Paul is not the only person that had properties that were subject to potential foreclosures on that date, was he?
I don't know for a fact, but it seems reasonable to assume there would be other properties that would have been subject to foreclosure.
Okay. Potential homeowners, correct?
Again, I don't know of any particulars, but it's entirely possible.
So it's safe to say that it could have been someone that didn't have a job and didn't have money to pay their home loan, correct?
I have no reason to agree or disagree with that. I don't know.
Okay.
Which is a perfectly fair answer. He doesn't know. So that is a perfectly fair answer. That's not evasive. He doesn't know. How would he know? He has no clue.
That informal
I'm like, yeah, that's
guidance was
probably true,
issued.
but he doesn't know.
And to be clear, Eric, would you mind pulling up House Boards 119? That was not issued like a legal opinion was normally issued, correct?
Are you referring to?
No, I'm asking you personally.
Unless he likes spending his time at
Issue like a
courthouse,
formal
at
legal
foreclosure
opinion,
sales
correct?
or something.
It did not go through the formal
Or likes,
process.
reading legal
it was-
notices in
Just
newspapers.
answer yes or no when you can. Okay.
which I have better things to do
It
in
was
my
just a
time.
news post.
Although at this point, maybe I'll go to the next foreclosure sale at my county
Which
courthouse just
document are
because
you
I
referring
can.
to?
I'm referring
Maybe I'll bid
to
on
the
something.
informal
That could be
guidance
fun.
regarding the non-judicial foreclosure sales that you signed instead of
Then I
Ryan
can be like
Vassar.
Bart in that one episode of The Simpsons. What did I
It's a
get?
post on the website, right?
I believe it was made available to the public via our website.
Okay. And if we look at House Board 119, you state, we compromised by urging that, we agreed to compromise by placing a short, noteworthy post on the website, correct?
Yes, I wrote those words.
Okay. Now, after that noteworthy post was issued, we're in August of 2020, true?
We are in August of 2020, and I do think I need to correct the record on something
Just
that
a
you
yes or
asked
no
me.
question. Was it August of 2020?
We are in August.
Okay. You had no knowledge about anything to do with the renovations with regard to Ken Paxton's house at that time, did you?
The knowledge I had would have been through conversations with Mr. Mateer via Mr. Wicker.
You have no personal knowledge of that, do you?
I did not discuss that with Mr. Paxton, nor was I at his house.
You do not know who paid for the renovations to the Paxton's house.
At that time, I was unaware of who was paying for the renovations.
You don't know. You haven't seen any documents, have you?
I have seen documents that include testimony from individuals who have described.
It's a yes or no question.
I have seen
Have you seen documents that specifically show and prove who paid for those? Have you seen receipts?
I have seen documents strongly suggestive of who paid for that.
Okay. When did you first send your application for the Alliance Defending Freedom?
It would have been sometime in October.
Okay. Was it prior to leaving the Attorney General's office?
Yes, I was in conversation with ADF prior to leaving the Attorney General's office.
So when you said earlier that what you did with regard to reporting Ken to the FBI, going to the FBI being a death warrant for you, it did not affect your ability to get another job, did it?
It ended my ability to be employed by the Attorney General's office.
Well, no, because you resigned. You didn't get terminated, true?
I was constructively terminated.
Which is a perfectly
Submitted a
fair
letter of
answer.
resignation, did you not?
I did.
And then you went to work for a company or a firm that you had already applied for, true?
I did.
He knew the end was
At
nigh,
the end of the day,
and he went looking for a
you
life
have
raft.
to agree that Ken makes
What's
the
your point?
Mr. Paxton makes the final call on what opinions are issued by the Office of Attorney General, true?
I wouldn't put it quite that way.
Well, he has to sign the document, doesn't he?
Mr. Paxton has authority to make the final signature on the document.
So in the context of a legislator, a senator perhaps, if there's a piece of legislation that they don't like, or let me rephrase that, if there's a piece of legislation that one of their staff members does not like, and they want it to go through, the senator overrules his staff member, true?
I do not know how the senators make their decisions. I can only assume that senators, much like statewide elected officials, have ultimate authority in their offices.
Have you had any conversations with any statewide officials or legislatures regarding this case?
Nothing specific.
Nothing specific. Is there any record of that, of what you actually said?
No.
So it's kind of like your conversations with Mr. Harden and the House Board of Managers?
No.
He's trying like all these like technical gotchas that are just like, I can't be bothered to care. Didn't you say 5 when it was in fact 6? Didn't you say you went to lunch at Applebee's, but it was really a Chili's?
At this time, Judge, I would offer Attorney General's Exhibit 1004.
No objection. It will be admitted into evidence.
May I approach the witness, Judge?
Yes, you may.
Mr. Bangert, I've highlighted in orange on this document. I'm going to hand it to you. I'm going to ask you to read it, okay? The highlighted portion, okay? I want you to read it aloud, Mr. Bangert.
The highlighted portion.
One moment. Does Eric have it?
Eric does not have it, Judge. This is more of a rebuttal exhibit, if you will. So, Mr. Bangert, if you could read it aloud so that our jurors could hear the highlighted portion.
Yeah, read it.
Pardon me, Your Honor. May I approach him and ask him to highlight the portion that he's highlighted for the witness so I'll know what he's talking about? I just want to highlight on my copy.
Fair enough, man, you know. He has a right to see it, you know. You know? Amazingly enough, you know, you don't get to present something to the witness without the other lawyer also being able to see it.
Thank you.
These and other basic trial tactics brought to you by Uncivil Law.
I'm going to ask you to read the highlighted portion now. Aloud, Mr. Bangert.
The highlighted portion states, accordingly, my administration, to the extent reasonably necessary to prevent the further spread of COVID-19, will take all lawful measures to prevent residential evictions and foreclosures resulting from financial hardship caused by COVID-19.
That is an executive order issued by the Trump administration. Mr. Bangert, were you aware of this executive order when you filed or sent Mr. Vassar that email on September 30th of 2020?
Look at the date of the order. It's August 8th. I don't recall if I was aware of this order, but it was irrelevant.
It was irrelevant?
Yes.
Okay.
It is irrelevant.
It was a week after you just issued an opinion with regard to foreclosure sales, was it not?
It was 1 week after the August 1st opinion.
Okay. But it's your opinion that it's not relevant to your summary of what happened on that foreclosure opinion you drafted?
How could it possibly be relevant? It happened afterwards.
I'll take that back from you.
Do you understand how time works, sir? Is what happened on August 8th relevant to what happened on August 1? Probably not.
May I have a brief moment, Judge?
If I could turn back time, if I could find a way, I'd give you the Trump memo and you'd say...
Point of inquiry, please, Your Honor. I'm looking at the record as it was. Maybe counsel wants to have an opportunity to correct it. I think he referred to the order in a question. That is an executive order issued by the Trump administration, Mr. Bangert. I suspect he meant to say the Abbott administration, but I just want to make sure the record is correct. I don't know which he meant.
No, it's a federal order. I meant the Trump administration.
Pardon me?
It's a federal order. I meant the Trump administration.
Thank you. Okay.
I want to talk to you more about your representation by Johnny Sutton, Mr. Bangert. Was it after you ended your employment at the Office of Attorney General that you hired Mr. Sutton?
I began working with him prior.
You began working for him prior?
I began working with Mr. Sutton prior to ending my employment, yes.
You searched for Mr. Sutton on September 22nd of 2020, did you not?
He was recommended to me.
Okay.
I can't recall searching for him on September 22nd.
Okay.
Thank you.
This time, Your Honor, I would offer Attorney General Exhibit 312.
Any objection?
No objection?
It is admitted into evidence.
Okay. Mr. Banger, this is a download of your computer, and I'm going to approach you with it. I'm going to have you look at it and refresh your recollection.
It shows Texas leads the way nationally. I guess that's one way of looking at it, Don.
I didn't realize Eric had. Eric, you got it published, don't you? Okay, thank you. We see here on September 22nd of 2020 that you actually searched Johnny Sutton's law firm.
That's what the document represents, that I searched for the ashcroftlawfirm.com.
And that is where Johnny Sutton is employed, true?
He's one of the named partners there.
Okay. That is 8 days before you decide that you're going to go to the FBI and report Ken Paxton.
We went to the FBI 8 days later. Yes, that's correct.
So he's shopping for an attorney.
So you were searching for an attorney before you even knew that Brandon Kamick was issuing subpoenas at those banks.
Oh, no, I don't believe this had anything to do with looking for Mr. Sutton to retain him.
Oh, it's just a coincidence? Yes or no?
It probably is, yes. There's no reason. We were not searching for a counsel prior to that. I was not.
I'm going to ask you a question that Mr. Busby has stated earlier. Have you ever heard the term, there's no coincidences in the city of Austin?
I've never heard that term before. And there are plenty of coincidences.
It was a yes or no question, Mr. Banger. You said you'd never heard of it.
Never heard of it.
It's a stupid saying. Even if it were the most well-known saying ever, it doesn't make it true. Objection, hearsay. It is not. It seems to be offering. It seems to be being offered for the truth of the matter asserted.
FBI, true.
You know, it's like okay. It's like all right.
Now that is before you become aware of a second referral made to the Travis County District Attorney's Office. True.
Trying to recall when we became aware of that second referral. It may have been. I just don't recall precisely the order of events, but I believe it was.
I mean, you seem to have a great recollection of the order of events when Mr. Harden had you on direct examination. Are you saying that you're forgetting now?
No, I'm telling you that I'm trying to recall specifically when I learned that fact, but I did learn that there was a second referral.
Okay. And it was after you went to the FBI?
That is entirely possible, yes.
Okay.
Okay, I'm gonna speak like this.
And then the next day,
Dramatic. Hello.
that is when you guys decide to reach out to Ken Paxton, after you've already outed him to the feds, right?
We reached out to him the next day.
Okay, that's what I said. So that's a yes, right?
We did reach out to him the next day.
You were pretty
The
active.
witness, but once again, witness, when you can answer yes or no, if you can, answer yes or no.
I cannot answer yes or no to that question. I'm answering what I can.
Okay.
Because the question is built on a false
You were
predicate.
pretty active on October 1st.
I was active on October 1st, yes.
Okay. You guys, when I say you guys, I mean the executive level administration. You had a group chat going, did you not?
We did,
And you participated in that group chat, right?
yes.
We heard you talking to Mr. Harden about some of the text messages in that group chat, right?
Hi, Sandy.
Yes.
And specifically, they were talking about a draft. that was
Also, hi,
circulated
Sandy's
between
husband.
you
How are
and
you
the
doing?
Executive level attorney generals, right?
Yes.
Eric, would you mind pulling up House Board 225? And in that message, well, it's safe to say that the
Almost 500 people watching, not bad.
did not go to the FBI, right?
Yeah. Not bad.
I don't believe, no, this letter that's
Right.
being referred to here,
It
no.
was revised and edited to an extent.
The
Sure.
document, I don't recall if it ever went to the FBI. We were working on an internal document
Okay.
to
And-
memorialize our complaints.
Right. And the first version of that complaint, well, from what we look at in House 225, Jeff Mestier says from Maxwell, read the letter, not sufficient. A request letter must allege specific allegations that are in violation of state law to include documentation of criminal act. The only thing you have is what happened today, and that is documented. Is that true?
You added the word "and," but
Okay.
apart from that, you read it
Excuse me?
correctly.
But that's what the text says, right?
That is what the text says with that
And
addition.
presumably that's regarding the initial draft that you guys created to memorialize your complaint to the FBI, right?
I don't recall specifically that that's what this was.
Are you forgetting all of a sudden? Because you had a crystal clear recollection when Mr. Hardin had you on direct examination, Mr. Bangert. Do you not remember this? You're here to testify in the court of impeachment. Do you not remember the day that you went behind Ken Paxton back to the FBI? Do you not remember that?
Sir, we did not go behind the Attorney General's back.
Did you tell him you were going to the FBI? Yes or no?
Sir, we did
Yes
not
or
go
no?
behind
Did you,
the...
Mr. Bangert, I'm asking you yes or no questions. Did you tell Ken Paxton you were going to the FBI? Yes or no?
I cannot answer that question with a yes or no.
Witness, you'll answer the question.
Yes or no, Mr. Bangert?
Provided him with ample opportunity.
That's not what I asked you. Did you tell Ken Paxton you were going to the FBI? Yes or no?
We gave him ample opportunity.
That's not what I asked. Objection non-responsive, Your Honor. I'd ask that he answer the question before him.
Witness is ordered to answer the question, yes or no.
Mr. Bangert, it's a very simple question. Did you tell Ken Paxton that you were going to go to the FBI?
On September 30th, we
It's a
did
yes or no
not.
question, Mr. Bangert.
It's
a
not
yes or no.
a yes or no
It is a yes or no question.
Excuse me, sir. Your Honor, he said, he answered the question, but because he was talking on top of him, he didn't hear it. He said, on September the 30th, we did not. And he starts interrupting him halfway before, and the court reporter probably had trouble hearing, we did not. So I just asked him to let him finish what he's saying and not talk on top of him, if for no other person than the court reporter.
You can ask the question one more time.
Mr. Bangert, it is a yes or no question, and I want a yes or no answer. Did you tell Ken Paxton that you were going to the FBI?
I did not tell Ken Paxton before I went to the FBI.
I'm not sure why he fought him so hard on that, to be quite honest, but here's where we are, you know? It's like...
Your next message after we're talking about the first draft of y'all's complaint says, okay.
That was
sounds like
his
we need
best
to beef
moment
up
so
the
far, and I still
specific
don't care.
allegations. Does it not?
Yes, that's what I wrote.
So you actually had to go back in there and put more words and more filler into that complaint, didn't you?
No.
No? Well, the first complaint clearly wasn't sufficient if we're to go off your text messages, right?
You said the word filler. That's an inaccurate characterization
You had to
of what
amend
we
it.
were doing.
Well, let's look down there. Eric, if you could hop off of the zoom in. So it sounds like we need to beef up the specific allegations. You needed to beef them up, right? You needed to make them sound stronger.
Well, did you
True
tell
or
someone
no?
you're going to the FBI?
We needed
I
to
don't
include
know.
additional allegations to substantiate what had happened.
Boss, I need an extra
it's
hour
after
at
that
lunch.
that you started
I need to
talking
go
about
rat on you to the
Other
FBI.
things that Ken Paxton had done previously that you didn't think to include.
Can you
in
cover me
first
for the
version of
afternoon? I won't be
complaint, right?
back. I don't know.
I wouldn't put it that way.
You wouldn't put it that way. And to be clear, this is all coming to fruition because Brandon Kamek is serving subpoenas on a bank. True?
That was in.
But every one of you can feel free to talk to the
all the while,
FBI and
you
tell them
didn't
that they
even
too
know
should like, comment, and
County
subscribe to
District Attorney's
Uncivil
Office
Law.
Sent a complaint directly to Mr. Kamek.
The FBI might learn
that
things
did not go to the office
from
of
this
Attorney
channel,
General.
some of which might help them in their
That
in
would
their
have been
field of
much
work.
more concerning if I'd known that.
We all can learn the law better, right? Yeah.
So you didn't know that.
No.
Eric, would you mind pulling up Article 6? Or excuse me. Article 5.
Matt says you've never gotten out of the FBI beating it under an hour.
The allegation in Article 5
very
is that
true.
Paxton
That's very
misused his
true.
official powers by violating the laws governing the appointment of prosecuting attorney pro tem. You would agree with that, right? That that's the allegation?
Yes, that is the allegation.
Mr. Bangert, Mr. Paxton, excuse me, Brandon Kamick was not an attorney pro tem. True or not?
Thank you, Robert, for your fine contribution to this channel. That's helpful. Robert says, I tag the FBI with these streams all the time, which
True
message
or not
subversive
true?
must be watched. That's great. Thanks, Rob.
Personally,
Thanks for
believe
helping.
he was properly ever appointed a prosecutor pro tem.
And the Travis County District Attorney's Office never recused themselves officially and formally from the complaints made by Nate Paul to their office. True or not true?
I'm not aware of any recusal.
Okay. May I approach you, Your Honor?
Yes.
Alex says FBI in the chat. I have very little doubt that there's at least one FBI person out here. 530 people? Yeah, there's probably at least one FBI person. But that's okay. We like the FBI. I actually like them probably more than the channel as a whole, notwithstanding their many failings. Well, yeah, there's probably a someone in a U.S. attorney's office or an FBI official watching the channel.
I want to
Why
go
not?
back to your last answer, and I'm going to re-ask
It's
you
good.
this.
It's good for the legal education.
Brandon Kamick wasn't just not improperly appointed as an attorney pro tem. Brandon Kamick was not appointed as an attorney pro tem at all.
Not to my knowledge.
Yeah. Tony P says maybe they're in the FBI. Yeah, that would just be the lamest sting ever, Tony. You have worked your way
This time, Judge,
over time
I
and
would offer AG
over
Exhibit 95.
months and months to gain yourself a trusted
that's on our list.
non-position
We've already
so that
admitted.
you're on the inside of uncivil law.
It's already admitted.
Thank you,
What
Judge.
a
Eric,
waste
would you
of
mind pulling up
time.
the first page to AG 95.
If you're a mole, this is a real... If you're a mole to find the deep, dark secrets of uncivil
we
law, I
talked
think you're
about
going to be
you being
very
heavily
disappointed.
active on October 1st of 2020, and you agreed, right?
I was.
And one of the many actions you took that day was that you took it upon yourself to email Jeff Mateer's letter to Brandon Kamick terminating his employment, did you not?
I did not take it upon myself. I agreed with Mr. Mateer that this would be an appropriate way to handle this.
Okay, so you and Mr. Mateer were both of agreement to do that.
We were in agreement to do this.
All right, I want you to flip to the second page of that correspondence. You would agree that, and Eric, if you would do the same, you would agree that that is the letter that Jeff Mateer provided to terminate Brandon Kamick's employment, right?
You're visited by the FBI because you sold pure acetone? Nail polish remover?
It's produced by the House, Mr. Bangert.
Okay.
Correct. I want to make sure that the word terminate is accurate here. We were told him to cease and desist.
Third line, notice of termination effective immediately.
Yes, we do say that.
Okay.
Yes.
And just to be clear, you don't know all the work that Brandon Kamick put into that investigation, do you?
At that time, I was not aware of what he was up to.
And you were willing to just fire him without even thinking to pay him or compensate him for his time and his services as a lawyer?
We terminated him in this letter and told him to cease and desist.
Without even thinking about giving the guy a little bit of money for the time and effort he spent on this investigation? Yes or no?
I would not put it that way.
Okay. You didn't pay him, did you?
No, we did not.
All right. But the thing I really want to focus on, Mr. Bangert, because you're a man that has attention to detail, right?
I do my best.
I want you to look right under that Attorney General seal at the top of that exhibit, okay? Do you recognize anything that should be there?
The name is what he's looking for. You know
It's
the
been
answer.
several years since I worked with letterhead. It has the seal of the Attorney General's office there.
How about your boss's name? You see that there?
His name is not here, no.
Yeah. You went ahead and sent it without his name, didn't you?
I'm trying to recall. I think there was a version.
You're looking at the
letterhead
document, Mr. Banger.
Excuse me, he's trying to answer the question. Can you please let him before he jumps?
Overruled.
You're looking at the document. Is Ken Paxton's name on that document you sent to Brandon Kamek or not?
His name is not on the letterhead, no.
I take note that the Attorney General, Ken Paxton's name is still on the letterhead today,
For the record, I do want to
despite
point
the
out
fact
he
that
doesn't
technically he's
appear
not the
on
AG.
It's
So
non-responsive. I didn't ask this witness a question,
I don't know what that's all about.
and I'll pass Mr. Banger.
Extra letterhead floating around. David, I'll agree that the witness is a little pedantic. I'll agree with that. I'm not sure I see smarmy, but he is a little pedantic, but that's okay. It's a common trait among lawyers. If you want pedantic, though, talk to some patent lawyers. My field, holy shit, dude. Because you're trying to capture technical concepts in language, and you'll have the most stupid fights about wording, maybe ever. Patent law is so pedantic. Patent law is all the pedantic. Oh my God.
Mr. Bangert, I want to start to try to ask you a few questions again to go back to this opinion that sometimes has been referred
Tom says I
to as
just
midnight
just side with whoever's snarkiest.
Originally,
that's possible.
If I can, I would
That's
like
possible.
to bring up, please.
You may have a better
Statutes
observation
112.
about me than I do myself. You might be right.
Now, can you look at this and determine and help me out and tell me whether or not this is the original draft that y'all did on and presented to the Attorney General on that Saturday afternoon? You need a moment to look at it, or would it help you?
Yeah, so
have
that
a hard
cross was a
copy?
massive waste of
Hard
time for
copy would be
me.
helpful. Yes, sir.
That cross was a massive waste of time for me.
And Stacy, do we perhaps have a hard copy for the court?
But I can tell you without looking at it that this is not the original version that we sent.
Thank you, Mistress Meg, for being a member for 6 months. We do appreciate everyone who's a member of the
What your
channel,
observation is. What,
including and
what
especially our
order would
Fed
this draft have
friends,
been?
who I will absolutely take the taxpayers' money and put it to better use on this
I'm
channel.
assuming this is the final draft. It would have been the very last thing that was produced.
Would you look at the first page, please? And
If you want, Feds, if you want access to my
the
super
last page, if it
secret,
helps you.
direct messages where I tell people about all the illegal stuff, it's
No,
going to
this
cost
is
you
not
about
the final draft.
$500.
I can now see there's no signature
Super chats,
on it.
Right.
and then I'll give you
Would
access
look
to the
at
super
opening
secret
paragraph
messages
and
that we
see
don't
what
tell
that
the
seems to
normies
say
about.
in terms of the original position you
Yeah.
took.
This is working.
Yes, this refreshes my recollection.
Pardon me?
Yes, this does refresh my recollection
All
as to
right.
that.
And now that you look at the language in the first paragraph of Exhibit 112, what does that tell you in terms of which draft or order it was?
This was one of the early.
Now, let me tell you a problem for you to keep in mind. When you look to the left for the iPad, there you go. Perfect. There you go.
There we go.
Totally not the Feds.
Yes,
Hello,
this was-
fellow
this was one of the
uncivilians.
early
How are we
drafts.
enjoying the law today?
And in the first
That's good. I like
paragraph,
that. That's very
would you
nice.
look at the sentence that begins with "we conclude"? Would you highlight for me, Stacy? Would you highlight for me, Stacy? Read this paragraph out loud to the jury, please.
Yes. We conclude that a foreclosure sale of residential or commercial real property constitutes a service to which no occupancy limit applies under Executive Order GA 28.
Tom asks the
And local
Fed pay me
governmental
for incriminating
bodies
statements. Does that
therefore
mean they
lack
can't use them
authority to
against you?
restrict in-person
Well,
attendance
not inherently,
sales.
no.
Right.
But
Now,
it would
at
depend on
that
me
time-
actually meaning them.
What was the legal
Right,
basis
so
for
if they
you
pay me to
concluding
say
that there
words,
wasn't a restriction?
like me
and
saying
that it
any
could be
arbitrary
conducted?
words doesn't necessarily
It
make
was
them illegal,
GA-28,
because you have
the
to have
governor's
intent
order.
behind them.
All right.
So if I were to like
What
suddenly
about
just threaten the life of a
28,
federal
the
official, just to
governor's
pull
order?
out an example,
And I may have a
right?
copy of
It wouldn't
that.
make it illegal
I couldn't locate it on my
because
desk.
I'm not
Somebody
actually
finds it,
making
they
a
can bring
threat.
it up
I'd just
to
be
me.
using it as
But
an illustration.
What was it about
So,
the governor's order?
Yes,
and
they
when
could
was
pay
that
me to
order
gain
that you
evidence, but in this
concluded
case,
would
they wouldn't be
allow
actually gaining evidence because it wouldn't be evidence of
essentially the
anything.
foreclosure sales to go forward, particularly outside?
But you know. Also, I also prefer that you
Yes, there
not
was
super chat me
number of
to get me to
exceptions
say
in
death
the governor's
threats,
order
please.
to in-person
Because, you
gathering
know, for my own
restrictions.
safety and protection,
With the
I
court-
probably
with
won't
the
read those
court's
on stream.
permission,
Notwithstanding
I'm
the
going
fact
to
that I probably
mark
legally
this as an
could.
exhibit
I prefer not to
number-
flirt with that danger that much, you know? Yeah, thanks.
621? Thank you so much. 631 or 633? 631. Thank you. I'm going to tender it to counsel, Your Honor, because I don't have an extra copy right now.
You may see my Matt Murdaugh impression again today. My eyes are definitely hurting a little bit.
No objection, Judge.
631 shall be admitted into evidence.
Thank you, Your Honor. Do we have a copy by chance for the court to have up there? This
Always
only-
nice for the court to have a copy.
The fact that this witness
this
knows
only
more
came
about
up
the
in
evidence than the
lunch hour. I
prosecutor
apologize.
is not surprising. The prosecutor's been a little bit off their game.
And one for him.
So that maybe is less an indictment than you might have intended.
Thank you very much. Now, I don't know whether or not, and I'm going to ask as we go along, whether Ms. Manella can figure out a way to balance these. First of all, if there's a way to do a split screen here, Stacy, 112.
I'm going to terminate these
and
tacos.
115.
That's fine. Tacos are not
And I
people,
believe
so
I will represent.
I think that's fine.
115 is the final order. And I believe 115 is in evidence. Now, if you could look at these two orders, is the one on the left, the draft we talked about, Exhibit 112, what your first finding was?
Yes, our first finding is summarized in the first paragraph. We conclude that a foreclosure sale. Yeah, there we go. Thank you. We conclude that a foreclosure sale of residential or commercial real property constitutes a service to which no occupancy limit applies under Executive Order GA-28, and local governmental bodies therefore lack authority to restrict in-person attendance at these sales.
All right, now, I'm going to ask you if you could leave that up, please, Stacy, first.
Taco is a given name.
And then I want you, if you would.
Is there
I want
someone
you
out
to
there
look
naming their
over to
child
the
Taco?
government's executive order.
I've never met a
page 3.
taco, so I'll take your word for
And I
it.
don't have a copy of the order.
Do we have one more, Mark? No.
Thank you, sir.
Thank you. And I believe that 112 was just never discussed as one of those that you did not object to. I want to tender it to you again to look at. I just looked, make sure. I'm told that 112 is not in evidence, and I apologize. The headlining is not. This is the original draft they proposed.
No objection, Judge.
No objection, 112 will be submitted to evidence.
And I apologize for having published that before I realized that that's my fault, not anybody else's. Now, I want to ask you, you referred in your testimony just a moment ago that in your first draft, in which you basically had a ruling that said these foreclosures, particularly outside, would be allowed. And then you said that was partly based on the governor's executive order that he had previously issued. and you talked about it
Man, I'm ready for a
as
power nap,
General
I'll tell you
Order
what.
28, correct?
Yes, no occupancy limit applies.
I'm sorry?
Yes, no occupancy limit applies under
All right.
GA 28.
And what role can you point us in the governor's General Order 28 to the section that you relied on in that initial opinion that said they could be open to the public? They could foreclosure proceedings could be open.
Yes. May I see the second page of
Pardon me?
exhibit? May I see the second page of Exhibit 112?
All right. We move to second page. Thank you, Stacy.
Yes. Yes, we reference it here. We address your question.
No, I'm sorry, Stacy. What I want to do now is go to, if you have ordered, I don't know if you have 631 loaded, do you? If you do have 631 loaded, could you go to the second page of that? And you can sacrifice the one on the right. You can take down 115 and put in the governor's general order. And by the way, the executive order, before you move, Stacy, that is dated. Can you see on there what date it is? Is it June? Can you see June 20th?
I can. It's June 26th, 2020.
All right. Now, so that executive order, did it not, existed at the time that you were drafting your opinions at the request of the Attorney General?
They did.
All right. Now, what is it on page 2 of the governor's executive order that led y'all to conclude and say in
I need to book travel for
foreclosure sales could be
next
conducted?
thing.
Yes, if you will go to page 2 of Exhibit 112,
All right. Stacy, if you go to page 2 of
the
the
first
general
full
order.
paragraph.
Pardon me?
First full paragraph. We point out that Executive Order 28 has a baseline limitation that does not apply to.
I don't. I'm confused here, and it's probably my fault. Stacy, may I approach, please?
Does anyone have a link to
As usually,
Nick's
Ms. Manello,
Eventbrite thing
You directed me
in
you directed
Knoxville?
me to page 2 of
Exhibit 112.
None of you guys in chat can post a
your
link.
initial draft opinion.
So why did I ask
Initial
you?
opinion.
And I was trying to go over to the governor's.
Does anyone who has
Let's
access
stay
to
with
my
112
Discord
first.
have access
So
to
now
the
let's
link
just
for
say,
next
see, let's
thing?
put up
If so,
112
could you post it
and
in
the governor's
general?
order. Those
Thank
are only
you.
the two on the screens. Go ahead. All right. Tell me what it is about 112 that you think is relevant to what we're saying.
Yes, this paragraph that is highlighted,
All
the
right. You're
second
moving
paragraph.
away from that microphone. You got to move it to
Yes.
you. There you go.
The paragraph calls out the executive order's baseline
Nashville?
limitations.
Yeah, see, this is why I want the
Together.
links, so that I make sure the big
It then says this limitation does not apply
There's kind of a difference
any
between
services
Nashville and
listed
Knoxville, yeah.
by the U.S. Department of Homeland Security's Cybersecurity and Infrastructure Workforce version 3.1 or subsequent version. CISA guidance is how we referred to that. Among the services listed in version 3.1 of CISA are residential and commercial real estate services, including settlement services.
And then if we go down
additional-
to,
Yeah.
you go down to about a sentence or two down there, you say, do you not? And there is no better indication
Matt.
of that intent than the words that are chosen, correct?
That is correct.
All right, now let's stop there and let's go over to the second page of the general. And by the way, could you just explain to us lay people
So
what
theoretically, I'm
CISA
supposed to go to this
CISA,
thing.
What does that stand for?
It's the Cybersecurity Infrastructure Workforce. CISA is I'm trying to recall exactly what that acronym stood for, but there was a guidance document issued by an agency within the federal government that called out essential services and infrastructure that should be exempt from COVID limitations.
Okay, so for us lay people, essentially.
So this
are
is
you
Saturday,
saying
September
that you
16th.
are going from your draft that you did to show why
This is
the
next
governor's
weekend.
proclamation or executive order would have exempted it as far as you were concerned when you dropped the original draft. Is that right?
That's exactly right. We were trying to demonstrate, and we did demonstrate here, that a straight application of the governor's executive order excluded these types of foreclosure sales from
Yeah,
limitations.
thing the third and Lindsay, yeah.
I don't want to
on
tell
the
everybody how to
16th.
build a Swiss village when we're trying to just do what time it is. But if we go to page 2 of the governor's order, where in there does it point people to the legal basis you made for your original order?
Paragraph 1A.
Hi, Mary Humphreys.
Yeah. on the
No.
left.
I'll talk anytime I
1A.
please.
Thank you.
Thank you.
Can you highlight 1A for me?
Not that you're missing anything, at least in my judgment.
Mr. Donnelly wants to make sure that I let you know that we can't give you a copy of the CISA document because it's a government confidential document, okay? But having said that, would you explain in this highlighted language how this tells you...
Objection to that sidebar about the CISA document. I don't believe it's confidential.
Sustained.
Can you explain in the highlighted portion here?
Say again?
Yes, explain in a highlighted portion how that impacted your original opinion you recommended in a draft to the Attorney General.
Yes.
Let's take a look at hotels in the area.
Exemptions from occupancy limits. And the CISA guidance called out a number of essential services, infrastructure, among which, as we point out in our original draft guidance, are residential and commercial real estate services, including settlement services.
So explain to the court what that meant as far as the conclusion that you ultimately reached and recommended to the Attorney General.
Based on a plain text interpretation of the governor's order, foreclosure sales would not be subject to occupancy limitations.
If it affected any real estate?
Yes, and that was a straightforward textual interpretation.
So in your original one, did you actually base it upon an exception the governor's executive order had given to say that it should be open to the public?
Yes, it was a straightforward application of the governor's executive order.
Now, how did you get around that then when you were ordered to come up with a different answer? And if we can, Stacy, let's now take down the governor's executive order and put up Exhibit 115, please. Now, tell us what it is about what did you do that, since you had based it on a specific reading of the governor's statute, and now you're being asked to give an opposite view? How did you do that?
Could you go to page 2 of Exhibit 115?
Yes. Where do you want to be?
If you'll look at the third paragraph. We simply jump straight to the general occupancy limits.
Pardon me?
We jump right to the general occupancy limits, excluding conversation about CISA.
Direct us and Ms. Manella where to highlight that you're talking about.
The language, this general limitation, however, is subject to several exceptions.
I might have to skip Nashville.
Where you read?
One such exception is found in paragraph 5 of the order, which limits outdoor gatherings to 10 persons or fewer without approval by the mayor.
I might have to
or the
skip Nashville. By the time I get a
unincorporated
plane ticket and a hotel room and stuff like
So
that.
we switched out the applicable exceptions in the order to eliminate any reference to the CISA guidance.
So what you did is you just wrote out a paragraph, did you not, of the governor's order?
We determined, based on the Attorney General's instructions to us, that we would no longer apply the exception that had been granted by the governor's order.
When you say based on his instruction, did he actually talk about that language?
No, he told us to reach a different conclusion, and that was the only way to do it.
I don't need it, but thank you. All right. Now,
Yeah. I think I'm going to have to skip it.
finally,
I'm trying to be a little bit more price conscious about
this,
things.
But had you read, may I approach the witness very briefly?
Yes.
I'm going to approach you and show you what we have just marked as a new exhibit. House Board of Managers Exhibit 632 is a new listing. I'll tender to the court and the council with the admonition that I don't intend to read all this.
So if I like fly in on the 16th and like fly out on the 17th,
So my question to you, though,
what can I do for a
without
direct
having
flight?
introduced it yet, I will actually make it for ease, move to introduce it. We move to introduce House Board of Managers Exhibit 632.
$330 for a flight.
Judge,
Yeah,
I would object to this witness
plus
testifying to this
hotel,
document,
plus
and
expenses,
additionally,
$500.
This document has not been produced. There's no bait stamps on this document.
No, that's certainly right. It has not been produced. We never foresaw this issue. So we've just gathered this during the lunch hour and printed it out here, and we've tendered it to him. Whatever his position is fine, but he's certainly right. It's never been produced. We did not foresee this issue.
Maybe Ian's going, I
It's
could share a room, I'll
40-page
ask him.
document riddled with hearsay, Judge.
It's a government record, I think.
It's an easy drive. I'm not sure how much money I'd save by driving, to be honest. But it's about 12 hours or so to Nashville. So it's a hell of a drive. But yeah, I could drive it. I'm not sure how much money I'd save doing it, but
Mr. Rosso, do you need time to review this 40-page document?
Judge, if I could have 1 or 2 minutes.
If I may, I think that's a reasonable question. So if I could speed it along, what I'll do is I'll hold withdrawal or wait on the motion to admit it, see if I can elicit testimony that gets the same, but it may not become an issue ultimately. But if I do want to, I'll give him notice so he gets time to read it.
Hold on 1 second.
Judge, we're ready to go.
Thank you. Now,
Do you withdraw the objection then?
No, Judge. Judge, may we have 5 minutes to just look through this document real quick? Okay.
Yes.
fine.
We'll stand at ease for 5 minutes.
all right. I don't know what's going on. Yeah, so for those of you who are curious about what we were talking about in the background, sorry that we were kind of over talking, but my mind is only half working and I was trying to do something while I was, half conscious about it. My friend Nick Requeta from Requeta Law is having a meetup in Nashville on September the 16th. And so he invited me as his guest, which is nice of him, of course. So to fly out there, the cheapest direct flight I can find is $340. And then, by the time you throw in a hotel room and some, incidentals and stuff, you're at like $500. So I was like, it's a $500 trip. And, $500 is a fair amount of money. So that's kind of where we're sitting on that. It is a business expense, that's true. That does help a little bit. I'll sit on it. I'll sit on it for another day and think about it. I know some people had said that they were looking forward to meeting me there, but I wonder how long. Yeah, so it's a 12-hour drive up there, isn't it? Something like that. That's a long drive. Thank you, Matt. Yeah, so it's 12-hour, 47-minute drive. That's not practical. I doubt I could make that in one day. 12 hours and 47 minutes. That's a long drive. That's a long day. If I drive that straight, I don't even know if I could do that. Usually I start to lose it around hour 7 or hour 8 when I do long drives. Fly to Knoxville, rent a card. I guess I could do that too. Bus? Nah. Well, I appreciate everyone who's here and supporting the channel. I'm sorry also that my energy levels are kind of low. Because I know, more energy is good. So I'll see if I can conjure some energy from somewhere. Driving all day ain't bad. I don't know, man. When I've driven before, usually around it's a lot. It's hard, Usually about around 7 or 8, I get really tired. So I'm not sure I can do it, and I obviously would like to arrive alive, and cogent. I'll ask Runkle if he's going. Apparently my acting teacher is bad at checking emails because I sent her an email yesterday telling her I wasn't going to come to class anymore, and she assigned me a role in class. She assigned me a scene partner. That's great work. You sent gifts? Thanks. Let me take a look. Stella Stiller became an uncivilian for 99 cents. Cody Sams became an uncivilian for 99 cents. Mr. Meggs gave $1.99. Mr. Meggs has been a member for 6 months. Just Nova 113 asked, is it required among lawyers to work for the government, or is it highly recommended? It's certainly not required, but...
What's the number, Rusty?
David Wellman said, not even going to terminate these tacos.
No objection.
Matthew Harris gave us $2 to the Rakita Nashville Fund.
Excuse
Tony
me,
gave $10 to
632.
say Nashville or not. You're worth every cent.
632, do you
Stone
want to
Bleeds gave
exhibit?
$1.99 towards the Rakita Nashville Fund.
House Exhibit
And
632
Remy
is admitted.
Stolvuk gave their first super chat ever for 20 and okay. Thank you very much for all your contributions.
I want, if I can, I'm going to walk up to you and I'm going to show you a page. By the way, I mistakenly called this a confidential document. I've looked at it. It is not. It is a public document. There's nothing confidential about it. That's one of 230 mistakes I'll make during this trial.
Objection.
Okay? So now, thank you.
Object to that sidebar.
Excuse me, what is the
and strike.
objection?
Sidebar, and I just moved to strike Mr. Harden's comments.
Yeah, sustain.
Thank you.
You know better than that. There you go.
That makes it 237. Thank you. I'm going to walk up. I'm going to show you where the tab. I'll show counsel where I'm pointing it to.
That's a nice comment, Cheese.
What I'm about to address you to, because I can't send you to a page number.
That's funny.
Now, on Exhibit 632, is there a provision of it, and I showed you a tab, so there's no secret about this. Is there a provision in this document that you relied on in coming to your conclusions that you presented in your first draft to the Attorney General?
Yes.
And shown in Exhibit? Can you explain? And I don't know that. Stacey, you don't have this loaded, do you?
Oh, I'm sorry. I forgot to put that back up. I'm sorry. You're absolutely right. I didn't even notice.
All right.
I'm sorry.
Let me show
That's
you
how tired
where
I
I'm going,
am.
Stacey, because again, I don't have a page number. May I approach her?
I'm sorry. I'm sorry. Thank you. I forgot to switch the scene. I'm sorry. I was so tired I didn't even notice. Yeah, if you want to donate towards my trip, you're more than welcome to send donations.
Is there somewhere on this screen that you can direct the viewers to?
And
that has any
Stream Elements gave you the link.
That you used as a basis for your original opinion that you delivered to the Attorney General on that Saturday afternoon?
Yes, the very last bullet point. Residential and commercial real estate services, including settlement services.
And what did that mean to you?
We interpret that in the original opinion.
And then can you read the portion of Exhibit 112? Stacey, can you split it for me? 112.
No, I saw the post. I saw the post.
On this segment.
I appreciate
It's one
that you
excerpt
were
out of
interested in
632.
donating towards
Yes.
the costs. If you'd like to donate, the donation links are right there.
Second
And we
paragraph,
appreciate any
second
support
page.
you want to send my way.
The court's main objective in construing the law is to give effect to the intent of its provisions. And then we footnote, and there is no better indication of that intent than the words that are chosen. Then we footnote, where text is clear, text is determinative of that intent.
Microphone. All right, keep going.
One dictionary defines a service as work that is done for others as an occupation or business. Real estate is defined as land and the buildings and permanent fixtures attached to it. Thus, real estate services include services performed
total?
for others as an occupation or business that pertain to land or the buildings.
It's about
and permanent
$3.50 for the
fixtures attached
ticket.
to the land, insofar
see.
as the performance of auction or foreclosure sale services related to commercial or residential real property. Such services are one specific iteration of residential and commercial real estate services.
All right. So, to reduce it down to its basics, in recommending or in your drafting to the Attorney General, saying that there should be no restriction on the foreclosure sale. Did you rely on a government document as guidance as to why it would be considered an essential service or activity that was exempted based on the governor's executive order?
Yes, the specific government document.
Probably about $500.
Incorporated into the governor's order.
All right.
I mean, I could get you an exact total, but it's something like that. It's going to be about
Was your recommendation?
It's going to be about
that they
$350
open
for the
it
airfare, maybe a little bit
based
more
on
by
a
the time we throw in
combination
baggage fees and
of
shit
the
like
governor's
that.
order
But let's say it's
if you go
$350
to
for the
basic
airfare,
item that they're
and
referring to in the
then
governor's
for the
order,
hotel,
that would have said
it's going to be
essential services that would have included
$100 plus. So it's probably going to be close to $500 by the time we're done. I would estimate.
Residential property, excuse me.
Yes, we conclude that it is not, there's no occupancy limit applicable pursuant to Executive Order GA 28.
Now, when you then were directed to come to the opposite conclusion in the drafting, that is the final product in the exhibit that we've been using, I think is 115, you had a challenge to write around the basis for your first opinion. So what did you do?
Objection to leading and assuming the answer in the question.
Sustain, rephrase.
What did you do to come up with the opposite conclusion you had originally arrived at?
A couple of things. If you go to page 2 of Exhibit 115, you first point to the general occupancy limitations in the third paragraph. Next, we do point ultimately to CISA at the bottom paragraph. And if you would go to the next page, at the very bottom of the first full paragraph, and this is really the kicker, the court's main objective in construing the law is to give effect to the intent of its provisions.
Slow down, please. On behalf of court reporter.
Yes, my apologies.
And the volume on behalf of the people on the floor. Could you speak a little louder, please?
Yes. We repeat our commitment to textualism, which was a guiding star of our office at all times. We then point out that based on our analysis of the words, we believe that outdoor foreclosure sales, last sentence, are not exempted from the 10-person attendance limitation.
And
we completely reversed it.
Excuse me, I'm sorry. What was the only thing that had changed since you had the original opinion?
The direction from the Attorney General.
All right. Now, you had questions about whether or not it would have happened anyway because of other subsequent events. At the time that you drafted these two opinions, did you have any idea that Nate Paul had bankruptcy hearings scheduled?
Objection to asked and answered. And this witness said he didn't have specific knowledge, so speculation.
Sustained.
In this particular matter, did you yourself know about any bankruptcy hearings that were set any foreclosure hearings that were set in the foreseeable future? Just you yourself, were you aware?
Objection to asked and answered.
Not by me.
And lack specific knowledge.
Overruled. I sustained your first objection, which forced him to ask the question a second time.
Thank you, Your Honor. Did
No.
you yourself?
I had no specific knowledge of any specific foreclosure sales.
All right. You were there when he introduced a certain document, and if I can I have exhibit AG Exhibit 295, please, Stacy?
Man, I don't know why I'm crashing this hard.
You heard earlier questions on direct as to whether or not, have you not, sir, these
I woke up a little
opinions
early.
would be of help
But
to
man,
somebody who was
crashing
either
so hard.
somebody that was opposing a foreclosure hearing, right?
I recall those.
All right. Now, if you could, can you identify? Had you seen before we showed you this? This Attorney General exhibit? Had you seen it before? This exhibit that he's entered into evidence?
No, this is the first time I've seen this document.
All right.
With the cross-examination.
All right. Now, I want you, if you I'm going to read this to you and ask you what the import of this when you look at the exhibit is. Judge Gamble, August 3rd, 2020. As it is relevant to these proceedings, please see the attached guidance just released by the Attorney General's office. Had been just released, hadn't it? What date was it released?
The 1st.
1st of August. That was a Sunday, was it right?
I believe midnight the 1st. I think that's right, yes.
So this is just Tuesday after you released the opinion on, or after you provided the Attorney General the opinion on Sunday the 1st, correct?
It's 2 days later, yes.
Keep your voice up, away from the microphone.
2 days later, yes.
All right. Regarding the foreclosures may not proceed unless specifically authorized by the mayor and the city of the foreclosure, given the standing 10-person restriction would violate Texas Property Code, Chapter 51. Does the attachment include the opinion that we have just been so laboriously going over?
Yes.
Would you look to the last page of that opinion and see if that's the final one that we identified as Exhibit 115?
It is.
With your signature?
It is.
Does the cover page identify on behalf of whom this particular email, this particular pleading was filed in a court here in Travis County?
Yes.
And who was the person that represented whom was presenting this particular pleading and urging that your opinion was relevant to their case?
This is one of Nate Paul's companies.
Do you even yourself personally know how the judge ruled one way or the other on this motion?
Not in this case, no.
All right. And in fact, are you familiar with any other cases? Nate Paul cited this opinion and seeking to foreclosures in that year of 2020 after you rendered your final opinion?
Only through news reports that came out after.
All right. Was it multiple places?
Yes.
Objection to hearsay, Judge.
Through.
Do you withdraw that question?
Yeah, I think actually he meant to say leading. It was leading, it wasn't hearsay.
No, I meant to say hearsay, but I'll retract the objection for Mr. Harden.
That's all I have.
Recross?
Yes, Judge.
Mr. Rosso?
You just cited the Cybersecurity and Infrastructure Security Act pretty precisely to Mr. Harden on direct examination, did you not?
I had it in front of me.
Okay. You also cited the day of the week that you issued that opinion, did you not?
The day of the week was
Thank you for the
August 1st when we
$25
issued
from
the
Peggy.
opinion.
I'm just surprised because you showed an uncanny ability to remember things when Mr. Harden was asking you questions, as opposed to when I asked you about the same documents during my cross-examination. Can you explain that?
I disagree with your characterization.
Okay. We'll agree to disagree. I don't have an e-copy of this CISA document that the House has just produced, but I think Mr. Harden had you reference page 16 of that document, did he not?
He did.
He had you reference the very bottom part that I have highlighted in orange, and I'm going to show the jury. And it says settlement services, correct?
One of the things it says is settlement services.
Now, behind the term settlement services in this document, there is no definition as to what settlement services are.
I do not see a definition.
I don't see the word foreclosure sale or non-judicial foreclosure sale behind it, do you?
The word foreclosure sale does
Tony
not
asked me if it's a fair line of questioning. Tony, at this
have a
point,
real estate
I am
license?
basically unconscious.
Okay. Would it surprise you to know that people who have real estate licenses oftentimes engage in settlement services to close on homes?
I'm not sure that I'm hearing any of the
Title
words.
work and things of that nature?
I would not know.
Okay. You won't find the word foreclosure sale in that definition, sir.
This definition, it is not in, the word foreclosure does not appear there, but that's why you engage in legal analysis and construction.
Legal analysis and construction, which means that somebody else, another attorney, perhaps the attorney general, could have a different viewpoint as to what a settlement service is, correct?
He could have any number of viewpoints about that.
That's why they call it the practice of law. Zone of reasonable disagreement, that happens a lot in law, does it not?
Not in this case.
Okay. Well, that's your opinion, but let's talk about facts. Are you aware of whether or not the opinion that you wrote that you said was unconscionable and opposite of Attorney General policy, did anybody challenge that in a court of law?
Did anyone challenge the opinion?
Yeah, the opinion in a court of law.
I'm not aware of it being challenged. I don't know how you would do that under standing doctrine.
Okay.
Fair question.
The witness may step down.
Judge, I have one more question if the court would entertain it.
Will the witness come back? One more question.
Prior to your term as a politician, did you or did you not practice real estate law? No. Paxton practiced real estate law, did he not?
I believe he had some real estate experience back in his past.
Okay. So when you guys are going back and forth regarding the definition of things, it's possible he had some background knowledge of what settlement services meant?
In this case, that was not the best interpretation.
Okay. That's your opinion, sir, correct?
No, that's the law.
That's your opinion.
I disagree.
Okay.
No, that's the law.
You may now step down.
Law. Okay, that was a little
House
much.
call the next
That was
witness.
a little much at the end there.
We call Mr. Ryan Vassar.
Yeah, please do.
All right, so notwithstanding that last moment, which is a little too cheeky, the witness as a whole comes off as credible. A little, but you know, yeah, we'll let one slide. That's the law. I didn't know I could do that, you know. This is the law. I am the law.
Mr. Vassar, were you sworn in the other day in the group? Okay, I need to swear you in. Please raise your right hand. I do solemnly swear or affirm that the evidence I give upon this hearing by the Senate of Texas of impeachment, charges against Warren Kenneth Paxton Jr. Shall be the truth, the whole truth, nothing but the truth. So help you God. You may be seated.
All right, who's this guy? Who are you and why do I care?
Good afternoon.
Good afternoon.
Mr. Vassar, you and I have met at least once or twice, correct?
Yes, sir.
But I don't think we've talked about this subject. And that is, we have some microphone issues that you and I have to worry about. If you will try to make sure that you're speaking into that microphone to where everybody in the back of the room would hear, and I will try to make sure that I don't talk on top of you, and we go from there, okay?
Yes, sir.
Your full name?
Ryan Vassar.
That's going to work, if you can just stay with that. How old a man are you?
I'm 39.
And you married?
I'm married.
How many children?
4 kids.
How old? What ages?
Ages between 3 and 7.
Wow. In 2020,
You got
how
four right
old
back
were
to
they?
back to back to back, man.
I had a 6-month-old,
Pump those babies out, man.
a 2-year-old, a 3-year-old, and a 4-year-old, I believe.
How are you employed now?
I'm general counsel for a local nonprofit organization in Austin.
When you left the Attorney General's office, and we'll get to that, how long were you unemployed before you found a place to land?
6 months.
What was your source of income?
Savings, but I was not employed as a lawyer for that 6-month period.
Did your wife work outside the home?
No, sir.
Let's go back now, a little bit of an autobiographical sketch review for about a minute and a half if we can. I'm not going to time you, but just roughly. Like where you grew up, your parents, what your background was?
I grew up in Big Spring, Texas, a small town in West Texas. I'm the oldest of 3 siblings. I attended Texas Tech University.
Tony, tell us, how do you know?
In accounting. My father and grandfather are both certified public accountants. They both attended Texas Tech. They've had a CPA practice in Big Spring for the past 40 years, where they serve 3 generations of farmers and ranchers and salt of the earth people.
So how many years has your family been living in Big Spring?
I mean, technically
whole life.
speaking, the Attorney General's office is also a
Now,
nonprofit.
when you finished as an accountant at Texas Tech, what did you do?
So,
I moved to Dallas and worked in finance for about a year and decided I wanted to go to law school. And so I started working at Jones Day as a litigation assistant and during my application periods.
Does litigation assistant mean a runner?
Essentially, yes, sir. I was in charge of the documents.
And did you clerk or get to know anybody else of the legal profession while you were there? Other than the lawyers at Jones Day?
No, sir.
All right. Now, and then after you graduated, what year did you graduate from law school?
Law school was December of 2012. I'm sorry, December of 2011.
2011. And Mr. Vassar, were you involved in any outside, either political or social activities in addition to going to college and law school?
I was a member of the Federalist Society for Law and Public Policy Studies while in law school. And then I interned for 2 federal judges, one on the Southern District and one on the 5th Circuit.
Which judges did you intern for?
Judge Lynn Hughes on the Southern District, and then Judge Jennifer Elrod on the 5th Circuit.
And those were both law school internships, correct?
Yes, sir.
Were you involved in Republican politics at that time?
Not at the time, no, sir, other than just typical voting.
All right. And then after you finished law school, what did you do?
I served in Governor Perry's office of general counsel as an attorney fellow.
How long did you do that?
It was, I think, 6 weeks. It was a summer.
And then what?
And then I was invited to clerk for Justice Don Willett of the Texas Supreme Court.
So Justice Willett was on the Supreme Court. How long, to your knowledge?
How long had Justice Willett been on the court?
Yes.
He might have been appointed by Governor Perry at the time, maybe around 2010 or sooner.
I haven't sought to introduce it, but is it a fair statement that Justice Willett had a extremely complimentary letter for you to have you go off and seek employment elsewhere when your service was over?
Objection, relevance.
it's basic background information.
Now, at the end of the day, how long did you work for Justice Willett?
3 years.
It's a long
And
time.
was that always exclusively on the Supreme Court, or did you work for him after he went to the 5th Circuit?
Just the Supreme Court.
Now, at the end of those 3 years, what was your internship supposed to be? How long was it supposed to last? Your clerkship, excuse me.
Right. Justice Willett had asked that I commit to 2 years. 2 years came and went, and he said I could stay as long as I wanted to. But just with the circumstances that had changed, when I joined the court to work for Justice Willett, I was single. My wife and I got married while I was working there. And then about a year and a half later, we were pregnant with our first kid. So I think it was just a necessary transition from the court to other opportunities.
Right. So where did you go to work after clerking for Justice Willett?
I joined the Office of the Attorney General.
And who interviewed you? Who hired you?
Amanda Crawford, at the time, was the division chief of the general counsel division.
And what year was it that you joined the Texas Attorney General's office?
It was July of 2015.
You recall what your first assignment was in the office?
No, sir, I don't.
Okay. And then as time went on, by the time we reached the period of 2019, what was your position?
2019, I was chief of the general counsel division.
What does that mean? What would your responsibilities be?
So I advised the agency as the general counsel, whether it was employment matters or contracting matters, state procurement law, just the typical day-to-day business legal advice.
And then as you went along there, and did you continue to move up within the organization?
Yes.
When was your next promotion?
It was April of 2020.
Now, was Attorney General Paxton already the Attorney General when you joined the office?
Yes, sir.
So your entire career at the Attorney General's office was under the guidance and service of General Paxton?
Yes, sir.
How well did you get to know him?
I might have met him for the first time at an office Christmas holiday party where he and Senator Paxton were taking photographs with employees. That might have been 2 years into my employment, so maybe around 2017. From then until I was promoted to deputy for legal counsel, I might have seen him once or twice at a division chief's meeting, but nothing.
And then what about by the time we approached, let's say, January of 2020? How much contact by that time in your different positions that you had with General Paxton?
He might have contacted me once about a matter, but other than just the typical monthly division chiefs meeting or holiday party, it was nothing substantive.
All right, so we in the jury and the court assume that you yourself did not personally know Mr. Paxton that well at the time.
That's correct.
All right. Were you around him socially other than a periodic office gathering?
No, sir.
All right. Now, when we enter the year of 2020, whom did you have under your supervision in the office?
April of 2020, I was promoted to be the Deputy Attorney General for Legal Counsel.
Does that mean that you were one of the top 8 deputies, or 12 deputies rather, up on the 8th floor?
Yes, sir.
Would you describe, I'm not sure we've broken it down to people, when we talk about the 8th floor, what does that mean in common vernacular for you?
So the 8th floor refers to the 8th floor of the Price Daniel building, where the majority of the executive staff at the Office of the Attorney General have offices.
All right, so when we talk, if the jury is to hear about people where General Paxton dropped into this person's office, this deputy's office, that deputy's office, were all of these offices along the same area, or what was the physical layout?
So if you can imagine, there's 2 elevator banks in the middle of the building, the middle of the floor. And the offices are spaced out around the perimeter of the inside of the building. So each deputy would have an office. There were roughly 3 or 4 offices on one span or one length of the building. So each deputy would have an office.
So my reason for asking, and I'm asking you the answer to this, is that where the office is readily accessible to each other and to the Attorney General, where any of those folks were within a very short distance on the same floor of dropping in or out on each other.
Yes, sir.
All right. Now, when did you first hear, if you ever did, of a person named Nate Paul?
I think it was May of 2020.
And what was the occasion for you to first well, let's back up. What was your position in May of 2020?
I was Deputy Attorney General for Legal Counsel.
Now, how much contact did you have with Mr. Mateer?
We had weekly meetings, one-on-one meetings with Mr. Mateer, Mr. Bangert, and myself.
Now, you're dropping off. I want you to remember that microphone. And maybe you need to move up just a little bit, or... All right. You had these weekly meetings, staff meetings, where there's a day scheduled of the deputies And Mr. Paxton?
So there are deputies meetings that occur weekly, and then there are also one-on-one deputy meetings with Mr. Mateer. So I would meet in all of the deputy meetings, but then I would also meet individually with Mr. Mateer and Mr. Bangert.
And at that time, how old were you?
I would have been 37 or 36 at the time.
And you would have been there at the Attorney General's office since you were about 32 or so?
Yes, sir.
Would you agree that you had moved pretty fast in the organization?
Objection, leading.
How would you characterize your speed?
Sustained.
Speed of
Asked differently,
promotions.
Now, at the end of the day, when you entered into, say, your new position as Deputy General Counsel, what type of matters would that have put you primarily over?
So the Deputy Attorney General for Legal Counsel oversees the opinion writing process, the Open Records Division, the Public Finance Division, the General Counsel Division, and I believe that's it.
All right. So in May, or April or May of 2020, what was the occasion with you becoming familiar with the name of Nate Paul?
There was a pending open records matter involving the Department of Public Safety that had been connected to Nate Paul's name.
Now, at this time, how well did you know Mr. Mateer?
I believe Mr. Mateer joined the office in 2016, if I'm not mistaken. So I'd become familiar with him just in my experience over the past 5 years working at the agency.
What was he like as an administrator and first assistant?
He was great. I mean, he was a people person. He wanted to know how staff were doing. He wanted to connect with each person. He was invested in what they were doing, what they were interested in. He would host book clubs where he would select a book, whether it was a managerial book or leadership book, and we'd meet over a brown bag lunch and just talk about a chapter of the book and how we could implement it in our work and at home. So he was a role model.
Was he religious?
Yes, sir.
How about you?
I am.
In what way?
Objection, relevance, Your Honor.
It's very relevant to who these people are.
No, it's not.
In light of who they've been
Overruled.
accused of. Thank you.
My wife and I attend an independent Baptist church here in Austin. We've been members at different churches here in Austin, and I've been a member throughout my life.
What did you view your duty as an assistant AG to be?
Assistant AG, or as far as Deputy Attorney General for Legal Counsel, I was responsible for providing legal advice to the agency through the various functions of the divisions, whether that was the Open Records Division, the Opinions Division, the Public Finance Division, or the General Counsel Division.
You've heard, have you not, or have you heard, you're being referred to by the Attorney General, all of you, as rogue employees?
Yes, sir.
What was your reaction when you heard that allegation?
It was hurtful.
Why? Tell me.
Sorry. I worked for the state for 8 years as a public servant, as one who values.
May I approach the witness?
Yes.
Thank you. As one who values the commitment to public service, to set an example for my kids, the people that I worked with, the people that I managed. And it's contrary, the statement of being rogue is contrary to the years that I dedicated my life to the state.
how did you become familiar with Nate Paul?
Well, as I mentioned, the first time that I had heard the name was connected to the open records request that was pending at the agency, the Office of the Attorney General, involving the Department of Public Safety.
Now, that is not necessary,
And did you learn
Patrick.
what the issue was about this open records request?
Yes, I
Okay,
did.
And what was the
that's
issue?
over the line.
The Department of Public Safety had received a request for public information. Under the Public Information Act, agencies that desired to withhold information for a valid purpose have to ask for the Attorney General's ruling on withholding information within 10 days. The Department of Public Safety had requested a ruling from the Attorney General's office on whether it could withhold information under the law enforcement exception to disclosure. So in other words, if there is information in the request that qualifies as law enforcement information that is not required to be disclosed, the agency is requesting the Office of the Attorney General to make that determination so that that information can be withheld.
At the time that you began to have awareness of Nate Paul, how would you describe your sense of loyalty and support of the Attorney General?
It was my understanding that General Paxton had met personally with Nate Paul. He considered what had happened to Nate Paul to be wrong, and
you don't have to believe the witness. Just find a better way to express it than by, openly questioning his,
and when was
masculinity.
The first time? Did you have conversations with the Attorney General about this matter?
Yes.
When did personal conversations with the Attorney General begin in person? Either, in person or by phone or by text, any of that way. When did you first have contact of some type with the Attorney General about Nate Paul?
It was in the month of May of 2020.
And what form did that take, and how did it happen?
I believe it was all in person. There were no phone calls or text messages or emails, to my knowledge.
All right. And when they had these phone calls, do you recall what the Attorney General said in the first one and what the occasion was for that call?
The initial call was
no. See, you really don't have to, Dark. That's the thing.
The file,
please don't.
By whom? Who asked you?
General Paxton.
Do you recall what he said on the call?
Well, I say it wasn't a call. It was generally in person. So stopped by the office, asked me, I would like to see this file. And so I contacted Justin Gordon, who's the chief of the Open Records Division, and asked him to bring the file to my office.
Now, at that time, had you had any contact with Nate Paul's case yet? Or was the General Paxton's request of you the first time you had become involved?
That was the first time that I was involved in the DPS file, the request at that time.
So, did you get the file?
Yes, I did.
What did you do with it?
I reviewed it and notified the Attorney General that I was prepared to meet to discuss it.
How did you do that? How did you notify him?
Normally, it would have been an email to his scheduler, just to see if he was going to be in the office, to see if we could schedule a time to meet. I don't recall specifically if I emailed the scheduler or contacted his aide.
All right. Did you, when you reviewed it, what all did you do? I mean, how much time did you spend reviewing this file?
It's my recollection everything was drafted. The initial draft of the ruling was already complete, and it was a standard law enforcement exception was raised, law enforcement exception applies, the information should not be disclosed. So it was a pretty straightforward review.
Venmo isn't working?
Did you learn one way or the other whether there had been a previous ruling and finding from the department as to whether or not the law exception applied to the same event that was now happening with DPS?
Mr. President, I believe the objection would
What
be
Venmo are you trying to send it
calls for
to?
the solicitation of hearsay.
And where are you getting the Venmo information so I can figure out what's
So
wrong?
I'll take it back.
You have to walk me through this a little bit
much.
because I'm tired.
So let me ask
So
you
where are
this.
you getting the
When
information
you
for
reviewed the file,
Venmo?
did you find out anything about
Where's
whether
the
or not-
error?
What event was being complained of that they wanted access, whose files they wanted access to?
The subject of the event was the August 2019 raid of Nate Paul's home and businesses.
All right. When you reviewed the file, did you find out one way or the other whether this issue had come before the agency once before about the file on the same event?
At the time, I did not connect this event to any previous determination by the office, but subsequently, I did connect the two.
All right. So ultimately, did you discover or connect that this was the second time around for Mr. Paul or his attorneys seeking information to overcome?
Patrick, I'll just
the law
simply note that
enforcement?
they said something similar about Kyle
Objection
Rittenhouse.
leading.
All right.
That him crying on the stand was an appeal to
Now, let me
emotion,
ask you this.
and it was a fake.
When you,
So just
after
like,
you
you know,
reviewed the file,
Check your bias a
you
little bit
informed
on
the
that
Attorney
one.
General you were available to meet. Was there a meeting?
Yes.
And can you put a time limit on time area for us as to when this meeting occurred?
It was in the middle of May, and the reason that I believe that it was between that period is because when the Office of the Attorney General receives an open records
Kurt M is not my
request for a
Venmo,
ruling,
just me.
The office has 55
Kurt M is not my
days,
Venmo.
up to
Where are you
55
getting that
days
it's Kurt M?
to issue that ruling. The DPS ruling was due June 2nd.
My Venmo is at Uncivil Law. Where are you getting Kurt
So we
M?
would have been discussing it in the middle of May before it was released.
Is it
on
listed
June
wrong
2nd.
somewhere?
Now, you made a minute. Was there already a draft opinion regarding the matter that was intended to be issued before July 1?
Yes.
Or was it June 1 or July 1? I've got.
June 2nd was the 55-day deadline.
And what was the preliminary opinion that already existed in the file when you started looking at it?
It was to withhold the information under the law enforcement exception.
Now, when you told the lieutenant,
Yeah, you're definitely missing my
General that you
point.
were available.
Right, in both the commonality is in
when
both
else did you
cases
meet with him if
you
you
had a male witness. In both cases, you had
it would have been a matter of
the male
days
witness crying on the stand. In both cases,
him and
the people who
scheduling
wanted
a
to
meeting in his
deride the
office.
witness
Where
said
did you- are you
that he
met
was
with him in
faking
his office?
crying, that was fake emotion,
Was
that it
anybody
was an
else
appeal to
present in the meeting?
emotion.
There
And
were a
I'm
series
simply
of meetings
reminding
at
you
which Justin Gordon, the chief of the Open
that
Records Division,
you know
and
to
Ryan
look
Banger
at this
attended.
All right.
that
so
to
at this
just
first meeting,
check
were
your
they
own
both
bias.
present?
You know.
I don't recall if both were present, but there were just in this meeting and the subsequent meeting, they were both in
There's
attendance.
a Kurt M with
one
an
or the
Uncivil
other.
logo.
What did the Attorney General say in this meeting?
He asked us to review the file. He asked us what our interpretation of the file was. He told us that he had spoken personally with Mr. Paul. He said that he believed that something bad had happened to Mr. Paul. He felt that Mr. Paul was being railroaded by the FBI and by DPS. And General Paxton said that he didn't trust law enforcement. He asked us to find a way
There's a Kurt M on
information that had been requested to be withheld.
Venmo, but does not have
Now, in your
the
experience
logo.
and your familiarity with the subject,
So
what was
I
your
don't know what you're looking at.
response
I'm
to that?
confused.
Objection hearsay.
It's not. This is the witness. This is his
Overruled.
response. Thank you.
I told General Paxton that if we were to reach the opposite conclusion and to require the Department of Public Safety to release the information, it would upset decades
Well,
of precedent involving the law enforcement privilege, where law enforcement agencies rely on the protection that the Public Information Act gives it to protect ongoing information, to protect confidential information, to protect witnesses who could be compromised if their names
I'm
or their
so
identities
tired.
were released. So there's incalculable problems with reversing the decision to withhold the information and require it to be produced, not just across the state, but with the Office of the Attorney General.
Mr. President, if I may, a lot of this is in narrative and not responsive to the question.
Thank you for the 500 of you who are currently here, by the way. I appreciate your being here.
Just state the objection.
Sorry I'm not exactly on my A game right now.
Thank you.
I'll try to get a more solid night's sleep tonight, so that I'll be on a better game tomorrow.
Experience is the potential danger to innocent citizens who had cooperated with the police, thinking that would be confidential.
It could silence people who might ordinarily comply or speak to the police if suddenly their names or identities could be released.
So what was the Attorney General's reaction when you told him all? But first of all, the stuff that you just said, is that essentially, in a sense, the information you gave him in explaining what your position was?
Yes, sir.
Did anybody else speak up as well?
Kurt M is the page underneath is uncivil law. I don't know what you're talking
I
about.
asked if anybody else spoke up. That is
Overruled.
thank you. Did anybody else speak up?
Yeah, Kurt M
Ryan
at
Baker
uncivil law.
also spoke. I don't recall
Yeah,
exactly what he said.
so that's me.
And what was the Attorney General's reaction to all this?
He, again,
I don't
insisted
know
that
what the
had happened
problem
to
is.
Mr. Paul was wrong and that he didn't
I don't know how to
trust
fix
law
it.
enforcement.
And
What setting
did he
am I
make
supposed to
any
fix? I don't
distinction about
know.
which agencies, or did he talk about all law enforcement?
It was specifically the FBI and the Department of Public Safety.
And did he say why he didn't trust them?
Nah.
He said that he compared what had happened to Nate Paul to General Paxton's own personal situation involving the Department of Public Safety and the State Securities Board and the FBI.
Well, were you aware of who provided his security?
Yes, sir.
And who was that?
The Department of Public Safety.
Did he indicate in his comments what his level of feeling or trust or distrust about them was?
Not to me.
All right. Now, how long did he, when you expressed what his initial opinions were, did he go any further, or how did the conversation proceed?
He asked me if he could obtain a copy of the DPS file.
Had you ever been asked or know of any other time where the Attorney General had asked to see a particular file that it's a public information request for?
No, sir.
So what did you do?
I said that it was possible for him to receive a copy of the file.
And I believe you said this was around May 15th, did you not?
Yes, sir.
Did you provide him the file?
Yes, I did.
Did it have everything in it?
Yes, sir.
Did you take anything out of it?
No, sir.
Can you tell us whether or not in that file you had, there was any brief from the FBI weighing in as to their materials in the file and their position as to whether it ought to be released?
Yes, the FBI had submitted a brief in response to the DPS request.
What was the process or procedure within your department if you have a request for open records, people want to get some portion of it from another agency? What was your policy as to let the other agency weigh in?
The Public Information Act requires state agencies to notify the third party whose information may be at stake that they have a right to submit a letter ruling or a letter brief to the Office of the Attorney General for consideration.
So in these circumstances, would it be normal or unusual for y'all to have notified the FBI there was this request, that the request was to an agency whose files included FBI materials? Would it have been usual or unusual for them to let them know so that they could respond if they wanted to?
So in this situation involving the DPS request, the Department of Public Safety did notify the FBI that its information may be at stake in this request for a ruling. And the FBI responded by submitting a letter brief to the Office of the Attorney General under the ordinary principles of the statute.
Were you aware through these materials and looking through the file that there was an ongoing federal investigation of Mr. Paul at that time?
Yes, it was clear.
Did you take a position with the Attorney General that there was an ongoing, at least federal, I'm not including right now state because I have no knowledge one way or the other, but that there was at least a federal ongoing investigation of Mr. Paul that release of these documents would interfere with.
Objection, leading.
Sustained.
Did you inform him one way or the other about, did you have discussions with him concerning the topic of an ongoing federal investigation?
Yes.
And what did you tell him and what was said?
It's my recollection that there were discussions about the substance of the brief that the FBI had submitted, the quality of the arguments that they had raised and made.
And did this brief provide details of the ongoing federal investigation?
Objection, that will solicit hearsay, Your Honor.
No, I'm not asking for communication. I'm just asking whether or not it contained details about it.
May I be heard on that?
Yes.
Mr. President, so Mr. Hardin is asking the witness about the contents of some other document that is not currently in evidence, pretty much right down the fairway of hearsay.
I'm not asking for
I'm going to sustain, rephrase your question.
Well, I'm not asking you for specifics of what it said. I am only saying were there documents and information in this file that were used as the basis of a conversation with the Attorney General concerning the presence of an ongoing federal investigation of Mr. Paul?
Yes, sir.
All right. Now, when you gave the file to him, how did that happen? Did you go to his office? What did you do?
I believe I delivered the file to Andrew Wicker, who was General Paxton's aide at the time.
And did you later confirm that Mr. Wicker gave it to the Attorney General?
Yes.
And how long was it? Will be some intervening events I'll ask you. Well, how long was it after that event that you retrieved your file from the Attorney General?
Well, as I mentioned, when the Office of the Attorney General has to make a ruling, it's on the clock. So we have a timeline. I was notified by Justin Gordon, the chief of the Open Records Division, that we needed to make a decision because the clock was coming up. It was approximately 7 to 10 days before that when I delivered the file to Andrew Wicker, and Mr. Gordon had emailed me asking for a status update.
And so then how long after, back to the original question, was it from the time you gave it to the Attorney General to you? Let me ask you this, was it ultimately returned to you?
Yes, it was returned to me.
And when was it returned, approximately when was it returned to you?
I believe it was May 28th or May 29th.
All right. And in the meantime, were you part of any later conversations after the one you just relayed?
Kurdam Uncivil Law is me.
The Attorney General.
I just don't know what setting I need to fix on Venmo. I don't know how to fix the
The first
problem.
meeting being him asking you to look at the file.
So that looks like that's
The
my
second
account.
meeting
I just
being
don't
the
know
one
how
we
to
just
fix whatever
discussed.
problem you're
In
having.
that second meeting,
If you can't send me money on Venmo, I don't know how to fix
any
it.
indication as to what he wanted you to do?
I'm tired and I don't know what to do.
Well, he wanted us to find a way to release the information.
And after you expressed yourself, Mr. Bangert expressed himself.
William
Attorney
sent me some
General
money today.
expressed
Thank you,
himself.
William.
In that second meeting, was there a conclusion as to what was going to happen?
No, sir, not that I recall.
All right, how did the meeting end up?
We were essentially at an impasse on our recommendation not to release the information
Send it
and
to
the
you.
Attorney General's decision to release it in some form. We told the Attorney General that we would review our options and follow up with him to see if there's anything else we can look at.
What was his position as to whether or not he wanted or thought the law enforcement exception should apply?
He didn't necessarily take a position that I recall other than something happened to Mr. Paul, it was wrong, this shouldn't be allowed for the FBI and the DPS to get away with.
All right. Now, after that, when was the next time you had any contact with the Attorney General on this matter?
Again, probably was a matter of days after that, just in line of the timeline and the deadline. We followed up and let General Paxton know that we looked at it again. We didn't think that we could reach an alternative conclusion.
And who was the we in that part?
Ryan Banger and myself.
And how did you let the Attorney General know?
We met in his office.
And do you recall when this third meeting was?
I believe it was toward the end of May.
And
Counselor, not to interrupt, we're a little past our mid-afternoon break. Is this a good spot, or do you want to go?
This is
You're fine here?
Sure.
Okay. We'll stand in recess until 3:30.
I got one from Nikki today as well. So some people are Venmoing me, so I'm not sure what the problem is if you can't, but some people are Venmoing me. All right, guys, I appreciate that you're here, and I'm really sorry that I'm low energy today. Some days sleep and I do not get along. I have sleep apnea, and despite the fact that I try to treat it with the CPAP, some days sleep and I do not get along, and last night was one of those nights, and I am incredibly low energy, and I'm sorry I'm not quite the entertaining Uncivil Law. Also, my attention span is basically shot, and I'm having trouble actually hearing the witness and sort of processing what he's saying, which isn't great because I'm trying to do analysis over here. I'm having difficulty listening or hearing, more to the point. But yeah. So far this witness has testified similarly to the witnesses we've already heard. They're talking about the drafting of this records request, which we heard from the first witness, and now we're hearing it from this witness again in a very similar story from a different person's perspective. So that's good. I also understand, at least to some degree, his emotionality. I mean, he gave 8 years of himself to something that he really believed in. And he now believes that the person that's the head of that thing basically betrayed the thing that he believed in. And, you know, that would cause someone to potentially feel upsetness about it. So, you know, if you gave 8 years of your life to, you know, the cause, and you found out the leader of the cause was, you know, a dipshit in your view, that might cause you to feel something, whether that would be anger or sadness or whatever, depending on, you know, your person's particular sensibilities. So, you know, that's what I have to say about that. Then he should have righteous indignation. Well, that would be a valid response, but I'm not sure it's the only valid response. Different people respond to things differently. Some people would respond with righteous indignation. Some people would respond with anger. Some people would respond with sadness. Some people would respond... People respond in all kinds of ways. Human emotions are diverse. You know, I think sadness is a valid emotion. You know, that this once great thing that you believed in has been torn apart might make you sad. I don't know. Just one man's view. One man's view. Stoicism may be a virtue, but not everyone is stoic. You know? And that doesn't go to their credibility, I don't think. You know? If your argument is he's not stoic, then fine. If your argument is that like only stoic people are good people or honest people, then I'm not sure I buy that. He responds with more emotionality. He feels more. That's just in the nature of him, I suppose. Navarro has been convicted of contempt of Congress. Who's Navarro? Who's Peter Navarro? The bell's not ringing. Trump's White House advisor? I'm still having problems. Hold on. I'll Google it. Let's see. Former Donald Trump trade advisor Peter Navarro has been convicted of contempt of Congress for not complying with the subpoena. Should I know who this person is? I'm looking at a picture of him. I'm not sure I know who this guy is. I'm not sure who Navarro is. He's a former Trump economic advisor. I'm not sure I know who he is. Maybe I just haven't been paying enough attention. Jan 6 subpoena, which wasn't legal? Sure it was. You know better than that. Why isn't it legal? Because you don't personally like it? Because it makes you sad in your fifis? Where are those facts over feelings? Huh? Where's your stoicism? I don't like the chance that you made. Well, apparently the courts disagree with you in any event, since it went to the jury and he was convicted and it wasn't dismissed, so I guess he can appeal on the legal question and we'll go from there. They violate their own laws of their committee. There are no laws of the committee. There are rules. You violate their rules? Yeah. They didn't follow the rules to create the committee? Well, again, I hate to point this out as we sort of mentioned earlier, but as we were sort of mentioning earlier, the rules are made up and the points don't matter. So Senate has standing rules, or the House or whatever. They have standing rules, but they can choose to do something else. They don't have to follow their own rules. Each house is the sole judge of its own rules. It's in the Constitution. So, they're the judge of their own rules. So did they violate the rules or not? I don't know. Ask them. If they say they did, then they follow the rules because they're the sole judge of their own rules. It's in the Constitution. They get to make shit up. I meant the rules don't need to be pedantic. I don't know what you meant, Grant. I don't know what you meant, and I'm tired, and I'm just trying to analyze things as best as I can. I wasn't trying to be a dick. I'm sorry if I came off that way. I'm just tired. And the party in power can change the rules. Yeah. Or more to the point, they can just interpret them differently. Changing the rules is hard. All they have to do is change the interpretation of the rules, which is easy because you need a majority. That was what the nuclear option was in the Senate. For those of you who ever heard the term, the nuclear option, which they used, right? Because to change the rules, I think you need, well, it's been a while, but to change the rules, I think you need to at least get past a filibuster, so you need at least 60 votes in the Senate. So you can't get that. So what do? You just interpret the rule differently. You just interpret it out of existence. That's what they did, right? Because there was a rule. This is what the Senate did when the Democrats were in power. Harry Reid, I think it was, right? And saying, "You'll live to regret this," on the floor of the Senate. Was it Mitch McConnell talking to Harry Reid like, "You will live to regret this," when they broke the filibuster for judicial nominees? Because the rule says, like, flat out, well, they broke the rule in the filibuster. That's what they did, right? Because the rule says there should be filibusters, right? That's what the rule says. Filibusters are good. And then they asked for, so then they said, "I'd like to not filibuster." And the chair said, "But filibusters are good." And they said, "Well, I call for an appeal of the decision of the chair," which is fancy speak for I'd like to challenge your interpretation of the rule. So the rule says filibusters are good, and then the majority of Senate votes and says, well, okay, when it says filibusters are good, what it means is filibusters are bad. And that is the correct interpretation, because they're the sole judge of their own rules. And thus, the filibuster was broken without having to go past the filibuster, because they just interpreted it out of existence. And it's legal, because they're the sole judge of their own rules. Yeah. They can do anything. They're magic. It's political. It's political. They can do anything. It's magic. You're just figuring this out. So did they break their own rules? Probably. Does it matter? Probably not. Not in a way that challenges it legally. No. No. Probably not. Yeah, and then they did live to regret it, right? Because Harry Reid did it for non-Supreme Court nominees, and then fast forward, like, what was it, 2 years later or 4 years later, and it's who was being nominated at the time? Was it Alito was being nominated at the time? And someone stood up and said, "I'd like to filibuster Alito's nomination." And someone said, "I don't like," and then, then Mitch McConnell stood up and said, "I don't like filibusters." And the chair said, "But the rule says filibusters are good." And then Mitch McConnell said, "I appeal the decision of the chair." And they had a vote on it, and they interpreted the rule that said filibusters are good to mean filibusters are bad. Filibusters were bad, and that's how they broke the filibuster. They just interpreted it out of existence, because you only need a majority for that. And that's, the brief history of how that came to be. So was the Senate was the January 6th committee lawfully chosen? I don't know. Ask Congress if it was lawful. If they say it's lawful, it's lawful. End of analysis. Because that's what it means when it says they're the sole judge of their own rules. When the Constitution said sole, they weren't kidding around. So if they say it's legal, it's legal. The rules are made up and the points don't matter because it's political. Yeah. I thought it was the 2/3 rule that Reid changed. Either way, Either way, it was the same. Well, no, they just interpreted it out of existence for judicial nominees. The rule still says filibusters are good. It just doesn't. The rule still says filibusters are good. It just doesn't. They're just not good when it comes to nominees for nominees for the court. So the rule still says filibusters are good. It just has been interpreted to mean filibusters are good, except when judicial nominees. Even though the rule doesn't say it, but that's how it's been interpreted because the rules are made up. So yeah, he didn't get rid of the filibuster for all purposes. There's still filibuster. It's just filibuster for everything now means filibuster for everything but judicial nominees. So the rule didn't change. The rule still says filibusters for everything. They didn't change the rule. They just changed the interpretation of the rule. Because they can, because it's magic. Grant says, do I think it's good? I think it's what the Constitution says. I'm a lawyer. I'm a legal analysis channel. I very rarely tell you what's good or not. I don't usually express opinions on what's good or not. I just try to tell you the law. This is the law. This is what it says. This is what it means. And then, as always, I just try to apply it consistently because I don't believe that the law means something different for me than it does for you. So whatever it means it across the board, right? I look for consistency. That's one of the reasons, by the way, incidentally, I asked that question about Kyle Rittenhouse, because I look for consistency. I look for a consistent rule. What is the rule? What is the rule, right? And so the reason I asked the question about Kyle Rittenhouse is specifically because I'm like, wait a second, here's an example where this chat probably as a general proposition went the other way on what seems to my mind to be a comparable situation. And so the reason I asked the question was to poke at you and say, effectively, in so many words, what is the rule? What is the rule? Let's be consistent. We can't have a different rule for Kyle Rittenhouse than this guy. Whatever the rule is, it can't be different for Kyle Rittenhouse. Whatever the rule is, it has to be the same. Now, you guys tried to say, well, it's a murder trial and he's young and all the rest of it. So you tried to find other reasons to separate the difference. You tried to find other reasons to separate the rule. But like, do I think it's good? I think it's what the Constitution says. That's where I say. Right. And it's like the same thing. Like, I think that the Constitution, at least in my humble opinion, says the president can pardon literally everyone, including himself. I said that when it's Trump. Right. When Trump was in office and people were asking, hey, can Trump pardon himself? I'm like, sure can. At least as far as I'm concerned. This is my read. Can Trump pardon himself? I'm like, yep, sure he can. So guess what happens when Biden becomes in office? Guess what I'm going to do if Biden pardons himself one of these days? I'm going to look right in the camera and tell you, yep, that's legal. Because that's the rule. You can't have it both ways. You can't have it both ways. What's the rule? You know, that's what I'm saying. So that's how I think about it. That's how I think about it. Patrick says, given that argument, I guess we should believe Amber Heard because she cried too. Well, strictly speaking, I'm not sure she did, because I'm not sure a tear came out of her face. So I'm not sure she strictly, technically speaking, did cry, but your point is noted. Right? My point wasn't to say, like, you should believe all criers. My point was to test you and try to poke at your bias a little bit. Because I came to the conclusion, which may not be necessarily a good conclusion, but I came to the conclusion that some of you guys were coming to the conclusion about him not being believable, not because you didn't believe he was crying, but you were using crying as an excuse. Because you don't want to believe this guy because you don't like what he's saying. You don't want to believe this guy because you don't want it to be true. Right? So the reason I asked the question was to poke at you a little bit and say, try to ask the question. I was trying to ask the question in so many words, like, okay, what is your real reason for not believing this guy? And are you sure? It was a call to check your own bias. Are you sure that you don't believe this guy because he's a crier and you don't like criers and you think he's weak or whatever? Are you sure that's what's going on? Or are you just using that as a convenient excuse because you don't really like what he says because for whatever reason, and I don't blame you, you like Paxton and you're just trying to interpret things in a way to favor your own conclusions? Are you special pleading this? I was trying to get you to think. Was I doing a good job? I hope I was. I was trying. I was trying to get you to think a little bit. But maybe I failed. Maybe I failed in my quest. But that was the goal. The goal was to make you think a little bit. He may very well be a liar. You may in the end conclude he's a liar. I'm not telling you that you have to believe him. I'm not telling you you have to believe him. I just don't want you to, like, what would you say? I don't want you to confuse what you want to be true with what is true. I don't want you to confuse what you wish for to be reality. I don't want you to, believe. I don't want you to dismiss this guy out of hand merely because he's not telling you what you want to hear. Think harder. Think harder. If you choose not to believe him, ask yourself why. Are you choosing not to believe him merely because it fits in with your a priori conclusion, or are you choosing not to believe him for other reasons? And by the way, just so that we're clear, I'm not saying I'm above all this. I'm not saying I'm above all this, because there are times where, of course, my own emotions and my own biases get in the way. I'm a human being. So there are definitely times where I can't see the forest for the trees. So this isn't like me trying to talk down to you or me saying I'm better than you. It's just me trying to say, think. That's all. So I don't know if any of that made any sense or if I'm even adequately explaining what I'm trying to say. But hopefully some of that makes sense on some level. I'm coming into this at least relatively neutral. I don't have any opinion on the issue. I don't read local news. So I don't really know what they're saying
Harden,
about
the floor is yours.
Beyond superficial headlines.
Thank you,
So
Honor.
I don't really have an opinion.
Now, Mr. Vassar, I'm just curious, what size is this file? It just occurred to me, everybody's been talking about this file that was the essentially open records request for Nate Paul and all. We've talked about what was in there in terms of descriptions, but what size file are we talking about, just visually?
It was a manila envelope that was maybe a 1/4 inch or less in thickness.
All right, and was it actually contained in a manila envelope?
Yes.
So like have a seal, not a seal, but like a little closing up at the top?
A label.
All right. Did you keep it sealed, or is it just in a manila envelope?
It's just in an envelope, not with the flap on top, but just a folding manila envelope.
I got you. All right. Now, at this time, we are, I think you said somewhere around May 28th, is that right, when the file you're estimating was brought back to you?
Yes, sir.
And that would have meant when you said that you believed you gave it to him around when in May?
The middle of May.
So about, the math would say like 13, 14 days. But you give me what your figure is.
I would say May 23rd.
May 23rd when you gave it to him?
Correct.
All right.
And then when it was returned on the 28th.
I got you. So you didn't have it for about 5 days.
7 to 10 days was what I recall. I apologize for the math.
All right. So, at any rate, that period of time, it was out of your possession to be in the possession of the Attorney General, correct?
Yes, sir.
All right. Now, when you got it back, so let's say toward the end of May, what was the next event or conversation you had with anybody, the Attorney General, concerning Mr. Paul?
The last meeting that we had regarding the Department of Public Safety file was that we did not recommend changing our conclusion to protect the information, but that there might be an alternative solution to take in issuing a ruling.
Why did you come up with an alternative?
General Paxton had asked us to find a way to release the information.
So who came up with a possible alternative?
Justin Gordon, who's the chief of the Open Records Division, had.
And what was that partial, that compromised position?
It was basically taking a position of no position. So we were not making a ruling saying to withhold the information, and we were not making a ruling to release the information.
Had you ever participated in that kind of position before?
No, sir.
Were you aware of it having been done before?
Not until Mr. Gordon suggested it.
Now, I'm not suggesting to you that never had it before happened in my question in the AG's office. I really am just simply asking, were you familiar with it ever having happened before?
No, not in the open records context.
All right. Now, well, what would be the implications of taking a position of no position? Would that be of any advantage to anyone as opposed to declining to release it? Let's do this. Under no position, would there have been 3 possibilities then that you would be treating that request? Here's what I mean. Just a flat out, we're not going to release the information because of law enforcement. That would be one, would it not?
Yes.
Another would be release the information, give it to them as they request. That'd be one, right?
Yes.
And then in the middle of that would be take no position, correct?
That's right.
If you take no position, does that have any different consequences than refusing to turn it over?
Objection. Mr. President, calls for speculation on the witness's part.
No, he's no.
All I'm really asking you, I want to try to ask you in a way that's acceptable. I'm trying to determine what is this, why do no position then as opposed to just you can't have it? What's the significance of no position?
General Paxton didn't want for it to appear that his office was aiding the Department of Public Safety or the FBI. And so by taking a position of no position, it was semantics, I suppose.
Well, what is your testimony as to whether if you say no position in terms of what you're communicating to people outside the agency as to the level of resistance you have to resisting?
Objection. Mr. President, calls for speculation on the witness's part.
Sustained.
Now, at any rate, was that the decision that was made?
Yes.
No position.
We were directed to take a position of no position.
And in these conversations and all with the Attorney General,
Yes.
had you expressed your position, being opposed to that?
Yes.
Had Mr. Bangert expressed his position of being opposed?
Yes.
Was there anybody else involved in talking about it with the Attorney General?
Not with the exception of Mr. Gordon, who had attended one of the series of meetings.
All right. And was Mr. Gordon have the same position as y'all did, even though he's the one who came up with no position?
Yes, my recollection is his initial review was very flattering of the quality and the content in the FBI's letter ruling.
Now, after that, did there become a separate issue from reviewing the file at some time?
Also, by the way, just want to say thank you to all you guys for giving me an opportunity to try to,
Paul's lawyer's position
talk to you guys
we
and
want the
express myself.
FBI brief.
Objection, leading and compound.
Well, I'll be glad.
Jordan Peterson, who I'm a bit of a fan of, has said before that there's no distinction between speaking and thinking.
And
I do like thinking out loud. And so part of the reason I talk
by the FBI
is literally to think.
The documents
and I appreciate you allowing me to think out loud with you.
Mr. President, asked and answered.
Overruled.
Was there?
Yes, there was.
And you got to speak in the microphone. Is your microphone on?
Yes.
Okay.
Yes, there was.
That's all right. And you're going to find you get tireder and tireder as the day goes on. You got to stay up there. I speak from experience, okay? In this particular case, did the FBI brief, what type of information was in the FBI brief if it was not redacted?
Objection, Mr. President. This calls for hearsay and the contents of a document that is
You
not.
just asked for what type of information.
There's no hearsay at all here. This is simply asking what documents are these. Are not.
What type of information, which is not.
This is nothing.
Asking for. Yeah, I think that's fine.
Overruled.
What type of documents were in there?
The FBI's brief.
By that, I say in there, referred to in the FBI brief.
Right. The FBI's brief identified emails, text messages, strategic planning, staging locations for the raid in August of 2019. They identified the task force members. The brief identified a under seal probable cause affidavit that said it was filed under seal, and the FBI brief indicated that that seal had not been lifted.
And so, including all these, when we talk about that affidavit sealed, it was actually under seal at that time in a federal court, wasn't it?
That's what the FBI brief said.
So the federal judge has ordered it sealed. It had not been unsealed. But if the FBI brief unredacted was released to the object of the investigation, that person would have all kinds of information that a federal judge had sealed, correct?
Objection, Mr. President. Leading.
I'm asking just, is that correct?
That's kind of why it's leading.
Rephrase.
What type of information?
If you're asking a question on direct and it ends with the phrase, is that correct? There's a pretty decent chance that you've asked a leading question.
What they were saying. Did they lay out sources?
It's like, all I was asking is that correct? I'm like, that's kind of the problem there, Cat Chap.
Investigation.
That's,
personal data of investigating officers and personal data on individuals. Was that included in the FBI brief as they argued against its disclosure?
Objection, Mr. President. Once again, this is not, the witness's testimony is not the best evidence of the content of this material. It has not been entered into evidence, and it remains.
Ooh, best evidence.
Surely we can't keep that information from this record. I'm asking you simply of the types of information.
Okay. All right. You don't hear that. You don't hear that objection very often. Best evidence. When do you want to do it? Admit the FBI file? That'd be hilarious.
We'll overrule. You can ask for the types of information.
Thank you.
Limited to that.
So, I believe my question was, In the FBI brief, did they, without saying,
Thank you,
now
Keith.
what they were saying, did they lay out sources, names of witnesses, background, history of the investigation, personal data of investigating officers, and personal data on individuals?
How is that not leading
included
in
the
8
FBI
different
brief
ways?
As they argued against this disclosure?
Yes, that was all the content of the probable cause affidavit that I recall.
Did it include this thing, 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 and their thing?
So,
Dude,
was it,
how is that
what
not
was your
leading?
understanding?
How's that
Mr.
not
William
leading
Knight?
8 different ways?
Lawyers for Mr. Paul were asking for things to be disclosed by the Attorney General's office that a federal judge had refused to disclose and sealed.
This guy isn't just leading. He's leading on levels. He's leading on levels. He's got leading inside your
Ask
leading.
it another way. Were you aware that a federal judge had placed these documents under seal?
Yes, sir. Based on the content of the FBI brief that indicated that the records were sealed and that the probable cause affidavit was identified as sealed.
So essentially, was the Attorney General of the state of Texas seeking to reveal to a person under a federal investigation the basis of the evidence so far that the government had against him?
Objection. Leading.
Sustained, can you rephrase that?
Sure. Was there a clear clash here between what the judicial system had decided somebody that it should be sealed versus a man under investigation seeking the sealed information?
Yes, that was my opinion.
And was the information he was seeking particularly harmful and dangerous to other people, if disclosed?
I believe so, to the extent it revealed the law enforcement information within the probable cause affidavit, the investigators that were involved, and other government officials that participated in the decision.
All right, so how did it proceed now about whether or not, by the way, by this time,
This guy is
time
leading
frame
more than my
where the
Clemson
officer
Tigers are
seeking
leading
the
in the
FBI
NCAA
I
football
believe the request was
polls.
submitted May 24th of 2020. So it
That
was
joke didn't
in the
work.
middle of our conversations about
Damn it.
the DPS file itself.
all right? And did they, when they were seeking it, how long do you think it was before y'all provided an answer?
This guy's leading. This guy's leading
The
more
answer
than
was
Duke
due
led
Sometime
Clemson.
in July.
That's better.
July 28th.
Of their open records request for the FBI brief, is that what you mean?
Correct. So if I can lay it out
Yeah, please,
on a calendar,
please.
the DPS file was due June 2nd. The request by Nate Paul's lawyers to the AG's office for the FBI brief was received May 24th. I believe the deadline to issue that ruling was July 28th, just based on the 45-day or 55-day time period.
Mr. Vassar, if we do this in a time frame, what is your testimony as to whether or not the request for the FBI brief by itself came before the no decision on the release of the DPS file? Did it become before or after?
It came before, because the DPS decision was not issued until June 2nd.
All right. When the June 2nd position was issued, I believe that was what you said was the no decision, is that right?
Correct.
All right. Now, anytime after y'all said no decision, was there any attempt anymore by people on that Mr. Paul's position, excuse me, was there any attempt any longer to get access to the whole file?
No, not to my knowledge. So just generically, under the Open Records Act, when the
All right, how about this
Attorney
joke?
General makes a ruling,
This guy is leading
have the right to
harder
appeal that ruling
than the
to the district
headline
court.
"Man lands on moon" in the New York
That's another way.
Times.
So to your knowledge, are you familiar whether
Do you like
or not,
that one?
after y'all said no to the DPS file on June 2nd,
So that's
was there any attempt by Mr. Paul's lawyers to appeal that to a district court?
Does that work?
As they were entitled to?
I'm not advised of that.
And instead, did they move to be trying to get an unredacted
made me
version
laugh.
of the FBI brief?
It's the timelines are suspicious.
And they're suspicious for what reason?
Sorry, Mr. President, I'm going to object to the witness's speculation and unresponsive statement and ask Your Honor to strike it from the record.
Yeah, we'll sustain that and strike that from the record. You can ask any other question.
When you issued no opinion on June 2nd, was there in that no opinion a redacted version of the FBI brief?
No, sir.
All right. As of June 2nd, had they had access to the FBI brief with the probable cause affidavit setting out the basis for the search and arrest?
Objection.
Just give me just a second, I'm sorry.
Please.
Strike the word arrest. There wasn't an arrest. I didn't mean that. Go ahead.
Objection, Mr. President. Calls for speculation. I understand the question to be asking for what Nate Paul's lawyers did or didn't have, unless I misunderstood Mr. Hardin.
Objection sustained.
Would it change if I said he misunderstood me?
Give it a try.
All right, no problem. All right, now let's do this. What was the decision? Did you have any conversations with the Attorney General on the issue of releasing to Mr. Paul the FBI brief?
Yes.
How did those conversations happen? When? Where?
They coincided.
See, there's a good direct question. How did those conversations happen? When? Where?
All right, so can you
There you go.
the time frame when you talked to
Who, what, when, where, why, how?
whether
There
to
you go.
release
Good
the
job.
FBI brief?
I believe it was the last week of May.
And when you did so, what did you do? I mean, what was the decision? Can you tell me what the Attorney General said?
I had notified General Paxton that the office had received a public information request related to the DPS file, and it was a request for the unredacted FBI brief that the FBI had submitted.
And what was his response?
He asked to see a copy of the two briefs, the redacted version and the unredacted version.
Yeah, I'm interested on the metal card sold as a novelty thing with the conviction on that one. I need to look into that on sort of the legal findings. That might be interesting.
We met
Trying to dig
maybe the
into
next day, and
the
he
courts.
showed me the two.
There must be
versions that I had
some
sent
sort
to
of
him,
like
and he had highlighted
analysis
and
from the
circled
court
and
on
marked up some of the documents, and he
how a metal card is a
stated to me
machine
that
gun
he
part.
didn't see anything in here that.
Which seems like a slightly dubious conclusion at best.
Attorney General of the state of Texas, are you saying, actually went over the affidavit and the brief, all the information that was referred to in the brief, and made circles himself on
it? He marked up the copies of the letter brief that the FBI had submitted to the Office of the Attorney General.
And the Attorney General decided, what had been your advice as to whether it should be released?
Well, the initial step in that process would have been to notify the FBI that the office had received a request for its information.
Did you do that?
Yes, I did not personally, but
Was it done?
it was, yes, sir, it was done.
And what was the status? Were you waiting for their response?
Yes.
What was did the Attorney General have a position about that?
On the response,
Yes.
so it was my understanding that there was a delay in either connecting with the FBI or the correct person to make a decision.
This guy is
whether to
leading
respond or
more
how to respond.
than French
After
soldiers
a
lead
follow-up
the wave.
attempt to contact their office. I don't know the content of that conversation, but I know we made a couple of attempts to contact them.
And then when you were unsuccessful in figuring out who in the FBI to talk to, what happened then?
After mentioning all of these sequences of events to General Paxton, he directed us to let the brief go out.
And he had earlier told you he didn't see anything that was a problem releasing?
That's right.
Do you know anything about the criminal law or practice history that Attorney General might have been particularly informed about to make those kind of decisions?
Objection, Mr. President. Calls for speculation.
No, let me rephrase it to make sure.
Well, how do you?
Sustain.
Do
You guys didn't get that one?
that you've ever witnessed or observed?
Okay, because
terms
how
of
do you do the wave
Of the Attorney General
in a football
to be making
stadium,
a decision
right? You get up and you
about
raise
what
your
law
hands,
enforcement
right?
Information should and should
So
not be
the
released.
French soldiers are raising their hands
No,
because
sir.
they're surrendering all the time.
Now,
That was the joke.
When you
They
released,
lead by doing the wave because they're
are you
surrendering.
saying
No,
the Attorney General's office
Funny joke.
released an FBI
much.
brief, unredacted, to the subject of a federal investigation, in spite of it having pointed out that the information in there currently was under seal with the federal judge?
Objection, Mr. President. Leading.
I don't think that's leading. I can,
Sustain. Sustain.
pardon me?
Sustain.
All right.
Rephrase.
Tell us exactly what the consequences and what he did when he ordered that brief to be released to the
stretch.
subject of a federal
Okay,
investigation.
I'll work on it.
So the decision to release the information was done under the Public Information Act in order to reach a decision that the office was required to make in response to a request for information. Based on what I recall, the absence of the third party responding or responding in time or informing the office that it didn't intend to fight the release resulted in a release under the act.
Well, would you have released it even if you were making the decision? Let me put it this way. You, as a courtesy, tell fellow law enforcement agencies this is under consideration, correct?
It's a required notice under the Public Information Act.
In your processes, are you allowed and able to review law enforcement information from another agency? And even if you don't hear from that agency one way or the other, do you have the authority to declare the law enforcement exception to apply and hold it back even if you don't hear from the other agency?
Objection. Compound question.
There are situations in the open records.
I think there were
context
3
when
questions
the
in
Open
that.
Records Division may raise exceptions based on the information that it reviews that may not have been raised by the parties.
In this particular case, what was your position, even when you had not heard from the FBI yet? What was your position as to whether this FBI brief, unredacted, should be released to the subject of the investigation?
I believe that it should have been withheld just based on the content of the document.
And did you argue that position?
Yes.
Did you argue that position even when you had not heard yet from the FBI?
Yes.
And once that information is released, is it released under any conditions, or can the recipient share it with
The
anybody
guy
who
is
wants
leading
to?
harder than Canadians in
released under any
1812 DC.
conditions.
So when you release law enforcement
I respect that.
information through a Freedom of Information Act or public records request, once that information is out, if anybody wants to find out, what would be the possibility if anybody with larceny in their heart wants to know addresses, names, all kinds of personal information about law enforcement or witnesses? Would they potentially have access to it if the possessor wants to give it to them?
Objection, Mr. President. This is leading and calls for speculation on Mr. Vassar's part.
Sustain.
Mr. Vassar, are you aware
Rusty,
that in September
let someone
of
else ask some questions
2020,
for a while.
a, quote, special prosecutor was serving subpoenas using the names and addresses of officials that appeared in the file that your agency released?
Objection, Mr. President.
Are you aware of that?
I'm sorry. Objection, Mr. President.
That is why this is relevant.
Don't talk to each other.
This guy is leading harder than
Assumed
Mr.
facts
Paul
not
was leading
establishing
Ken
evidence in this
Paxton.
trial, Your Honor.
Your Honor, I swear to you under my oath as a lawyer, you're going to have that evidence presented. Now,
I don't
guess-
have it now.
Pardon me?
We don't have it now.
I know that, but it's coming. My point being is I'm only asking him if he was aware the event happened. When he talks about evidence not be before the court as yet, I'm seeking to find out if he's aware how this information was used. He can say he's not aware, and that ends the inquiry. But if he says he does, it points out the danger of what exactly happened here in this case, which is at the heart of the major impeachment contentions that we have.
Mr. President, may I be heard?
Yes.
I have great esteem for my colleague. However, I promise it's coming is not a proper response to that objection.
Sustained.
Only this question. Was the type of information I talked to you about available then to the recipient once you released the FBI brief?
Mr. President, same objection, same horse, different question.
Still a legitimate question. The question was that available to the recipient? That's all. I haven't asked about anybody else you haven't heard information about. I'm talking about the person in this case, Nate Paul.
In this case, Counselor, I'll overrule.
Was it?
The information that would have been in the FBI brief is what would have been disclosed to the requester.
Thank you. Now, can I move on to was that the last contact?
Matova, great joke. I promise it's coming. Didn't make 4 children. Very good.
The FBI
plus 1 point.
Was there any more attempt to get the information from the DPS?
Not to my knowledge.
So what is your testimony as to whether or not, after you issued no opinion, but then released the FBI brief, was there any more attempt to try to get to a fuller file of DPS?
Not to my knowledge.
Thank you. And was there any lawsuit, to your knowledge, filed in state court to try to get it?
No, sir.
What did that indicate to you?
They may have gotten the information.
From some other way?
Yes, sir.
All right. Now, if we can, when's the next thing you had to do with Mr. Nate Paul?
Well, unknown to me at the time, Ryan Banger contacted me on July 31st, which I think was a Friday, in the evening, and asked me about a foreclosure opinion.
Did you? And how did that come about? That was, but you remember what day of the week that was?
It was a Friday evening.
All right. And Mr. Vassar, what did you understand that your responsibilities and mission were?
So, Mr. Banger.
Yeah, I may not be as tired now. We've had some funny jokes. I've got a little bit more life in me.
Foreclosure sales.
And did you understand, who did you understand this was a request from, that you were asked to do this?
From General Paxton.
Do you recall where you were when you got the information?
I was at home.
And what did you do as a result?
I responded to Mr. Banger over the phone and told him that I would look into it. I would give him a first draft as soon as I could.
Now, what time of day was it? First of all, what day of the week was it?
Friday.
And what time was it on Friday night that Mr. Banger called you?
Between 5 and 7.
Geez, if there's further information on that, I'd be interested.
Did you understand in response to the initial
It wouldn't
call
surprise
that
me
any
that that's
urgency
true.
with you?
I'd be interested to see if there's a
And
report that's
the
public
urgency,
about
when
that.
were you supposed to try to have this opinion?
As soon as possible.
What did that mean to you? No, it's okay. Go ahead.
I told Ryan that I would get him a draft sometime that evening, if not first thing in the morning.
All right, did you do that?
Yes.
And then what did you do the rest of the morning in connection with it?
Ryan and I spoke about the draft. He agreed with the initial conclusion, which decided that foreclosure sales should be allowed to proceed under the governor's executive order at the time.
All right, and were the two of you in agreement with that?
Yes.
About what time of day did y'all get a document that you thought was sufficient to send over to the Attorney General as a draft?
It was probably 11 to 12 on Saturday, that next day.
What's the next thing you did in connection with it?
Ryan called me not long after that, probably 30 to 45 minutes after he had sent it to General Paxton.
Were you aware as a result of that phone call whether he had talked to the Attorney General?
Yes.
And as a result, what did you
One of the
understand
witnesses
your
in the
position
Enrique Taro trial
understood
was apparently a
that
government
General
informant
Paxton said that we got the wrong
who had been
answer.
working for 2 years.
So the right answer had been what, in your view?
Well, based on the office's position on numerous COVID-related matters, we had erred on the side of opening Texas, not closing Texas or prohibiting people from gathering. We had issued a number of opinions relating to houses of worship, election issues, and schools, all of them encouraging opening, not closing it. So the initial conclusion was based on my understanding of the office's position throughout the summer.
And did you make a legal determination that that went in line with what you believe the office
Masterson got 30 years?
Yes.
And then what happened when you were told you had the wrong answer? What did you do?
I laughed.
Damn.
Why did you laugh?
30 to life. Damn.
Just because I found out that I had gotten the wrong answer when I believed I had reached the right answer just based on the office's position throughout the summer.
All right, so then what did y'all do?
I told Ryan that I would take a look at reaching a different conclusion. I think he volunteered to do that and made modifications to the draft that I had sent him.
Now, you two guys are deputy chiefs of the whole office, right?
The sentence was the maximum allowed by law. It means Masterson will be eligible for parole after serving 25 and a half
Pretty
years.
high up in the food chain, were you not?
Yes, sir.
How often do you two write opinions?
Rarely.
He's 47 now, so that means he wouldn't get out until he's, what, 73?
We're doing it rather
Woof.
than, very capable lawyers underneath you in the
That's rough.
litigation section?
I think it was a priority issue that General Paxton wanted someone to get it done as quickly as possible.
All right, so who did the main drafting this second time?
It was essentially the same shell of the first draft, and Ryan Banger revised the conclusion to conclude that foreclosure sales should not proceed.
Were you aware of at that time any contacts that Mr. Banger and the Attorney General were having in drafting the opinion?
I knew that Ryan Banger was speaking with General Paxton.
And were you getting any kind of progress request or were you aware of how often they were speaking one way or the other?
No.
All right. And then was there any challenge to rewrite it?
Well, I mean, we had to go back and adjust the analysis to the extent we could based on the position that we had taken initially.
All right. Now, once you completed it, about what time in the morning on Sunday did you complete it?
I spoke with Ryan throughout the day on Saturday after we were exchanging.
Masterson also has to register an SA offender. Yeah, I suppose he does. I'm not sure how much it matters in the end, but technically, yes.
Around midnight on Saturday evening.
But was he passing on to you, y'all discussing at that time, any involvement in the Attorney General in the editing process?
I was not involved in any conversations directly.
That was going to be my next question. So during that entire evening that night, is it correct to say you were not dealing with the Attorney General, only Ryan was?
Judge was pissed.
That's right.
Okay. Now, once it was produced, at any time during that process, did you have any idea whether or not this was something that would or would not benefit Nate Paul?
No, sir.
Did you later change your opinion or your sense of awareness?
Objection, Mr. President. This calls for speculation.
I'm only asking about his mind state. I'm not asking anybody.
Overruled.
Thank you. Go ahead.
Yes, sir. I believe Monday, or I think it was Tuesday.
And what changed your mind Tuesday?
Well, foreclosure sales across the state are held on the first Tuesday of each month. So when the opinion was announced on our website on Sunday at roughly 1 in the morning, a foreclosure sale was reported in the media to have been...
Objection, Mr. President. Any reports in the media would be obvious hearsay and inadmissible.
Sustained.
All right. All I'm going to ask you is, did news reports provide you information that changed your sense of awareness?
Same objection.
I'm not asking you what you heard, not asking you what you read, not asking you any hearsay or anything. Just simply, did news reports later change your sense of awareness, whatever that was?
He's just, excuse me, he's just asking about did it, not what was in them. Overruled.
Yes.
All right. Now, at the end of the day, did whatever that opinion was, did that concern you, and if so, why?
Well, not at the time. It was odd, but it wasn't concerning because at the time I had no context for who was involved or what it was for.
And then once you did have a context about who might be involved, did that change? What was your reaction to that?
It was even stranger that we would have gone through that effort to become involved in a potential Nate Paul related issue involving foreclosure sales.
Okay. Now, after that opinion was done, did you have anything else to do with anything that Mr. Nate Paul and his businesses did, whether it was later bankruptcy or any other events? Did you know anything else? Do you have anything else to do on that front, on foreclosure front, with Mr. Nate Paul or his affairs?
No, sir.
All right. Now, let's go to the final area I want to talk to you about. Was it tell us what your responsibilities were if somebody above you or below you wants to do a contract with an outside lawyer. Let's start here. What was the policy generally of getting outside law firms within the agency? How would that happen ordinarily?
So ordinarily, with an agency of 800 lawyers and 4,000 employees, there are sometimes a need to retain outside counsel. That could be because it's a specialized area of law. Maybe it's intellectual property law, where the Office of the Attorney General doesn't employ IP lawyers. It could also be a local counsel issue. If the state of Texas wants to intervene in a Virginia case,
I'm available.
Local counsel. So
I'm available if you want to intervene. If you want to intervene in a Virginia case,
we would have engaged outside.
You can borrow my law license, Attorney General's office. I'm available.
All of those requests are managed by the General Counsel Division, which I oversaw in my role as Deputy Attorney General for Legal Counsel.
Well, now, how often in your memory have you ever recall outside counsel being retained to do a criminal investigation?
None.
Ever?
No, sir.
All right. And why is that?
Mostly just because the prosecutors and the attorneys in the office would handle that work.
So when did you first become aware that the Attorney General wanted to hire an outside law firm for a criminal investigation regarding the complaints of Nate Paul?
Well, the first time that General Paxton contacted me, I believe, was in the middle of August of 2020.
And what was the nature of that contact?
He wanted to know what the basic process was to retain outside counsel.
What did you tell him?
I told him exactly what I just explained to this chamber of there has to be a request, there has to be a specific need. The attorneys have to be vetted to ensure that there's no potential conflicts of interest. And there's a formal approval memorandum and a outside counsel contract template that is signed by the attorney and the Office of the Attorney General.
So can we have our exhibit 160, please, Stacy? Is that not in evidence? All right, we moved into evidence 160.
Peggy asked, do I have trial experience? Not much. Most of my work was transactional. The little trial experience I have was not in my primary field. I did some pro bono work.
No objection at all, Mr. President.
That had some trial experience, but it's not my primary. It's not my primary field.
Now, I'll represent. Well, you tell me. What is exhibit? Do you have a hard copy?
It's on the screen right now.
Okay. Do you recognize what it is?
I do. It's an email from myself to General Paxton's Proton Mail email address, dated September 3rd of 2020.
Now, that's a different type of email address than the official Attorney General email route, isn't it, or is it? What is a Proton ID?
But I really,
I'm not
I don't
sure.
know that I
I
necessarily
believe
want to
it's
do
a
trial
private
work.
email.
In sort of my, I'm more of an appeals guy
Suggested by
because
lawyers,
trials
it's very
are about
frequently
facts,
used in your-
and facts
in your organization.
are messy.
Is that true? And there's a
I don't
email
want to do
address in
facts.
addition to
I want to
the
do
official
law.
one,
And that's
very
where
commonly
appeals are
used
about,
with
is
the people
about
in the
law.
office.
Objection, Mr. President.
So
Lack of foundation and
I think my
compound
next job
speculation.
probably will be
They
like
can't
as an
do what
appeals
they-
specialist.
You heard the cross-examination in this kid talking about how common and ordinary
You
it
know,
was.
you tell me what the
Surely I'm
you tell me what the
allowed to ask
facts
his
are,
witness if
and I'll
that's true.
figure out the
Mr.
law. You
President, I
know.
That's all I'm doing.
I'm sorry, Mr. President, I believe we've invoked the rule and perhaps should not be talking about what other witnesses testified to with this witness.
I was getting ready to say that.
Pardon me?
I was getting ready to say that.
Yes.
Sustained, and you should not be talking about other testimony given in that specific instant.
Well, let me ask you. If one were to contend it is commonly used within your agency to have a Proton email address, would that be accurate or inaccurate?
Objection, Mr. President, calls for speculation.
Your Honor, this is really...
Yeah, overruled. Go ahead.
Thank you.
Not to my knowledge.
Pardon me?
I've never, not to my knowledge, it would not be ordinary.
How did I do in trial work?
I am not even sure. what it was.
Most of
Yes, I'm
them
not trying to
settled
suggest
out.
It's never done, but in
One
your
of them went
experience,
to ultimate conclusion.
frequently or infrequently been dealing with official business in your agency with the Proton
We didn't win,
email address.
but that's okay.
Objection, relevance.
It didn't help that our
That's
client
really
basically
overruled.
sabotaged our case on the
Go
stand.
ahead.
No,
That,
sir.
you know, so that was
this
good.
Could be the first time that I had used that email address for General Paxton before I.
It was a civil case
haven't
though,
seen it
not
before.
criminal. So
How did you know to use it here?
I think I asked him for his email address that he wanted me to send the contract to, the draft.
The general himself?
Yes, sir.
So are you saying that 5 years you've been there, this email address is the first time you ever used it in dealing with him?
Objection, leading.
I'm asking, just try to be clear.
Sustain the objection, but rephrase.
Thank you. In this particular case, do you recall when he gave you this, how did he ask you to do it, first of all? Did he call you, drop in on you, or how did this happen?
The first time was a phone call when he asked about the basic process for retaining outside counsel. The second, he came into my office on September 3rd, and he instructed me to draft a contract for Brandon Kamek.
And then did he tell you at that occasion where to send it?
Possibly, if I
I did a landlord-tenant
ask
case
him,
one time.
He could have instructed me in my office.
I did a landlord-tenant case, and our
where
client
it's
was facing eviction.
Ordinarily, if he sent it, if you
And
sent it to his regular
she
official
obviously had some debts from the
agency
landlord,
email address,
and she
who
kind
had
of
access?
sabotaged our case.
I believe
And so we went to her, and I'm like, okay, you got to
assistant
listen to me.
has access to his
We're
email
going to
box.
lose.
I don't know if he had access.
We're going to lose,
This
and
Proton
they're going to get a writ of
address being
attachment,
on
and they're going to seize
access
all the
would
stuff in
other
your
people be-
apartment. So
would
you got to
other
go home
people
tonight,
be aware
and
of
you
it
got to
or
clear out
only
your
run into
apartment.
it? If you sent something at this address,
And
does it
God
become
bless her, she did,
available to others, or would it be only to the user of this email?
because she had like
President.
she had
Calls for speculation.
fairly
lack of
expensive
foundation.
like electronic
Since that's not
equipment and
evidence.
stuff. So she had some
not asking for
equipment that had
I
value.
know what facts are not in evidence I have talked about.
And so she went home and she cleared out her apartment,
Is if this is used,
and we lost.
would
And
that
sure
would
enough,
be
opposing counsel
restricted
immediately said, "Your Honor, I move for a writ of
the
attachment."
Attorney General. That's all.
And I just simply said,
And
Your
Mr.
Honor,
President, what I
that issue is
concluded
moot.
with my objection,
The apartment
there
is
no
empty.
foundation laid for Mr.
Here are
Vasquez
the
to know
keys.
anything about what the other agency
And they were
employees
very,
can
very
access or
sad.
cannot access.
Sustained.
They were very sad.
Now, when you sent him this contract, did you draft anything in there that was a little different?
Well, I drafted the scope of work.
And when the Attorney General asked you to do the draft, was anybody else around you when he asked you to send it?
No, sir.
Did he describe to you what he wanted this person to get a contract for?
Yes.
What did he tell you?
It was my understanding that Mr. Kamek was being hired as a second set of eyes, if you will, to review the Travis County District
So we
Attorney's
managed to save our
referral of the
client's
complaint involving
assets,
Paul.
what little she had.
And had
So,
you been ever asked to
we-
do that
we
in the
counted it as a
criminal law
partial
area
win.
before?
No, sir.
When was the last time you had done an outside agency contract for somebody to do a criminal investigation?
I can't recall one.
Does that mean you don't remember any?
That's right.
All right. So when you did that, did you pay attention to a particular concern as to how to limit the scope of work?
Yes, sir.
Why did you do that?
Well, the referral from Travis County used specific language about providing assistance to Travis County.
Did you look at it at the time, the referral?
The first time I was given a copy of the referral from Travis County was September 3rd.
Were you aware at that time, one way or the other, of any conversations and disagreements that had been occurring internally as to whether Mr. Kamek should be hired to do this? Were you aware through talking to other people or any other source?
Objection, Mr. President. That response would call for hearsay.
I've not asked for the statements yet. I've asked if he was aware of anything.
I'm going to sustain. Would you re-ask the question?
Thank you. So, at that time, were you aware of any other concern about this matter, namely Mr. Kamek being hired to review a criminal investigation or whatever the assignment was? Were you aware one way or the other as to whether there was any opposition by other people in the organization to hiring Mr. Kamek for this project?
Objection, Mr. President. That would be derivative of hearsay.
I have asked simply whether he's aware of...
Overruled.
Thank you.
He can answer.
Are you?
Yes, sir.
Is that another reason you wanted to be cautious?
Objection, leading.
All right, that's fair enough. Are you? Thank you, Judge. Were you, because without going into what you said, had you had conversations before September 3rd with the Attorney General about this matter?
Yes, sir.
When did you have your first conversation with him about it?
The first time would have been when he asked about the basic process. That would have been around August 15th.
And at that time, did he talk to you at all about what he had in mind?
No, sir. It wasn't until the week of August 26th, I believe, when I was on vacation, General Paxton called me and asked me to explain the process, the basic process, to two individuals.
Did he mention Mr. Kamek's name?
Yes.
What did he say to you?
He just asked me to contact both of the individuals, explain the process to them, and that these were the two individuals that...
The other person, why two individuals? Was there somebody else under consideration?
There were two names that General Paxton gave me.
And what was the other name he asked you to prepare a potential contract for?
Joe Brown.
All right. Mr. Joe Brown had been a previous U.S. attorney, had he not?
Yes, sir.
All right. Now, so did you prepare a contract like we just introduced for both Mr. Kamek and Joe Brown?
No, sir.
All right. Whom did you prepare the contract for exclusively?
So the only contract that was prepared in this matter was for Brandon Kamek.
And why did you not do one for Mr. Brown?
Based on when the Attorney General came into my office on September 3rd and directed me to prepare a contract for Brandon Kamek, it was my understanding that there was no longer any need for a contract for Mr. Brown.
All right. I want to take the contract now. Stacy, if you could put up, I moved to introduce 160. I'm not sure. I got a reaction one way or the other.
Mr. Hardin, you admitted it.
Thank you.
Yes.
Yeah, it's admitted.
Thank you, Your Honor. I want to move on this contract of September 3rd over to the addendum. Can you go to the next to last page, which says Addendum A? You have that?
Yes, sir.
And is there a portion of this contract and this addendum that you can direct the court and the jury to that will show how you tried to restrict the scope of activity in this contract?
Well, and again, this was all drafted based on my understanding of General Paxton's decision of what Mr. Kamek should be doing, as well as the conversations about the Travis County referral and the extent to which it authorized our office to assist. You can see that the first paragraph specifically refers to certain criminal violations made by state and federal employees. So there's a singular referral.
You're welcome.
That this contract is referring to.
Happy to stream this.
It says, does it not, that this is to be a review of the allegations, correct?
That's correct.
One could review the allegations just by looking at them, right?
That's right.
Object to the sidebar. Move to strike.
It's not a sidebar, it's a question, Your Honor.
You can strike the word right.
Okay. And a review of the allegations, which include complaints of potential criminal violations made by certain state and federal employees. Were you aware at that time of any of the details of what was in Mr. Paul's complaint?
When I drafted this scope, that was the first time that I received a copy of the referral and a copy of the complaint.
And when you looked in the referral, when you looked at the documents that Mr. Paul had provided the Travis County DA's office and that they sent over to the Attorney General's office, what type of allegations did you note as to what type of people and conduct this young man was to look into?
Based on what I recall, Mr. Paul had alleged that certain members of the FBI and the task force, the Department of Public Safety, may have taken his phone from him or not allowed him to contact his attorney. They may have damaged property searching through evidence. I don't recall the specific nature of the allegations other than just...
Were there allegations about improper conduct by a federal magistrate?
Yes, sir.
Did that give you pause?
It did.
Well, all right. So when you see these kind of allegations, then how did you draft it?
Did anything interesting happen? I think I passed out there for a second.
Well, the last paragraph refers to conducting an investigation under the authority of the OAG, which would be derivative of the complaint, which is to assist. Towards the end of the paragraph, it explains that notwithstanding anything else, outside counsel should only conduct an investigation consistent with the complaint and only as directed by the Office of the Attorney General, meaning that any activities that he wanted to pursue should have been authorized and approved by the office.
And in it, as the way you structured this, do you make any reference in there to this man becoming a special prosecutor?
There's a plain exception that says that the legal services under this contract do not include any other post-investigation activities, including but not limited to indictment or prosecution.
So as you believed when you drafted this contract and circulated it to be approved by others, what did you think this contract was setting out, giving him the authority to do if it was approved?
In short, he was to review the allegations in the complaint, the statements in the complaint, prepare a report that would be returned to our investigators to provide a second opinion to General Paxton.
And those investigators of yours would have been of who? Who would they have been turned over to?
David Maxwell and Mark Penley. David Maxwell was the director of law enforcement at the office, and Mark Penley was the deputy attorney general for criminal justice.
Did you have discussions with the Attorney General that this is what he was authorized to do? Or did you have any, first, did you have any conversations with the Attorney General about this?
Yes.
About this restriction?
About the nature of the services that Kamek was being hired for, yes, sir.
What did you say to him?
I just explained that We can't, the OAG, the Office of the Attorney General, cannot ordinarily engage in a criminal investigation except for a referral, a case of a referral. General Paxton explained that he had a referral from Travis County, and then I explained that even under a referral, we wouldn't have an outside counsel representing the agency.
Did I understand him correctly that the Office of the Attorney General does not do criminal complaints?
He didn't
unless it's referred to them by someone else?
And so then
they don't generate their own?
Done this, what kind of process it was supposed to go? Did you, when you sent this to the Attorney General, did you get a response from him?
No, sir.
Did you hear back from him on this?
Not that I recall. When he asked me to send him a draft of the contract, he also asked me to send it to Brandon Kamek.
Well, so if I can, I move to introduce 161, please.
That's interesting. Okay.
I don't see this on our list.
I guess that kind of makes sense.
Introduce it. I believe it's not in evidence.
Okay.
No objection, Mr. President.
Stella, can I have a hard copy, please?
There are no objections when you receive it, Mr. Harden, you may.
Thank you very
We'll
much.
admit 161 to evidence.
Thank you. Now, this is, would you identify this for me on September the 3rd? Now, this is, I'm sorry, Your Honor, may I have just a second?
I mean, okay. I mean, to some degree, this is just echoing what other witnesses have testified about. So he doesn't, I don't think he's really offering anything new, but he's just providing another witness that these things happened with respect to this, like, external witness, this external person, this contract thing,
the same document that
and
you had
some other things.
the same day on September 3rd, except that this one is to Mr. Kamek. Is it the same document?
Yes, sir, that's right.
All right, so now you have forwarded a contract to Mr. Kamek and the same contract to the Attorney General. But what all would be necessary to happen before this became a true contract and Mr. Kamek authorized to work for the Attorney General? What would be necessary?
So ordinarily, when the Office of the Attorney General wants to engage an outside counsel, that has to be approved internally through what was referred to at the time as an executive approval memorandum. That memorandum would explain the background of the request, the nature of the legal authority through which the agency could act, and the amount that was likely to be expended.
All right. In this situation, if you're going to go through the matrix for the contract, would you explain on this type of procedure what would all have been, what would it be, the process? How many people would have to approve of this?
I'll run through them very quickly, but generally the process would start with the General Counsel Division Chief. It would next go to the Financial Litigation and Charitable Trust Division. Budget would be next. I believe I would be next in line as the Deputy Attorney General for Legal Counsel. Given the nature of the services involved criminal justice, Mark Penley, the Deputy Attorney General for Criminal Justice, would have been next. I believe Lacey Mays was next.
Well, in y'all's process, does anyone along the...
How many people do they need to sign off on things over at the Attorney General's office?
To accept it or approve it?
How do they get anything done?
Basically,
That's
request
the most
was
pertinent
denied,
question I have.
but it
How they
could
get
be
anything
revived
done when you
based
have
on
8
further
different people
conversations.
who need to sign off on
In other
anything?
words, everything stops if somebody declines until at least it's talked about more? Is that what you mean?
Yes, sir.
All right. So what happens?
That's a
if the
lot of
Attorney General
bureaucracy.
goes
I'm
out
just
and
saying.
unilaterally
That is a
hires
lot of
somebody
bureaucracy. That's a lot of
without
levels.
sending it through the process at all? In your opinion, could he do that?
Yes, sir.
All right. He has the authority, right?
Yes, sir.
He's the guy. Okay. Now, if in fact, are you familiar with why y'all follow those processes, though, that you've just described that would be in the ordinary situation? Why do you do it that way?
Mainly for efficiency purposes, but also just to ensure that each decision is vetted by the divisions that may have input or advice on.
I mean, he's talking about himself, right? And at this time, he's like, he is the division head or something of whatever.
That are affected by
And the contract gets to him and still has levels to go.
What all divisions would be affected that would have to okay?
You know, like,
the general counsel.
you don't trust the head of the division to make the call? You still need more people beyond that to sign off in it?
Myself.
And we need a different division. We need their signature too.
The controller.
This guy's
the agency
signature.
Controller, the deputy for administration. The
As
deputy
AG, I'd probably lose my mind.
of staff and the first assistant.
It's like 8 people, isn't it?
There's a lot.
Hey, thanks a lot.
I'd lose my mind.
All right.
I need 8 people's approval on this?
Now, let me ask you, in the emails that we looked at, or in this document, 161 is a contract, earlier some emails where we looked at 160. 160 is the contract that goes to Mr. Paxton. 161 is a contract that goes to Mr. Kamek. Is that correct?
Yes, sir.
And then you go, if you want, 228, contract 228. Not contract, exhibit 228. Well,
I don't really want to be AG. I'd rather be Solicitor General than AG.
I apologize. I want to ask you I want you to look at 166.
I'd rather work in the
This is
office of
already
the Solicitor
evidence, Your
General than
Honor,
the
because
office
I
of the
think it's
Attorney
already been
General.
up on the screen once.
It's a better job, in my opinion.
Yes, it is.
I want to go argue
Thank
in
you very
court.
much.
I don't want to go enforce laws.
161. Now, does this?
Well, someone
I
else
want
can
you to look
enforce
at
laws.
this
All right,
and
briefs.
Describe for everyone whether this sets out the approval level it has to be done. Does it?
Like I've said before, that I think
All right.
like my dream
Now,
job would be
this
like
is
Solicitor of the United States.
The contract
I think that'd be so cool.
that is to be the process to get Mr. Kamek's contract approved, correct?
That's right.
So it starts out with Joshua Godby, the Charitable Trust Division. Why would he have to approve it?
So the Financial Litigation and Charitable Trust Division manage the Office of Attorney General's outside counsel contracts.
Yeah, I've heard that
Do y'all
before. Reagan's
approve
line,
the
"Tear down this
contract
wall,"
that
is rejected
doesn't
6
have
times by the
to
State
fund it? Who
Department.
has to agree to fund it?
The budget division has to approve funding.
It's like, I don't need your
go
approval.
up.
I'm the president. I
Then
outrank your
Josh
ass.
Godby, after him is Ryan Vassar. Who drafted this particular document?
I did.
All right. And how did you know what to put down here under the synopsis and background?
Just based on my understanding, again, of the nature of the services that Kamek was being engaged
Now-
for.
Excuse me.
Mr. President, I believe there may be some distrust over whether this document is actually in evidence. We do not object to it. It has not been offered.
Yeah, we're just relooking at that now. So it was not entered, but you do not object? Is that
do
correct? Pardon?
not.
Okay.
I believe it was shown by an earlier lawyer on your side. I think you had
It was a pretrial
Yeah.
issue that didn't come in.
Are good.
But you're good. Go forward.
Thank you very much.
You did not
Joe.
object.
No, thank you. Thank you very much. Now let's.
Excuse me, for the record, 166 is admitted to evidence.
Thank you very much. Now, so you prepared over on the second page, or it says page 1, but second when you turn it, the synopsis of what happened in the background and all of that?
Yes, sir.
I want you to tell us in your own words, when you sign off an initial, this particular contract, did you sign off as if you approved it?
Yes.
All right, why did you do that?
I concluded, based just on my position of whether the agency had lawful authority to hire an outside counsel, Brandon Kamek, in this situation, that it did.
So you understood who wanted to hire him?
Yes.
Who was it?
General Paxton.
Describe it in your own words, that he made clear he was going to do it.
Yes.
So did you have any doubt whether or not that's what he was instructing you to do?
No, sir.
When you draft it, put a synopsis and initial it. Tell us in your own words, what was your position then as to whether this contract should or should not be approved?
So based in my position as deputy for legal counsel, my role was to recommend based on whether the agency had lawful authority to act, not whether it should act. So in my review, I determined that Kamek, as outside counsel, could provide legal services to the agency to investigate or to review the complaint referred by Travis County.
And what would be your position as to whether he had the authority if he stepped outside the scope that you had drafted so carefully in the addendum A?
Objection, Mr. President. That would call for speculation.
Sustained.
Was he authorized to do more on behalf of the Attorney General's office than you set out in the scope A of the contract?
Not in the draft that I wrote.
All right. Now, when you sent these two contracts, or these proposed contracts, that you've just raised an issue right there. Were these drafts or were they final contracts?
They were both drafts.
So at the time you sent these out to Mr. Kamek and to the Attorney General, what was necessary to make them a binding contract where the Attorney General's office had actually legally hired Mr. Kamek? What process was required?
Objection, Mr. President. This actually calls for a very important legal conclusion. And this witness is not qualified to reach that conclusion on the ultimate issue.
I'm asking him what process within his organization was necessary for it then to be, at least him to consider it, a complete contract with the agency. Let me put it that way.
That is a different question than the one you asked.
So I'm going to sustain the first objection. I'll sustain.
But he's allowing the second one. Is that
Well, you can start the second one now.
Thank
One
you.
more time.
Thank you. So what was necessary in your mind as the person responsible for both drafting and initiating these contracts to make the drafts you sent to Mr. Kamek and to the Attorney General, what was necessary as far as your procedures and your experience and in your opinion to make it a contract that where Mr. Kamek was actually officially hired and entitled to be paid under the contract?
Objection, Mr. President. That question is extremely compound. There are several questions in it. Procedures, policies, his opinion may be very different things.
Sustain.
The contract that you sent, had it been signed by anybody?
No, sir.
To be a binding contract as far as you were concerned and the agency and your responsibilities, whom did it have to be signed by to be a binding contract?
Under the agency's signature delegation policies at the time, it would have been Jeff Mateer.
All right. And if the contract at that time was signed solely by Mr. Kamek, do you have a contract, or does it have to be signed by somebody that can bind the agency along with Mr. Kamek?
It would have needed to be signed by the agency as well as funding obligated to pay for the services.
So did we ever get to that process that you were aware of at this time?
It was started. I believe June 4th, we started the internal approval process.
And that's the internal process. It's circulating it to the people on Exhibit 166?
Yes, sir.
Just to correct the record, the witness said June 4th. I believe you mean September 4th. Is that correct?
That's right. September 4th.
I'm sorry?
Let the record reflect September 4th.
Okay. The cover sheet would be 166, would it not? The contract, I believe, were the 164. 161, I'm sorry. I just want to make sure we got it straight.
Oh, I'm sorry, were you talking to me?
We've got
Be
160.
best to speak to the court. And
166 is what I introduced that you accepted. And that's a copy of...
Leah Remy is suing Scientology for harassment.
That's what I was asking.
That should be
That's what I
entertaining.
was asking about.
don't talk over each other. Yes, sir.
166 is on the screen, and it has been in.
I'm reading her complaint right now.
Pardon me?
You can continue, Mr. Hardin.
I'm sorry, I'm all confused.
166 has been admitted.
Right.
166, correct?
And I thought you were changing the number on me.
I'm sorry, I'm confused by your statement. Maybe this would be a good time for a break.
All right.
In about 15
So-
more minutes. About 15 more minutes, we'll have a break.
All right, thank you. So let's try to move through this real quickly. Did it start going through different procedures, and what was the outcome of this contract? Did it ultimately go all the way, or did it stop somewhere along the way?
It stopped
The
along
approval
the way.
process. And where did it stop?
Mark Penley declined.
I don't know if she'll be able to get anywhere, but, you know, Godspeed, as they say.
And, when did you become aware that Mr. Penley would not sign it?
I don't recall the exact date. I recall there were conversations that when I signed it, it would go to Mark Penley next. I advised Jeff Mateer that that was going to be the next line in the sequence. I also advised Mark Penley that he was going to be next after I signed it. I don't recall exactly when Mark Penley declined to sign.
I think there are other documents that we can introduce later that would show that. We'll do it through other people. As to your involvement, Mr. Vassar, how would you view your role once you started sending out the drafts? Did you start having contact personally with Mr. Kamek, where he would have several different requests that you would communicate with him, or what?
I was the point of contact for Mr. Kamek just based on the introduction through General Paxton. After the internal approval process had started, I received a call from Mr. Kamek. I believe it was around the 13th of September.
What did he want?
I might do
He
a breakdown
asked if
on
there
it.
were any official documents or an official email address that we could give him.
Scientology will throw up
And at
every
some stage
obstacle in
along
the
line,
world
was
at
there
her.
inquiry about
It'll
whether
take
he
him.
was
It'll
going to
take him
have
3
inquiries
years to
by
get
him
anywhere, bare minimum.
as to where he was going to have credentials?
Probably longer than that by the time
sorry,
we're
could you say
done.
that?
Was he going to have credentials? Did that ever become an issue that would show that he was authorized to work on behalf of the AG's office?
No, sir.
Did you ever provide him any?
No, sir.
Did he ask you for any?
He did on that phone call.
And what did you tell him?
I told him that he didn't have a contract yet. I didn't understand why he needed credentials to identify himself as representing the agency.
All right. Were you aware, what was your level of awareness as to whether Mr. Kamek, or belief, was authorized to be speaking for the AG's office before this process was completed? What was your belief?
He had none. He had no authority to represent the office.
In your opinion, when would he have had authority to represent the office?
When?
Yes.
When he had a binding and executed contract.
And did he ever, to your knowledge, have a binding and executed contract?
Objection, Mr. President. This once again calls for a very important legal conclusion that goes to the heart of the matter.
I'm not asking him for a legal conclusion.
Yes, you are a little bit. Yeah, you kind of are a little bit, but
Witness can answer the question if you know of your own personal knowledge, not on hearsay.
you gonna ask the question again, or
On October 2nd, I believe Brandon Kamek sent a contract that appeared to be signed by General Paxton and Mr. Kamek himself.
Do you know when you first saw that?
I believe it was October 2nd.
Is that the first? Describe for us. Were you aware before, any time before that, that General Paxton had decided to sign the contract on behalf of the Attorney General's office?
No, sir.
Did you have any idea at that time when you saw it on October the 2nd, how and when that happened?
No, sir.
Did Mr. Paxton ever tell you that he had signed a contract personally with Mr. Kamek?
Yes, he did.
When did he tell you that?
I believe it was Friday in October, which may have been the 3rd. He emailed me and informed me that he had signed the contract with Kamek and that there had been a mistake in Jeff Matier's letter terminating the contract as an invalid agreement.
We need to jump ahead a little bit for this particular portion. You're aware, or you're not, that, well, let me ask you, do you recall what date you and a group of people went to the FBI to report your concerns?
September 30th.
All right. And are you aware then when y'all informed the Attorney General that you had done so?
October 1st is when we notified General Paxton.
And after you informed the Attorney General, did it sometime on either September the 30th or October 1, had Mr. Kamek been sent a cease and desist letter?
Yes.
And whom did he send a cease and desist by whom sent him a cease and desist letter?
I believe Mark Penley sent a letter to Mr. Kamek, and Jeff Matier sent a separate letter to Mr. Kamek.
And then separately was action taken in the courts concerning the subpoenas, grand jury subpoenas, that Mr. Kamek had obtained and was serving. Was there separate action undertaken by either Mr. Penley or Mr. Matier?
Mr. President, we object as to leading.
Are you aware of any? Excuse me. Are you aware of any action that had taken, personally aware of any action that was taken in the courts concerning the subpoenas that Mr. Kamek had been serving?
Mr. Penley moved to quash the subpoenas.
All right. And so then when you get a letter, did you get a letter from the Attorney General? And if so, what date that was, or text?
It was an email indicating to me that he had signed the contract with Brandon Kamek and that Jeff's letter telling Kamek to cease and desist was improperly sent.
All right. At that time, during that first week in October, when we got to October 3rd, what was your status with the agency?
I was still employed.
And had Mr. Matier resigned the day before, October 2nd?
October 2nd. I believe he resigned on Friday.
All right. When he resigned, had he sent a letter to Mr. Kamek before that, if you know?
Yes.
And at that time, were all of these actions being done with the involvement of each of you deputies that had been called colloquially the whistleblowers?
Yes.
Now, before that, when this contract, what was your involvement as far as the contract for Mr. Kamek once Mr. Penley refused to sign off on it? What happened then?
From what I recall, Mr. Matier and Mr. Penley sent a cease and desist. Mr. Kamek followed up to our agency mailbox, just the general mailbox, with invoices that he had purported to work under some authorization from General Paxton. Because we didn't have a record of a contract or a copy of a signed agreement, we informed Mr. Kamek that we could not pay him, and his response was that he had a signed
What date was that?
I believe it was October 1st.
All right. And during the time that you were going back and forth with Mr. Kamek about the contract, were you the person that was communicating with him?
He had emailed me directly, but the rest of the conversation was through the general mailbox that he is.
Did he send you an invoice seeking to be paid?
Yes.
Do you recall when he did that?
It was right around the same period, so it would have been October 1st.
And when he sent you an invoice to be asking to be paid, what was your response?
We informed him that we did not have a record of a contract under which to pay him.
And did you tell him you need a contract signed by somebody within the agency?
Well, we just told him we didn't have any contract with his name on it.
That had been signed by anybody?
Correct.
So what did he do?
He responded and said that he had a signed contract.
Do you recall what date he told you that he had a signed contract?
He provided it to us in the morning. I believe it was October 1st. Or no, I apologize. It was September 30th because we went and met with law enforcement on September 30th.
And did you get a contract from him that had been signed by the Attorney General before you went to law enforcement?
Yes.
Now, at the time this was all going on, were you willfully and totally involved in the actions that were decided and that led to you going to law enforcement?
Yes, sir.
Why did you go?
I formed a conclusion, just based on my good faith
Here,
belief,
keep it to the microphone.
that General Paxton was using the power and authority of his office to benefit a private individual.
And what was your opinion as to whether or not y'all had done everything you could to stop him before that?
Well, all of these sequences of events, ranging from May of 2020 to the foreclosure letter in late July and August of 2020, and the Kamek issue in August and September of 2020, in isolation were just activities that we tried to handle for General Paxton.
Mr. President, I'm sorry, I must object as non-responsive to the question.
Well, let me continue with
Sustained.
you. Yeah,
Re-ask the question.
Thank you. Now let me ask you this. What was your state of mind in terms of the degree that you, in your opinion, of the degree that you and others had engaged in to try to dissuade him from this conduct that you disagreed with?
We had repeatedly suggested that the positions that we were being asked to take were contrary to established law and policies. When we did that, he directed us to find a different way. So as lawyers do, we found alternatives, and those were the alternatives that he chose.
Well, then what was the tipping point about September the 29th or 30th that led you to decide to go en masse to the FBI?
Well, it became clear at that point that the degree and the extent to which General Paxton appeared to be using the office to benefit a single private individual, to target and harass law enforcement, rose to a level that, just based on our good faith belief, criminal activity had occurred. And under no circumstances did Brandon Kamek have any authority, either under a contract that was unsigned or a contract that was signed, or by some deputation by Travis County District Attorney's Office to serve as a special prosecutor for the Office of the Attorney General. So he was representing himself in a capacity that did not exist, and doing so for the benefit of a single individual.
Under those circumstances, did you feel that the Attorney General had any authority to appoint a, quote, special prosecutor?
No, sir.
Objection, Mr. President.
Did,
The objection is relevance. I don't believe that there is any contention on the part of the House Board of Managers that General Paxton appointed a special prosecutor. That is not the allegation.
Sustained.
Are you aware as to whether or not Mr. Kamek was going around and serving grand juries subpoenas claiming he was a special prosecutor of the Attorney General's office? Are you aware one way or the other as to whether he was doing that?
Objection, that would call for hearsay.
No, it doesn't call for hearsay.
Yes, it does.
This witness can be cross-examined about what the basis of his knowledge is, and then he can say whether it's solely hearsay.
Overruled it.
Thank you.
You may answer the question.
Yes, sir. I'm aware.
And in fact, was Brandon Kamek ever hired by the Attorney General's office, by anyone in the Attorney General's office, and designated a special prosecutor?
No, sir.
And in what is your opinion as to whether or not they even had the authority to hire a special prosecutor in this case under the facts that you knew him to be?
Objection, Mr. President. Lack of foundation, speculation, and relevance.
Sustained.
Mr. Vassar, was your concern if y'all did not go to the law enforcement on September the 30th of 2020?
Well, the concern was that it would only get worse. General Paxton's use of the office would only continue to be more extreme, to benefit Nate Paul, and the potential for us to be labeled as co-conspirators.
Yep.
How long did you remain with the Attorney General's office after October the 1st, 2020?
I was terminated November 17th, 2020,
And what was the stated reason for terminating you?
for disclosing confidential information outside the agency.
And did they describe to you or give you anything in writing to tell you what confidential information you were supposed to have disclosed?
No, sir.
Did you ask for a meeting to find out what it was?
I asked what it was, and they didn't provide a response.
Who replaced Mr. Mateer as the first assistant after Mr. Mateer resigned?
Brent Webster.
Is he still acting as the first assistant to your knowledge?
Yes.
Did you, without going into other conversations, did you seek to find out what confirmation or what information was being used to terminate you? And did you ever find out what it was?
Yes. I asked Mr. Webster what information I had allegedly disclosed outside the agency, and he didn't give a response.
To this day, do you know what confidential information you were supposed to have revealed?
I have not received a direct answer, but based on the agency's own internal whistleblower report, they've made allegations.
Finally, when you were terminated, how old were your children by then?
6 months to 4 years.
I believe you indicated, but I'm not sure I remember. How long did it take you to find another job?
6 months.
How did you live?
Just on savings that we had saved.
And when you took another job, where is it now?
Yeah, it's for a local nonprofit policy think tank here in Austin.
At the end of the day, in light of all that, and by the way, have you sued? Are you a whistleblower that has sued the Attorney General in the state of Texas?
Yes, sir.
Why did you sue?
Mainly for my family.
What do you mean?
Well, to take care of them financially, but also just to be a good example for them.
And what do you mean about a good example for them?
Just to stand up for the truth.
Okay, it's a little sappy.
You read this report that they put out back in 21?
Yes, sir.
You saw what it said about you?
Yes, sir.
You saw what it said about the others?
You got to be careful when you wrap
How would
yourself
you
in the
rate the
flag
level of
like that. It
accuracy
can
of the
come off
report
really
that
bad.
Mr. Webster says he primarily prepared.
I understand, by the way, he didn't literally wrap
On a
himself in the
scale of
flag. You
1 to
know
10,
exactly
I'd
what I
give it a
mean.
2.
Don't give me a hard time.
And was that report been out on the internet to the world at large?
Yes, sir.
All about you and the others being rogue employees?
Yes.
Is this the first time you've ever had an opportunity to tell your side since this all happened?
Yes, sir.
I've lost my screen completely.
You feel better or worse?
It's not fun.
I'll pass it.
My monitor crashed.
We'll break now until 5:25.
Are you guys there?
And members, there are some
I
snacks
can't see
back
you.
in the
I'm sad.
for you to get a little energized, and we'll come back for about another 60 to 90 minutes, depending on how it goes.
There you are. Yay, great. We're back. All right. So yeah, on substance, basically, he's testified kind of to similar things that other people have testified. Just another guy to say these things happened. with the contract, with the special treatment issues, the only benefit Mr. Paul, deviations in the procedure, escalating concerns, kind of similar concepts we've heard. His difference being, of course, he says he was fired improperly, so potentially some bias there, but some stuff here. So that's sort of just my generic thought. He doesn't really necessarily add anything to the picture by himself. He's just another person that can testify that these things happened. And so, like, in their combination, you got 3 different people who are telling me the same story, essentially. And all 3 are, like, credible, in my view. They all are reputable. They all are, First of all, I do have a bit of a high profession of. I have a reasonably, well, maybe I have a good perception of my profession, and so to the extent I have a bias, my bias is to credit members of my profession, perhaps. So maybe I do have a little bit of bias in that respect, and so when 3 members of my profession tell me that there's something, it's like I'm gonna give it a little bit more credit. I don't know if I'll give it more credit necessarily than you guys will. I'm just speaking to myself. So, all 3 people are telling me that there's a problem. And they all saw a problem. And they all saw the Attorney General acting in ways that were abnormal, all that seemed to benefit Mr. Paul, or at least were perceived to benefit Mr. Paul. And these weird contracts and these weird Attorney General opinions that were coming out, and the weird behavior by the Attorney General and stuff like that. So I feel like there's enough smoke here that's got my attention. So, and that's kind of what I think about it. There's something wrong here. So that's what I think. At the moment, of course, I'm still open-minded. But I'm at this point, I'm interested to hear what the counter is to some of this stuff. So. Yeah. Who elected them? No one elected them. What's your point? That has nothing to do with anything in terms of this issue. I don't know. What's your point? No one elected them. So what's your point? Apparently my computer screen just disappeared again. There it comes. Scientology leader David Miscavige finally considered served in a labor trafficking lawsuit after 27 times. So that's interesting, I guess. So that's fun. Anyways, I think we're going to cover this lawsuit at some point in the future, although this is taking priority. So at no point in the immediate future, but I think we're going to cover this lawsuit from, what's her name? Leah Remini, who is a somewhat famous former Scientologist. I saw her on Joe Rogan, for example. And apparently she's suing the Church of Scientology for harassment. And so I think we might cover that as time allows. So we'll do that probably, I don't know, like in a week, because we're going to be doing this for a while. And it's not going anywhere. So it'll take a while to get to, but I think we'll cover it. and try to assess it on its merits. Leah Remney. Yeah, so we'll try to cover it and see what it has. They're going to spend years in ecclesiastical issues trying to figure out what they can and can't do inside the court system. It's going to be a nightmare. So we'll cover that. Yeah, no, it'll take forever. It'll take forever. I noticed in this child trafficking suit, they're trying to say that they signed contracts that require them to go to the arbitration system. But didn't the Ninth Circuit say that those arbitration agreements were void, like relatively recently, in a comparable case? But I'm sure that'll be an issue too. So we'll try to assess it on its own terms. But they're going to spend years in freedom of religion hell trying to figure out what the hell's going on. And it's like, I don't know that it will matter to either like the anti-Scientologists or the pro-Scientologists, but I'll try as always to remain neutral, which I'm sure will be an entertaining, interesting thing. You know, can you imagine, like, my only fear in this, my only fear in covering it is, you know, I'm going to have to make an assessment, as I always do. I'm going to have to make an assessment. And there has to be some possibility, at least in the first instance, that Scientology might be at least legally right about something. And I'm going to have to say they are. And how's that going to work? And then I'm going to have to say Scientology is legally wrong about something. And how's that going to work? You know, with the accusations of the bias and the shilling and all the rest of it. You know? Because, yeah. You know? So I don't know how that's necessarily going to work out for that, but we'll see. I think they're on break for a while. Yeah, see, religious topics are best left to the corner pub, but I kind of want to do the same thing I did on Trump. See, like, this is where I shine, or at least where I think I shine, is like I can make it non-political. Because the Trump case is, to my mind, non-political. Because I can make it legal. I can make it a legal case, right? And I can treat it like a legal case, and I don't have to do politics. And I can just try to assess things legally and be like, okay, here's what I think legally. And it's like the fact that it's Trump, I can just treat it neutrally. So the fact that it's religion, I can just treat it neutrally. It's like, oh, it's just another thing. It's just another thing. Doesn't matter. Just treat it as another thing. It's just another thing. It doesn't matter. But I don't know if people respect that or not. Is it hot in Austin? Yeah, it's 105 degrees. They didn't take a 90-minute break. If they took a 90-minute break, they'd be done for the day. I wish. Matova says, how does Scientology count as a religion, not a cult? Well, at least as a matter of like U.S. law, there's no such concept as a cult. There's no such concept. If you're asking me, like, how does one qualify as a religion for, like, tax purposes, for federal tax purposes, that's outside my knowledge base. I don't know the answer to the question. But as a general proposition, U.S. law doesn't recognize a concept like cult because there's freedom of religion, period. So there's no There is no such thing as cults as a matter of law. So there's that. Yeah. Like a religion of one is in the first instance as valid as a religion of a billion. That's in the nature of freedom of religion, right? So there can't legally be such a concept as a cult. It doesn't make any sense. And as to like taxing issues, that's outside my knowledge base on how that works. So and at least some of what Scientology does is arguably done in other arguably mainstream religions. Like, you know, especially if you think about like Orthodox religions in particular, there's definitely some similarities in some of their aspects, and sort of like the control, the preference for religious courts over secular courts and stuff like that. Like, there's elements in particularly Orthodox religions where it's arguably comparable, at least in some aspects. Religious court thing is really dangerous. Well, you know, it only exists insofar as you choose to give it power. Like, that's like the whole thing. Like, it's to some degree voluntary, because religious courts only have power to the degree you give them power, as opposed to their more secular counterparts, which have power whether you give them or not. Like, you know, there's Orthodox Jewish courts. They have no power over me because I don't give them any power. So to some degree, it's voluntary. Like, you know, if you're an Orthodox woman, if you're an Orthodox Jewish woman and you want to get a divorce, you have to have your husband give you permission. It's called a get. If you can't get the get, you can't get divorced, as far as the church is concerned. And if you get divorced through the secular system anyway, they will shun you, which basically means that everyone in your community will, you know, refuse to do anything with you. But it only has power in so much as you care. You know, if you don't care, you know, then it doesn't matter. You know, the Orthodox Jews can shun me all they want. It doesn't matter to me. You know? So, I don't care. So, it's, to some degree, it's like they only have power because you give them power. So, there's that. For all I know, there's some Jewish court right now making rulings about uncivil law. It has not come to my attention. Yeah. Right up until the orthodoxy runs the town you reside in. Well, I mean, as a matter of law, if the orthodoxy truly runs the town, they still have to apply the law in a neutral way. So, they wouldn't be able to deny me any service if they're running the town in sort of an official governmental capacity, because they wouldn't be able to discriminate against me on the basis of my religion. So, there's that. Just, as a matter of law, as a matter of law, it doesn't matter if, the community is Christian or Muslim or Jewish or whatever. It's like they still have to do the same. Once you're the state, you have to be neutral. So it doesn't matter. Like, Scientology has no power over me. If they chose to harass me, that'd be illegal. I'm not sure how far that protects me in reality, but at least in principle. So, yeah. Isn't that what sophs say about regular courts? It sure is. You see, the difference is that the regular courts have people with the guns. Yeah, that is what the sophs say about the regular courts. It's just that the courts have power to execute their judgment in a very literal sense. So, you can choose not to recognize the courts; they can make you. It has been said before that one of the aspects of the state is that it has a monopoly on violence. Only the state can use violence as a coercive power. That's in the nature of the state. That is the state's special function, is that they have the authority to use violence in a coercive manner. So, take that for whatever value it has. Kestrel says, I have no idea. Don't make the claim. What claim was I making that I shouldn't make? What claim did I make that I shouldn't make? There's a reason Katie Holmes kept quiet until she was out the door and had her lawyer dad protecting her. I'm just saying, as a matter of law, what's true. Like, Scientology can break the law, and to the extent they are, they should be punished like anyone else. But I suppose that's why Remy is suing them, at least in part, because they're breaking the law. So, I don't know. Ruby Ridge and Waco are not great examples where the state acted in ways that were arguably messed up. Because the state can do things illegitimately too. So, I don't know. Keith says, $550. Here's for the Nashville Fund, and not booting me out of the chat. $10 from Bad Weather Biker. He's leading harder than your subscriber count is leading potentially criminal Sean's. Atlas Knife and Tool says, looking good, Kurt. Keep up the good work. Operation Snow White. I'm aware of Operation Snow White. I know what Scientology did. They broke the law. The IRS caved. In Florida, there's a fake town that Scientology built. Well, if it's a private town, then you get into interesting issues. If it's a private town, I don't know what happens at that point, because I suppose you could try to break out the old company town law and argue that the private town is also a governmental actor even though it's private. So, but I don't know how that works with respect to like more modern equivalents. I don't know if anyone's tried to use old company town law on like a perfectly private town set up in the modern era. It'd be interesting. For those of you who are unfamiliar with the concept, by the way, company towns were things that existed often in, I think it was principally like early 20th century. But there used to be like a company would discover a natural asset somewhere in the United States, like lumber or coal or whatever it would be, right? And the asset would be in the middle of absolutely nowhere. So the company has the coal or the lumber or whatever, but there's no workforce because no one lives there. So what the company would do is they would literally build a town. They would build a town and the people would live in the company's town. And they would work there and sleep there and eat there. And often the company would pay them in company money that could only be spent at the company store. And so like, you know, it was basically like, the company might charge them rent and the company store would, you know, only take company money and that was the only thing they were paid in. And so it would be like basically just the perpetually like self-feeding cycle. Right. And so there used to be so there was some case law dealing with this. The case law came up in the First Amendment arena, interestingly enough, because someone, I think, wanted to picket about the company town. And of course the company didn't want to let them because they were private streets. And the ultimate decision on the issue came down to be like, well, if you look like a government, if it looks like a duck and it quacks like a duck, you're a duck. So you look like a government, you act like a government, you have roads, you have stores, you have houses, you have banks, you have fire departments, you have police departments, you have this, you have this, you have this. You're a town. So they basically said, congratulations, you're now the government. And so therefore you're bound by all the constitutional guarantees that come along with it for the ride. So that's company towns. And that's some of that history. So you know, at some point we decided this was ridiculous. And it's like, okay, look, no, I'm sorry that, look, you say this is all your private property company. You say you own this all, right? They're our company. They paid, the police people are paid by our company wages. The fire people are paid by our company wages. You know, all the store owners are company. Everything's company. It's all private. And at some point we're like, yeah, no, this has got to stop. No, this has got to stop. Sorry, no. You're now the government. Congratulations. Act like the government. So, yeah. Stuff like that's interesting to me. I like history like that. I like things like that. I find stuff like that fascinating. I think law kicks ass.
Your witness.
Thank you, Mr. President. Mr. Vassar, my name is Mitch Little. I'm with the law firm of Sheaf and Stone, and I represent the elected Attorney General of Texas. We've much to discuss. I'm going to try to pick up a few crumbs here. The word that I heard at the end of your testimony was co-conspirators. Do you remember that word coming out of your mouth?
Yes, sir.
One of your concerns on September 30th was that if you didn't go to the FBI immediately, someone would think you were co-conspirators with the elected Attorney General in this state, right?
That was one of the concerns, yes, sir.
And your attorney that you hired before you went to the FBI is a man named Johnny Sutton, correct?
That's right.
And he's here today, correct?
He is.
And he's sitting in this courtroom, yes?
Yes, sir.
Would you indicate him for us?
It's right there.
Yes. And he represented a number of you employees at the Attorney General's office, correct?
Yes, sir.
And by the time that you went to the FBI, Mr. Vassar, just tell these senators, did you know who performed the home repairs and renovations at the Paxton's home?
No, I had no direct knowledge.
You didn't have any indirect knowledge, did you?
It was discussed when all of the events came together and we met as deputies on September 29th. That was mentioned as one of the potential concerns of bribery of the Attorney General.
Who mentioned it?
Based on my recollection, it may have been Mr. Brickman.
And Mr. Brinkman heard it where?
I'm not sure.
He heard it from someone else, correct?
I'm not sure.
You don't know.
I don't know where he heard it.
But one of the criminal complaints that you and your group of people who went to the FBI alleged was that the Paxton's home was being renovated at the cost of someone who was under federal investigation, correct?
He's allowed to lead. He's on
One of
cross.
the criminal complaints. I'm not, we did a verbal complaint
Yes.
at the office, but I'm not sure.
Let me be clearer. One of the things that you told the FBI in your meeting with them was that you were
Everyone
concerned
hired
that
Johnny.
someone
Conflict
else
of
was
interest?
paying
No,
for
not
the home
necessarily.
renovations
As long as their
at the
interests
Paxton's
are
home,
not
correct?
adverse to each other,
Me
no.
individually,
It's
I
not
have no
uncommon
knowledge,
for
but
one
yes,
lawyer to
in the
represent
meeting
a
with
bunch
the
of people with
FBI,
similar
all of us present.
situations.
There was a roundtable
So no, there's
discussion
nothing inherently
about
improper about the lawyer
some
representing
individuals'
all
good
them.
faith belief that
You know, as long as their
the Attorney
interests
General
are
was
not in
involved
conflict, and
bribery.
they don't appear to be.
Faith belief based on what?
I'm not sure. It wasn't my direct knowledge.
You were in the meeting.
Yes, I was in the meeting.
Can I
with
point to the
FBI,
camera?
But
What was the basis?
I'm not sure. I think it was redoing the kitchen countertops.
Redoing the kitchen countertops? Is that what you heard?
I'm just giving you the context of what I recall.
Did you see any documents exchanged with the FBI in this meeting?
No, sir.
Not one.
No, we did not provide any documents to the FBI.
And let me be clear, because I think your testimony was a little bit confusing, at least to me. It may have been to the senators as well. But you learned about Brandon Kamak's signed contract with the Attorney General after you reported the Attorney General to the FBI, correct?
I think that's correct, yes.
So when you went to the FBI and you told presumably some FBI agents that Brandon Kamak was out serving grand jury subpoenas without authority, you did not know that that man had a signed contract with the Attorney General of this state's signature affixed to it, correct?
That's my recollection.
Well, surely when you found out, you went straight back to the FBI and told them, right?
No, I mean, at the time
No?
we were represented by Mr. Sutton.
Surely at that time, Mr. Sutton asked you to go back to the FBI and correct that misinformation, correct?
What misinformation? That Mr. Kamak had a contract?
Yes, he had a signed contract affixed with the signature of the elected Attorney General of this
Thank you
state.
for the $10 super chat.
Yes, based on what he had provided to us was a signed contract, and General Paxton had confirmed to us that he had signed a contract.
And you had it in hand, correct?
Yes.
And surely your lawyer said, guys, we need to go back to the FBI and tell them that there's a signed contract with the affixed signature of the elected Attorney General of this state, right?
There wouldn't have been any reason to provide them with a signed contract because that wasn't part of the complaint that we had filed with the FBI.
Part of the complaint, let's be clear about the complaint, okay? Part of the complaint to the FBI was that Brandon Kamak was out serving grand jury subpoenas to support someone else's agenda besides the people of the state of Texas. True?
Yes.
And at some point after your meeting with the FBI, you discovered from Brandon Kamak that he had a signed contract with the elected Attorney General, correct?
That's absolutely true, for nothing that he was doing.
And I'll object to the non-responsive portion of the question or answer and move to strike, Your Honor.
Strike the last comment.
Now, let's be clear about something else. After this contract that was signed by the Attorney General of the state of Texas, Ken Paxton, he had the authority to enter into it, correct?
Yes, I believe he did.
And that's because over 4 million voters in this state gave him that authority, correct?
Yes.
And that authority exists to bind this state. And if the voters don't like it, they can vote in someone else, correct?
That's, yes, how the political system works.
That's my understanding as well. At what point in time did you come back to the FBI and say, well, maybe there was some authority for Brandon Kamak to do what he was doing? Did you ever do that?
No, sir. And just because
Object non-responsive to anything after no, sir, Mr. President.
Fair enough. Sustained.
Please keep your answers to the questions.
In your meeting with the FBI, did you tell the FBI that Ken Paxton had illegally disclosed some confidential material to someone?
we filed a complaint based on activity that we had formed a reasonable belief that...
Mr. President, I will object at this time as non-responsive.
Sustained.
Madam Court Reporter, would you mind reading my question back? I should have a... I'm sorry, I don't have one.
I do like the fact that he's under... He is in control, and he's like, I do appreciate his control, and he's like, this is the question.
Yes or no?
I disagree with the phrasing of the question.
It's a very simple question. Did you tell the FBI in this meeting, did someone in this meeting tell the FBI that Ken Paxton had illegally disclosed some confidential information to someone? Yes or no?
In the meeting, we alleged, based on a reasonable belief, that that activity could have occurred, but we were not investigators. That was what law enforcement was for.
That's right. And Mr. Vassar, I want to see us on this point. You're a lawyer and you're doing some, I mean, you have very good command of the language. You had a good faith belief in certain information, but you didn't know that Ken Paxton had disclosed anything to anyone when you made this report to the FBI, did you?
No.
You were hoping the FBI would sort it out for you and not think that you were co-conspirators with him, correct?
No. The purpose of the complaint to the FBI was because we had formed a belief in good faith that the Attorney General was involved in criminal activity.
This is something that I keep hearing over and over again. We formed a good, let me make sure I get it right, formed a good faith belief that the Attorney General of this state was engaged in illegal activity. Did I say that right?
That's accurate.
But you didn't know, right?
Well,
you didn't know, right?
That's the point of the good faith belief, is we had no evidence that we could point to, but we had reasonable conclusions that we could draw.
You went to the FBI and reported the Attorney General of this state with no evidence. Do I have that correct?
We reported the facts to the FBI.
That's not my question. You had no evidence that Ken Paxton had done anything illegal. Did you?
Your Honor, it's not necessary to yell at this witness. I suggest it's disrespectful, and I request he quit doing it.
I apologize. Let me do this again at a lower volume. Madam Court Reporter, would you read my question back for me, please, at an appropriate volume?
I like the snark. I do like the snark. That's nice. At appropriate volume. I like that. That's good.
Yes?
Repeat that, so because they could not hear her on the microphone.
Yes, Mr. President, I will. Watching the live stream over there? Hold on. Let me ask this question again. Let me get this straight. You went to the FBI and reported him for potential crimes without any evidence. Do I have that correct?
We went to the FBI and reported...
Please answer my question, yes or no.
Our belief that criminal activity had occurred.
That was not my question.
Witness needs to answer the question, yes or no.
Did I ask it again, Mr. Vassar?
Please.
I want to get this straight. You went to the FBI on September 30th with your compatriots and reported the elected Attorney General of this state for a crime without any evidence. Yes?
That's right. We took no evidence.
Good. See, he got good control. He insisted on the question being answered.
gain any
He
after
managed to
that?
get an answer. Good job.
Did you gain any after that?
Well, we weren't collecting evidence.
Did you gain any after that?
Evidence of what, sir? Of
Evidence of a crime committed by the elected Attorney General in this state, elected by over 4 million voters. That guy.
I don't recall if we had collected any evidence.
Don't you think that's something that you should be able to recall, sir?
Well, when we presented ourselves to the FBI, we did so as witnesses, not as investigators to collect evidence.
Did so as complainants, hoping that you would not be named as co-conspirators, true? You made a complaint, yes?
Yes, it was.
Without any evidence, yes?
No.
I'm sorry?
Again, these are our good faith beliefs that a crime had occurred.
Respectfully, sir, we are not here in this historic event for your good faith beliefs. So if you could just tell these senators who are taking up their time and all of Texas's time with this impeachment.
Excuse me. These sidebar testifying comments are an inappropriate form of cross. If you just asked a question, I have no objection.
I will throttle it down. I withdraw it.
Pull that back.
Yes.
Ask a question.
Mr. Vassar.
He's definitely a bit of a showman. I don't necessarily object.
Did you?
I mean,
gain
in a
any
practical
evidence
sense.
after you went to the FBI?
I'm not sure what evidence that I can recall.
You had a good faith belief. We've heard those words a lot in this trial, a good faith belief, but without any evidence, correct?
The evidence that we provided.
Why didn't you talk to Ken Paxton? I'm sorry.
Please let him finish his answer.
Overruled. He was finished.
Mr. Vassar, when you worked for Ken Paxton, was he gentle?
As far as I knew, yes,
Be
sir.
kind?
Yes, sir.
He ever yell at you, scream at you?
No, sir.
Don't you think you owed him the courtesy of at least a phone call before you reported a man to the FBI without a shred of evidence?
Well, that's not how the reporting structure worked.
Oh, please tell these senators how it works.
Well, all of my interactions were directly with Jeff Mateer and Ryan Bangert. General Paxton would call me with questions like the open records issue or the foreclosure letter, or I'm sorry, not the foreclosure letter, that was through Ryan Bangert, outside counsel. So every other instance was my weekly meetings with Jeff Mateer and Ryan Bangert. And I never called the Attorney General. He always called me.
I appreciate your answer, but that was not really what I asked. So let me try again. Don't you think you owed the Attorney General of the state of Texas at least a phone call before you reported him to the FBI without any evidence? Yes or no? That's not the way it worked? Yes or no?
Would you like me to answer?
Yes, I would.
Based on our conversations with Mr. Mateer and Mr. Bangert, they were having conversations directly.
Yeah, now he's coming off as
I was not
evasive.
part of those conversations. So
He's coming
any
off as
concerns
evasive,
they had
in my
raised
view.
with him would have been in their conversations. I had no reason to call him directly.
Object non-responsive.
Yeah.
Sustain.
Let me try this again, Mr. Vassar. Don't you think you personally, Ryan Vassar, don't you think you owed the Attorney General of the state of Texas, elected by over 4 million voters, a phone call before you reported him to the FBI without any evidence, sir?
I was appalled at the time. So
Object non-responsive.
Sustain.
I object to the continued interruption of the answer. If he doesn't like the answers he's getting, he can then object to it being non-responsive. But jumping in the middle of this, man, is totally unfair, and I object.
I will listen more closely, Counselor. I have not heard him interrupt him. I will listen more closely so the witness can finish his answer and you can do a follow-up question.
Thank you. Can we go
That
back to my
objection's
question?
overruled.
Thank you. May I go back to my question, Mr. Vassar? My question was, don't you think you personally owed Attorney General Ken Paxton, elected by over 4 million voters, a phone call before you reported him to the FBI without any evidence? Yes or no? No, I don't? Yes, I do.
Well, I would disagree that we didn't have any evidence just based on our beliefs, but I don't think I owed General Paxton anything.
Nice.
You don't? You worked for him for 5 years.
That's right, and I believed in him.
He gave you a job, correct?
He did. And promotion.
And a promotion, huh? Not enough to warrant a phone call before you report him to the FBI, though. True?
Yeah.
Like I said,
Do you wish you could go back and call him?
I'm sorry,
Do you wish you could go back in time and call Ken Paxton and talk to him before you reported him to the FBI without any evidence?
I wouldn't do anything else differently.
Interesting. Okay.
Good job. This is
You don't
good.
know anything about Ken Paxton's campaign donations from 2018, do you?
No, sir, I don't.
Yeah. So
didn't work
like,
with the Mitty
I don't know if it
Foundation
was the
case,
other
did you?
attorney
No, sir.
in what questions he
When you
was
went to the
asking or
FBI,
something, but
did you
like
have Ken
in the witness
Paxton's
before
phone
this,
at
when
least?
the
Did you
attorney
call him
was
on his cell phone?
basically
Yes or no?
trying to,
I believe I
you
have
know,
his
the
phone
answer,
number
the answers
in
I
my
didn't find it
phone.
evasive.
Yes, sir.
But this guy's answers seem evasive.
I think he gave it to me.
You know, to me, the other guy didn't seem like he was trying to dodge the
Based
question.
on
This guy seems like he's trying to
Working
dodge
with
the
him
question.
and questions that he would call me with.
So you could call him if you needed something, so he could call you if you needed something, right?
That could be an option, just based on a cell phone use.
You even had his secret email address, didn't you?
I'm not sure which one is.
Well, there is an email that's already entered into evidence in this case. It's ag.wkp@protonmail.com. Have you seen it?
Yes.
He gave it to you, right?
Yes.
Did you email him on his secret email address? Tell him that you were going to go and report him to the FBI without any evidence?
No, sir.
Why not?
It didn't occur to me.
Didn't occur to you. At some point since then, has it occurred to you that maybe you should have done that?
No, sir.
How secret could this email address have really been, Mr. Vassar, if you had it?
I don't know exactly.
Do you consider yourself a close confidant of the Attorney General?
No, sir.
Do you think you're the only person that had that email address?
I have no reason to believe that I was the only one.
So this gentle, kind man, was he attentive to your concerns when you talked to him in the office? Talked to him on the phone?
Sure.
Gentle, he's kind, he's attentive. And at what point in time did the weight of what you were doing in reporting this gentle, kind, attentive man to the FBI become apparent to you?
Ooh.
On September 29th.
When you walked in there?
Walked in where?
To the FBI.
No, that was September 30th.
Okay. So what happened on September 29th when the great weight of having to report this gentle, kind, attentive boss?
Right, because he got him to accept the premise of all these things earlier, that he's good, kind,
September
gentle,
29th, that was
attentive.
in
So
a
he can
meeting,
just keep using the descriptors over and
division
over and
meeting
over.
with
He got him to buy the premise.
And we
Nice.
she received
Nice
a text message
job.
on her phone.
You put the words in the witness's mouth, and now you get to
that I
use
did not
them forever.
recognize. And the individual asked if a Brandon Kamek was working for our office.
And you knew exactly who that was, didn't you?
Yes, I recognized the name.
And what happened in your mind was you realized this contract didn't work its way all the way through the executive action memorandum process. True?
Among other things, yes. That's a thought that went through my mind.
Yes. And the rest of that thought is, if that process has not been completed, he has no authority to work on behalf of the Office of the Attorney General, correct?
Yes.
And that was alarming to you, true?
In addition to the fact that he was acting in a capacity that he didn't have, even if a contract had existed at the time.
And in that moment, did you call General Paxton and say, Brandon Kamak's working, what's going on?
No, sir.
Do you think it's possible? Is there room in your mind for the possibility that if you had called Ken Paxton and told him that information, Ken Paxton would have said, yeah, Ryan, I signed the contract with my own hand, with my own pen. Is there room in your mind for the possibility that that would have happened?
Well, it is possible, but he was out of the state at that time, so I wouldn't have been connected to him or had a reason to call him.
You had his phone number. So what if he was out of the state? Cell phone works out of the state, surely, right?
Yes, sir.
You didn't think to call him?
Well, as I explained, because he was out of state, Jeff Mateer was running the office.
That's another thing we're going to get to, okay? My understanding is your belief was that while Ken Paxton was in Ohio working on the Google case, the biggest case that the Office of the Attorney General had, Jeff Mateer was the acting Attorney General, right?
That's correct, although my understanding, in addition to
the object is non-responsive to the remainder of this answer.
Sustained.
Mr. Vassar, can it possibly be in a state with as many millions of people as Texas has, that it is the belief of the upper echelon of the Attorney General's office that any time the Attorney General gets on the plane, Jeff Mateer is the real Attorney General?
Only to the extent the government code is triggered. That's what deputizes the first assistant to act under the authority of the Attorney General.
And your belief was that on September 29th and 30th, when Ken Paxton was in Ohio doing business on behalf of the people of the great state of Texas, litigation business, very important litigation business, that someone else was the Attorney General, and that's what the government code says. Is that right?
Well, it was my understanding it was a political event. It was a campaign event. I had no knowledge that he was working on the Google case.
He was doing a campaign event in Ohio?
That was my understanding at the time.
Where on earth did you get that?
Just conversations at the time with Mr. Mateer.
So if he was on, let's say he was in Ohio on a campaign event, Jeff Mateer's the Attorney General while he's there?
I was just clarifying my understanding based on your question. Your next question of whether Jeff Mateer is the acting Attorney General, again, that would depend on the statute. The statute provides if the Attorney General is absent or unable to act, the first assistant shall perform the duties.
Tell the senators what absent means.
The statute doesn't define it.
Tell me what you think it means.
Well,
Yep, Matthew, that's basically it. The AG's out of state, he's abandoned his
meaning
post.
of the word under a statutory interpretation approach.
Tell these senators, many of whom are very accomplished attorneys, what the word absent means to your understanding, please.
I am not advised of what the dictionary definition would be. That would be an interpretive guide. Absent could mean out of state. Absent or unable to act could mean incapacitated.
Like if Ken Paxton was on life support in a hospital somewhere, for example.
I presume so.
But he wasn't. He was in Ohio, which I guess is debatable one way or the other.
I'm not aware if that statute has ever been interpreted by a court, so I could not be able to say.
But in any event, it provides the perfect cover for someone in your office to remove Ken Paxton's name for the letterhead and begin sending out letters on behalf of the Attorney General of the state of Texas. True?
No, nobody removed his name from letterhead.
You don't think so?
No, sir.
Have you ever seen Attorney General's office letterhead without Ken Paxton's name on it?
All the time.
All the time.
Yes, sir.
How did correspondence in September of 2020 come to be sent to parties outside of the Attorney General's office without Ken Paxton's name on it? Tell us.
Well, the agency has different letterhead. There probably even today, letterhead that's available on the Attorney General's website that does not have his name on it.
So,
letterhead that he signed.
I see. So when the Attorney General is absent in Ohio, someone at the office goes, grab me the letterhead without Ken Paxton's name on it. He's in Ohio today. Is that right?
I don't recall any decision about using this letterhead or who instructed the use of the letterhead.
No one decided, it just happened, right?
Like I said, I don't recall any decision about it. The agency has different letterhead that exists today.
You're familiar with the Mitty Foundation now, right?
I've heard of it, yes, but
You've been an attorney how long?
I was licensed in 2012, so 11 years.
You said your family goes to a Baptist church, right?
Yes, sir.
Okay, that Baptist church is organized as a nonprofit, right?
Yes, sir.
And at some point in time, I'm sure you've given money to a charity, correct?
Yes, sir.
I gotta ask you something that's just been really bothering me, and I know I'm not the only one. What in the heck is a charity doing making a multi-million-dollar private equity investment with Nate Paul with charitable funds? Any thoughts on that?
I'm not sure. I don't know.
You ever ask anybody?
No, I was not involved in the Mitty case, was never consulted on it or provided any advice for it.
Do you know, maybe you do you know of any charities that make multi-million-dollar private equity real estate deals with charitable funds?
I have no personal knowledge.
The Mormons?
Do you recall giving testimony to the House Board of Managers and being questioned on video by Aaron Epley, Brian Binkin, and Therese Buse?
Yes, sir, I remember.
But they never put you under oath, did they?
Not that I recall.
Did that kind of surprise you?
I didn't think anything of it.
Did you ask why not?
I don't know. I don't think I did.
Well, just because you weren't, well, you are an attorney, obviously. Just because you weren't under oath doesn't mean that you didn't tell them the truth, the whole truth, and nothing but the truth, so help you God, true?
That's right.
Did you review your statement in preparation for this historic trial?
No, I consulted with my attorneys, and that was it.
Did anyone give you a copy of it?
A copy of my statement?
Your statement, yes.
No, sir.
So anything that you said in that testimony, I guess we can call it testimony, anything you said in that testimony that's recorded, we can take as the gospel truth, right? Yes?
Just based on my telling the truth, is that what you're asking?
Yes.
Yes, sir.
We can take it as being true, yes?
Yes, sir.
Okay. Have you ever, before today, have you ever in your life been asked to give testimony as a witness without being sworn?
I don't recall. I've been a resource witness to many Senate and committee hearings, but I don't recall if there's an oath administered to a resource witness, so I apologize.
Have you ever given sworn testimony anywhere before today?
No, I don't think so.
It's a tough first outing, isn't it? Mr. Arroyo, if you would, Article 1 of impeachment, please.
This guy's very good at cross, too. He has a very different style than the other one who was really good, but he's good in his own right, too, and I like him.
Can you see Article 1 on your screen, sir?
Yes, sir.
You don't know anything about this, do you?
No, this would be the Mitty Foundation matter.
And just to be clear, have you looked at Chapter 123 of the Property Code to determine what the Office of the Attorney General's obligations are with regard to charities in this state?
No, sir.
Don't know anything about that, do you?
No, sir.
All right. Mr. Arroyo, Article 2, if you would.
He's got good command, good control. I do really like the way that he's getting the
Mr.
witness to
Vassar,
answer his questions.
Given some testimony
As like,
about
we can keep
what
doing
we'll
this until you
call
answer my
the
question.
foreclosure opinion, right? There was
It's
issued
not
August
asked and
1,
answered until you actually answer. So it's like,
issued
we can
August
keep
1,
doing this,
2020.
but I'm going to keep
Yes.
objecting,
Yes, I believe
non-responsive
that's
until I
right.
get an
It's a
answer.
Sunday.
That opinion was not a legal opinion under subchapter C, chapter 402 of the government code, was it?
Yes, it was a legal opinion under subchapter 402.
It was?
Yes, sir.
That's not what you told the House Board of Managers. What did you tell them?
I don't recall.
We'll get to that later, but that's not what you told them, is it?
I don't recall. I may have misstated.
You may have misstated.
If you're saying that's not what I said, and my testimony today is that there's no other statutory authority except for Chapter 418 of the Disaster Act to issue a legal authority, to issue a legal opinion by the Office of the Attorney General. So it either has to be Chapter 402 or it has to be Chapter 418.
But we know this is not 402 because it says on the face of the foreclosure opinion that it is not under 402, correct?
It does say that it's not, but that doesn't mean it doesn't fall under the authority of that chapter. It just means it wasn't written in accordance with the typical legal opinion process.
I was
Good
hoping
luck.
we would be able to have a chance to discuss this. Mr. Arroyo, please bring up section 402.042 of the Texas Government Code.
Going to sell that proposition? It doesn't mean it wasn't under that authority. It just means it didn't go through the normal process, although it's not what it says. It says not under authority. I mean, that's a rough road to hoe, baby. That's a rough road to hoe. You're trying to go directly against the black and white text of what the document says and be like, well, even though it literally says it in exactly those words, that's not what it means. What it really meant is we didn't go through the normal process.
No, we're looking for 042. That's
Woof.
212. We'll get to that later. Thank you.
I mean, I do appreciate as a person who misspeaks from time to time or is slightly imprecise in their wording from time to time, that sometimes what I say isn't exactly what I mean and I might have made a wrong word choice or something. But damn.
Mr. Vassar, certain criteria need to be met. Is that correct?
I believe so.
There first needs to be an authorized requester, correct?
That's correct.
Who are the types of persons who are authorized to make that request?
The governor, the lieutenant governor, the speaker, chairman and chair people of committees of the House and of the Senate, executive heads of agencies, and county and district attorneys.
Did any of those people request the foreclosure opinion?
Yes, sir.
Okay. What is the next criteria to satisfy for Chapter 402 of the Government Code?
You're going to have to refresh my recollection.
All right, Mr. Arroyo, if you would move to the second page of that PDF that you just had up.
He's going to go through line by line to see whether it does or does not meet the statutory criteria. Good for you, right? Because his claim is it does meet the statutory criteria. So he's going to go through line and say whether it meets the statute or
highlight
not.
the text at the top, that big chunk of text there. A little bit lower. Thank you so much, and just blow that up for us. Let's look at item C, okay? You're a lawyer. We can read this together, right? Right?
Yes, sir.
It says a request for an opinion must be in writing and sent by certified or registered mail with return receipt requested, addressed to the office of the Attorney General in Austin, or electronically to an email address designated by the Attorney General for the purpose of receiving requests for opinions under this section. Did I read that correctly?
Yes, sir.
That didn't happen with the foreclosure opinion, did it?
I'm not advised if it did.
You were in charge of the section. Is there anybody who has more knowledge about this than you, perhaps?
I don't have access to the email box that it would have been received at. So I'm not aware of how it was delivered, if it was delivered by electronic mail.
Can you tell the senators whether the criteria of section 402.042C were satisfied? Yes or no?
I'm not sure. I don't recall.
And that you were in charge, right?
Yes, sir.
Ooh, yeah.
Subsection D allows...
Seems kind of, I'm not talking about subsection D. We're not there yet. Seems kind of important to know whether this satisfies the criteria for the Attorney General to provide formal legal advice. Yes?
Yes, sir.
But you told the House Board of Managers this foreclosure opinion was not formal legal advice, correct?
That's correct.
It was not formal legal advice. It was informal guidance. True?
I believe so.
And during COVID, the Office of the Attorney General was dispensing informal legal advice related to COVID almost every day. Was it not?
It was very frequently. I don't know if it was every day, but
Were you writing the opinions?
some of them, yes.
People who are working for you were writing the opinions as well. Yes?
Yes.
And there were all kinds of COVID opinions coming out almost every day, informal legal guidance from the Office of the Attorney General that did not satisfy the criteria of Chapter 402 of the Government Code. True?
I'm not sure about that. A lot of the things that you're referring to about the daily stuff would have come through Chapter 418, which is the Disaster Council legal function. Those would have come from county mayors or city mayors, county judges, and emergency management directors. Those were coming more frequently than the other ones.
Well, let's build two boxes. In this box, we have Chapter 402, formal legal advice, correct? Okay? So in this box, we place formal legal opinions from the Office of the Attorney General that satisfy the criteria of 402.042. Yes?
Sure.
And it's assigned a KP number, correct?
That's right.
And it's published in the formal opinions section of the office's website, correct?
That's right.
And to be clear, for the ladies and gentlemen of this jury, the foreclosure opinion did not satisfy anything in that box, correct?
No, that's why it was flagged as not a formal legal opinion.
It's in the 418 box. Because at that point in time, the governor of this state had decided to empower the Attorney General to give the people of Texas guidance more freely about what's going on during COVID, true?
That's not true.
It's not true?
That's correct. It is not true.
How did the Attorney General get the ability to give people informal legal advice under Chapter 418 of the Government Code?
It wasn't from the governor. The legislature enacted a statute that the governor signed, giving the Attorney General the power to advise three categories of people: county judges, city mayors, and emergency management directors.
I apologize for my imprecision. So at this point in time, these people, the legislature, at least in part, had empowered the Attorney General to give informal legal guidance more freely, true?
To select people, yes, that's true.
Yes. How select were they?
It's the three categories of people: county judges, city mayors, and emergency management directors under the Disaster Act.
There were people on the House Board of Managers who were requesting informal legal guidance relative to COVID, weren't there?
But that wouldn't have triggered Chapter 418. The only other express statutory authority for a legal opinion is 402.
But if it doesn't have a KP number and it doesn't satisfy the criteria of 402.042, it's not formal legal advice, correct?
That's correct. It's not a formal piece of advice. It's an informal piece of advice under Chapter 402.
One of the things that had to do with your termination, I believe, is you're voluntarily sending secret grand jury subpoenas outside of the Office of the Attorney General to someone who is not authorized to receive them. Do you understand that?
That's never been stated to me, but that's my understanding based on the OAG's whistleblower report.
Well, you don't have to wait for the OAG to tell you that. You know you did it, right?
I only sent copies of records to my private lawyer. I did not send them to any member of the public or disclose them to the public outside of the agency.
Was Johnny Sutton authorized to receive secret grand jury subpoenas from Travis County? Yes or no?
Well, on their face, they weren't valid. Brandon Kamek had no contract. He was not a special prosecutor. He had no authority to request them or to obtain them.
Mark Penley thought they were valid enough to quash and to get a judge to sign an order to quash them, didn't he?
Well, because they were issued.
They were issued. And when they were issued, they were secret, true? True?
I guess unless they were invalidly obtained under false pretenses.
Are you aware of some type of exception that allows you to send secret grand jury subpoenas to your lawyer?
Well, I thought sending it to my lawyer for purposes of legal advice would be permissible. I'm not a...
Did you check and ask Mr. Sutton whether he represented any of the subpoena recipients before you sent them to him?
Yes, in our conversation for him to represent us, we discussed whether he was able to do so.
And after you sent those grand jury subpoenas to your lawyer, copying the rest of the so-called whistleblowers, you deleted that email from your inbox. True?
That's right.
Ooh.
I think you will probably recall at some point in your 5 years of employment at the Office of the Attorney General receiving some type of training in document preservation. Yes?
Yes.
And what types of training did you receive? Please tell the ladies and gentlemen of this jury.
I believe it's an annual information security training. There's annual sexual harassment training. So there's a variety of required annual trainings that employees of the office are required to complete.
In a second, I'm going to ask you, well, let me ask you now. You are not allowed to delete official records of the Attorney General's office. True?
Official records, no. That's right. Unless...
in a second, I'm going to ask you whether you deleted emails from your computer that should have been preserved as official records. Do you want to consult with your criminal attorney first?
No, sir.
Did you delete official email records of the Office of the Attorney General, sir?
I deleted emails to my personal attorney under the agency's own information security policy that's provided to every employee that personal messages of a de minimis nature are allowed on agency devices, provided that those messages are deleted to prevent archival. Because I made a determination that I emailed Johnny Sutton in my personal capacity with copies of records, not records that had to be maintained on an agency device, but copies of records that existed in the office. I deleted
this qualifies as
the
de
personal
minimis
message to Johnny Sutton.
Okay.
It seems, Mr. Vassar, that one of the things you are accusing Ken Paxton of doing is by allowing people outside of the Office of the Attorney General to see secret things they should not see. Do I have that correct?
No, sir. Mr. Sutton was my personal lawyer.
No, that wasn't my question. Let me try again. Listen to my question. One of the things that you are accusing Ken Paxton of doing is forwarding secret information of the Office of the Attorney General to people who should not have it. Yes?
That is a suspicion.
You don't even have enough to make an accusation. You suspect that it occurred, right?
Yes, sir.
But that's what you did, isn't it?
No, I forwarded it to my personal lawyer for purposes of legal advice.
And you think that protects you somehow?
Well, if any ordinary person gets a subpoena, I imagine their first call is to their lawyer who reviews the subpoena.
In preparing the foreclosure opinion, Ken Paxton didn't direct you. Ryan Bangert did, yes?
Yes, sir.
And Ken Paxton didn't direct Austin Kinghorn. You did,
That's
correct? If you would, Mr. Arroyo, please bring up Article 2.
So that's less than fully great. It's not ideal. Yeah. It's not
true.
great.
Is it?
Is there a specific part that you'd like me to review, or?
Read it all. Ken Paxton is innocent of this allegation, isn't he?
So the first provision of the second sentence, this is Article 2 of the Articles of Impeachment. Paxton caused employees of his office to prepare an opinion.
Hold on a second. I don't want you to read it out loud.
Okay.
We don't need to waste the jury's time doing that.
Sure.
They can read. Many of them are skilled attorneys themselves. This article is not true, is it?
Well, it is true that he caused employees of his office to prepare an opinion in an attempt to avoid the impending foreclosure of properties.
But you don't know whether those properties belong to Nate Paul or business entities controlled by Nate Paul, do you? You don't know that.
Nothing other than what's been reported in the media.
You don't know that what's been reported in the media. Have you ever heard the phrase self-licking ice cream cone before?
No, you got me on that one too.
Let me explain to you what a self-licking ice cream cone is, Mr. Vassar. A self-licking ice cream cone is when a bunch of employees at the Attorney General's office begin to suspect their boss. They read it in the media. They believe what the media says. They report it to the FBI. And then the media reports that you went to the FBI. That's a self-licking ice cream cone. Are you familiar with the expression now?
Still no.
Based on your description, yes, sir.
I have to say that
You don't
no.
know whether this article is
You
true
got me
or
on that one too. I've not heard the phrase self-licking ice cream cone.
Mr. Arroyo, Article 3, if you will.
We're learning all kinds of new fun phrases over here on Uncivil
Thank you.
Law.
You weren't directed to act in contravention or contrary to the law, were you?
No, sir. General Paxton.
Object not responsive to anything after no, sir, Mr. President.
Sustained.
You think that your decision with regard to any open records request that was made by anyone was improper?
No, sir.
It wasn't, was it?
No. Everything that we did in a way that we could find a way to make it lawful, because we wouldn't have participated otherwise.
You did it by the book, correct?
Yes, sir.
You wouldn't do it any other way, would you?
That's right.
Yep, that's
Mr.
the
Arroyo,
answer you wanted.
Article 4, if you will.
You did it by the book. You wouldn't do it any other way. Woof. You know, yeah.
Can you see Article 4, Mr. Vassar?
Yes, sir.
Ken Paxton didn't improperly access anything in his office that you're aware of, did he?
No, not that I'm aware of.
And if he wanted to ask for a file, he could do that anytime he pleased, couldn't he?
Sure.
Because that's what 4.2 million voters elected him to do. True?
Yes,
To
that's
access whatever file the heck he wants. Yes?
true.
Article 5, please.
Ugh. I do like the light purple tie. I agree. We'll call it like a light plum. It's nice.
We know that Ken Paxton's innocent of this article, right? Right?
I'm not even. I don't recall the distinction about an attorney pro tem. I used to know it, but
You don't even know what an attorney pro tem is, do you?
I know there's two categories. One is court appointed and one is recusal based, but I don't recall the nomenclature.
And Brandon Kamak wasn't either one of them, was he?
Oh, he said he was on the subpoenas.
Stop there. Brandon Kamak wasn't either one of them, was he?
No, he had no authority.
Wasn't an attorney pro tem, was he?
Honor, he keeps interrupting the witness. He should be entitled to finish his answer.
You're right, Mr. Hardin. I apologize, Mr. President. May I try again?
You may try again.
Mr. Kamak was not an attorney pro tem ever to your knowledge. True?
Like I said, I don't recall the distinction between the two categories of prosecutors, but he was not hired to be a prosecutor.
He wasn't hired to be any type of prosecutor. True?
Yes, sir.
He was hired as outside counsel because that's how you drafted the contract personally. Yes?
Yes, sir.
So when it says, Warren Kenneth Paxton misused his official powers by violating the laws governing the appointment of prosecuting attorneys pro tem, Brandon Kamak wasn't a prosecuting attorney pro tem, was he?
Not
Nope.
based on my understanding of what that.
I didn't think so either. Article 6, if you would, Mr. Arroyo.
Holy shit, dude. This guy is good. I like this guy very much. He's doing a great job of the law, like walking him through on the legal argument and just getting this attorney to basically agree to his legal arguments. And it's like, oh,
You're familiar
okay.
with this allegation dealing with whistleblowing, correct?
Yes, sir.
Whatever this attorney's getting paid is
Kind of
too little.
think Ken Paxton had a right to be upset with you reporting him to the FBI without any evidence.
I suppose he's entitled to whatever feelings he may have felt at the time.
Article 10, if you would, Mr. Arroyo.
This guy is just getting destroyed. I'm not even sure it's necessarily fair to this guy in particular, but I'm still here for it.
This says the Paxtons, and it says Ken Paxton, but you understand he's married to Angela Paxton, right?
Yes, sir.
So when somebody's spouse gets accused of bribery, and the form of the bribery is improvements to a home that are owned by both of them, really you're accusing both of them of being corrupt, right?
I don't know.
Don't you think?
I don't know the elements of bribery. I'm not a criminal lawyer, so I'm not sure what the implication could be.
As you sit here today, you know darn well that the Paxtons paid for the renovations and repairs to their home, don't you?
No, I don't know that, actually.
You don't know who paid for them?
No.
Maybe it'll come out in this trial. Mr. Vassar, would you expect to be placed on investigative leave for sending a set of secret grand jury subpoenas to your outside counsel and then deleting that email?
No, sir. I mean,
You wouldn't expect anybody to investigate that?
for sending an email to my personal lawyer relating to my report to law enforcement
Yeah.
and to be retaliated against by being placed on investigative leave. Is that?
No, my question was a little bit different, so let me be clear about what the question is. Wouldn't you expect the Office of the Attorney General to investigate your use of your office email to send secret grand jury subpoenas to that man, Johnny Sutton, and then delete the email? Wouldn't you expect to be investigated for that? Yes,
That
sir.
was.
No, not necessarily.
Okay. Wouldn't you
Great
expect
question,
to be
because you
fired
don't
for
care
that?
what the answer is.
No.
Wouldn't you expect to be fired for reporting your boss to the FBI without any evidence?
No, I would expect an opportunity to answer questions based on answers that I was provided when I asked, what documents are you alleging that I disclosed? And when no response was given, I couldn't give any further information about who the messages may have gone to or for what purpose.
Mr. President, I'm conscious of the indulgence of the hour, and I want to make sure that I'm not running up against any type of deadline or keeping.
We were prepared to go to 7 if needed.
Would you like me to continue?
You may continue.
I will be happy to.
I bet you are happy to continue.
You are the chief of the General Counsel Division at the Office of the Attorney General, correct?
At one point, yes, sir.
Yeah, so for the ladies and gentlemen of the jury who are here and may not be lawyers, and for the people of Texas who may be watching, you were really a lawyer to lawyers, correct?
That you could describe it like that. Yes,
That's
sir.
how I would describe it. General counsel is really a lawyer's lawyer, yes?
Yes, sir.
And so what happens in the Office of the Attorney General, when you are in the General Counsel's office, actual lawyers come to you and ask you for legal advice, yes?
Yes, sir.
And that happened regularly, true?
Yes.
Yep.
You were first chief of the General Counsel Division, and then you were Deputy Attorney General for legal counsel, true?
That's right.
And your first involvement with anything related to this impeachment was being approached in the fall of 2019 with a question about an open records request made to the Texas State Securities Board, true?
That's true.
And Ryan Bangert approached you with a question. Remember, you're the lawyer's lawyer. He approached you with a question about whether the State Securities Board's involvement in a joint task force could harm the law enforcement or investigative privilege, true?
That's my recollection, yes, sir.
And you answered his question, yes?
Yes, sir.
And then you were not involved in anything else related to this impeachment matter until March 2020, true?
That's not true. I think it was May of 2020, which was the DPS request.
You're wrong about that, but
Okay.
I just want to make sure I understand what your understanding of the timeline is, okay? So when was the period of time when you believe you first got a request or an open records request related to this impeachment matter?
Well, to back up just a little bit, if I may, I was not promoted to deputy for legal counsel until April 1st of 2020, so I wouldn't have been overseeing the open records division until after April. So I don't know when the DPS request was submitted to our office. That could have been the date that we received it in March, but I wouldn't have been tasked with anything related to it until after I was promoted on April 1st, and then the conversations that I had in May of 2020.
Tell the ladies and gentlemen of the jury who Joe Larson is.
I believe he's an attorney representing Nate Paul.
And what type of work does he do, to the best of your understanding?
I'm not sure. He was a requester in 2 of the open records requests.
Yes.
I don't know if that's his practice.
In fact, Joe Larson works at, he's pretty well known in the state of Texas for being a Public Information Act lawyer, yes?
I'm not sure.
Had you ever encountered him before?
No, sir.
Okay. So I'm going to tell you, my understanding is on March 3 of 2020, Joe Larson sent what I call the big request to DPS. Okay, so the one that happened in 2019 was a request, public information was made to the Texas State Securities Board. Yes?
Yes.
Ken Paxton asked you about the law enforcement privilege. You answered his question. Oh, I'm sorry. Ryan Bangert asked you about the law enforcement privilege. You answered his question. And that went away. Poof. Yes?
Yeah, I never heard anything else. Yes, that's right.
Then March 3 of 2020, Joe Larson made a Public Information Act request to DPS, what I call the big request. He's asking for a whole lot of information related to the search warrant execution on Nate Paul. Yes?
I don't know about the dates. Again, I don't know when he submitted it to DPS, but yes, if that's how you want to categorize the big request, then yes, that is accurate.
Well, this is probably beneath many of the people on the jury who very well understand this, but for people who are watching at home, when someone makes a Public Information Act request of an agency in the state, the agency comes to the Office of Attorney General for representation, says, help us decide. Yes?
It's not representation, but it's a request for a ruling.
Yeah, they want a ruling.
Right.
And so in this situation, DPS wanted a ruling. Yes?
Correct. If they want to withhold anything under the Public Information Act, they must request a ruling.
But Joe Larson didn't wait for your ruling, did he?
I don't think I follow.
On April 10th of 2020, Joe Larson sent a demand to DPS saying, I asked for this stuff, give it to me now. Are you familiar with that request or demand?
No, sir.
And on April 16th, he filed a lawsuit to get it. Are you aware of that, sir?
I recall the lawsuit.
I'm going to show you what's been marked as Exhibit 5. I maybe light one copy. Your Honor, may I approach the witness? Thank you.
Thanks.
I have to say, for the lawyer's lawyer, I've had more confidence in people Once again, I'm forced to ask the question, am I, Uncivil Law, just massively overqualified?
We move for admission of AG Exhibit 5.
Because, yeah.
Mr. Hardin?
No objection, Your Honor.
Mr.
AG
Arroyo.
Exhibit
Oh, I'm sorry.
0050 should be admitted to evidence.
Thank you, Mr. Arroyo. Exhibit 5, if you would. This is good. What is this, Mr. Vassar?
This appears to be a petition for mandamus filed by Joseph Larson, as a plaintiff against the Department of Public Safety, April 16th of 2020.
Who did he sue?
He sued the department, it appears.
What did he sue to get?
I'm not sure.
Take a moment and look through it. Maybe you can figure it out.
Sure. So according to count one, Joseph
You don't need to read it out loud.
I think
I'm not.
Okay.
I'm summarizing.
I'm sorry.
I think the most damning indictment against Ken
suing
Paxton at this
DPS
point is that he hired and promoted this
Refusal
guy.
to produce the information.
Ken
that he
Paxton hired and promoted this guy to be the lawyer's lawyer, Office of General Counsel. Can you trust Ken Paxton's judgment?
Do you want me to continue?
Not quite. There you go. Thank you. Can you just pull up count one? Mr. Larson is suing DPS based on his big request for all the documents that DPS has related to the Nate Paul search warrant. True?
I don't know. It looks like, yes. Page 1 references the March 4th, 2020 DPS request for all communications. So we could call that one the big one, if that's the big request.
I call it the big request.
Okay.
Okay, so in the big request, Mr. Larson is suing to get all the raid information. Yes?
Yes, I mean,
Probable cause affidavit. Yes?
it says all communications in this document, but I would assume it would have said all records.
He wants the full Monty.
Right.
Everything DPS has related to the Nate Paul search warrant. Yes?
I'd presume
And
so.
he's suing to get it. Yes?
Yes, it appears so.
And the OAG was aware of this litigation. True?
Yes, we became aware of it. I don't recall when, but
It would be pretty stupid for Nate Paul to sue to get something that he already had, wouldn't it?
well, this predated any conversation. This lawsuit could have even predated a request for ruling to our office. So
Let me press pause there for a second. To be clear, this big request is the request to which OAG responded and said, we take no position on it. True?
yes, the big request.
Yeah, the big request. So this thing, by the time OAG even decides anything, Joe Larson's already sued DPS to get it. True?
Correct. If I'm following, so this was filed, it appears to be April 16th. The OAG's non-decision in the big request was June 2nd. So this lawsuit, and I apologize if I'm not following you, but
You are following.
Okay.
Mr. Vasher, you are following me. What happened is Joe Larson says, I'm not going to wait to see what the OAG decides on this. I'm suing. Right?
sure, I don't know what he was thinking at the time, but
And the OAG's no decision on the big request did not lead to the production of any documents to Nate Paul, did it?
not under the Public Information Act. No, sir.
No. But Joe Larson didn't stop there, did he?
If you're talking about the public information request to the Office of the Attorney General for the FBI brief, then you are correct. He did not stop there.
All right, let's press pause there. This third request from Joe Larson was for an unredacted copy of the FBI's brief. Let's go back a step. This is very confusing and arcane, so I want to go slowly. all right? When Joe Larson made the original big request of DPS for the search warrant, etc., DPS had to give notice to the FBI, yes?
Yes, sir.
Because they were holding the FBI's own documents, yes?
That's right.
Said, hey, we're holding some stuff that probably by right belongs to you. Do you want to object? And the FBI has a period of time to object, yes?
That's right.
And what the FBI did in response to that was they sent a legal brief, yes?
Yes, sir.
And that legal brief is a bunch of legal arguments from a lawyer at the FBI, yes?
That's right. The brief identifies the content of the information that the agency wants to withhold.
And the brief that the FBI generated and gave to Mr. Larson was almost completely redacted, like something you might get from the CIA, right?
I don't recall exactly, but based on what I recall, it was redacted.
It was just basically a bunch of pieces of paper with big black blocks on them, right?
I don't recall, but it was redacted. I do remember that.
And Joe Larson says, this is no good. He makes a demand for the unredacted FBI brief. He made a third request, so request number 3 under the Public Information Act, for an unredacted version of that brief. And he made it directly to the OAG's office, yes?
Yes, sir.
He didn't make it to DPS. He didn't make it to FBI. He made it to your office, yes?
Yes, sir.
And what happened is the OAG sent notice to the FBI, the same notice DPS had sent earlier, and said, hey, this guy wants a copy of the unredacted brief. You guys need to show up and object if you don't want him to get it. True?
Yes, that would have been the third-party notice.
And the FBI blew it, right?
I don't recall. I was not involved in those conversations. I don't recall.
The FBI made a mistake?
The FBI didn't respond in time. True?
True? I believe that could be true. I don't recall.
Oh, no.
I'm happy to refresh my recollection if you have.
Joe Larson got the unredacted FBI brief, yes?
Yes, I believe so.
And he got it because your office decided the FBI blew the deadline, yes?
That's functionally correct.
Functional? What do you mean?
Correct.
What does that mean?
Well, after we had advised General Paxton about the issue.
What did you need to advise him about? Ken Paxton, hold on a second. Ken Paxton.
Excuse me. He asked him, what do you mean? He's in the middle of answering, and he cuts him off because he doesn't want the answer. Excuse me.
Slow down.
You're very right. My apologies.
Did you want me to?
Did you need Ken Paxton to tell you that the FBI blew the deadline?
I'm sorry, did I need Ken Paxton to tell me that the FBI missed the deadline?
Yes.
No, sir. No. I brought it to General Paxton.
Not responsive to everything after no, sir.
Sustained.
So, after the FBI blew the deadline, Joe Larson got the unredacted FBI brief fair and square. Yes?
At this point, I want to see the unredacted brief. I wonder if it's on the record.
I assume so. I did not provide it to him, but I assume a copy was provided in response to the decision to let the brief go out.
Okay. Just make it like, tell the ladies and gentlemen of the jury like you would a 7th grader. Did Joe Larson get the unredacted FBI brief because the FBI blew the deadline?
It was mainly because General Paxton told us to release the FBI brief.
And he told you to do that because the FBI blew the deadline, right?
I don't know if that's why he told us that.
But they did blow the deadline, yes?
I don't recall. I was not involved in contacting them directly. I don't know what any responses we would have received or when.
Sorry. You're in charge of this, yes?
That's right.
And you can't remember, right?
No, I don't. I didn't have direct contact with the FBI about a brief or a notice. Those are all handled by the Opinions Division.
Are you satisfied in your own mind that the proper notice was provided to the FBI and the deadline was not satisfied?
Based on my knowledge, yes. I didn't see it, but
Paul's lawyer got that fair and square, didn't he?
Maybe under the Public Information Act.
The law, you mean?
Correct. Just under an interpretation
The law, you mean?
whether sufficient notice was provided or whether a third party submitted briefs that it wanted to submit.
It's just a brief. It's just a bunch of legal arguments, isn't it?
It is.
You told Rusty Hardin when he asked you on direct that this item contained all types of information that would subject law enforcement to potential retaliation, that somebody might come and shoot them at their home or something like that. That's not true.
Well, that's not exactly what I said.
This unredacted FBI brief is just a bunch of legal arguments from some Fed lawyer, isn't it?
Well, that's dismissive to our
Isn't it?
FBI friends.
The act requires the brief to identify information to which
Fed lawyers are good
exceptions
lawyers
might
too.
apply.
That's
The
all
Fed
he
need
asked
lawyers.
for, right? The brief.
Correct.
So the insinuation that Ken Paxton somehow got the file and sneaky, delivered it to Nate Paul, you don't have any evidence to substantiate any of that, do you?
I have no direct knowledge of what he did with the file when it was in his possession.
You want to make an accusation while you're here on the stand? You want to accuse the elected Attorney General of this state of delivering something to Nate Paul that he shouldn't have? Do you want to do that now?
I don't know what he did.
Woof. Woof. You know, for the head of the division, attorney's attorney.
So when Ken Paxton asked for the file, you gave him the file, right?
Yes, sir.
He had every right to ask for that, yes?
Yes,
If he just felt like looking at it, he could ask for it, yes?
that's right.
And irregardless of his feelings about Nate Paul and whether he was unjustly being railroaded or the feds are mistreating him, he had every right to look at it, didn't he?
Yes, sir.
And you don't know that Ken Paxton did anything illicit with that file, do you?
No, sir, I don't.
You're not here to testify about any of that, are you?
No.
In fact, when Ken Paxton had this meeting with you about the file, he told you that he had spoken to Nate Paul. He didn't hide that, did he?
No, sir.
He told you he would believe that Nate Paul was being railroaded just like he has been, yes?
Yes, sir.
He told you he didn't trust DPS or the feds, didn't he?
Yes, sir.
And he didn't
I'm going to
hide
send a resume to the Office of the Attorney General.
Not in that meeting.
Dear Office
by
of the
the way,
Attorney General,
that. Do you
I
trust
can
the feds?
count to 3.
Trust the FBI?
Sincerely yours,
Yes.
Kurt
I
Mueller.
have no reason not to.
See if they hire me.
Law enforcement and our peace officers.
You can't think of one reason in the last 3 or 4 years not to trust the FBI?
Dear Attorney General's
I mean,
office,
personally.
I know all my letters
Ken Paxton
and most
told
of
you
my
he didn't want to
shapes.
use his office to help the feds in any way.
Sincerely
didn't he?
yours,
Yes, sir.
Uncivil
Didn't
Law.
hide that from you, did he?
No, sir.
And when you were discussing the ruling, what I'll call the no decision ruling on the big request, you reached an impasse where each side made its case, and he's the boss, right? Yes?
Yes, sir.
And he didn't overwhelm you. He didn't tell you to do anything against your conscience, did he?
No, sir.
He told you to be a lawyer and make a decision, right?
No, sir.
You made a no decision, yeah?
Well, to clarify, it wasn't my decision to make. It was his decision for the ruling to be a non-decision. There was a couple of decisions in there that maybe confused me.
Have you ever seen the probable cause affidavit in connection with Nate Paul's search warrant? Have you seen it personally?
Yes, sir.
Earlier, you said that you delivered a file to, you gave a file to Drew Wicker, and just show the ladies and gentlemen of the jury with your fingers how thick that manila envelope was. Like that?
I'd say less than a quarter.
Dear
of an
Attorney
inch.
General Office,
Just
Austin,
very
big
thick.
city,
Probable
tall
cause
buildings,
warrant affidavit is 220
Capitol.
pages,
Wow.
isn't it?
I don't know.
Sincerely yours,
don't know, you said you saw
Uncivil Law.
Well,
Hire
I
me.
saw the body of the affidavit. I don't know if there was
These
anything
cover
else
letters write
attached to it.
themselves.
When DPS submitted its request to us, it was a request based on representative samples of information. So we would have received a representative sample of whatever DPS provided. And I don't recall seeing a document of that size.
Counselor, we'll go maybe 10 more minutes. You can stop anywhere you'd like in between.
You're very kind, thank you. I want to talk about the foreclosure guidance for a few minutes before we retire for the evening. The legal question from Ryan Bangert was, are foreclosure sales gatherings, quote unquote, since the governor and the local county judges and mayors had prevented gatherings of 10 or more people, right?
Yes, that's what I remember his question to be.
That's really the simple legal question. And you, as a lawyer at the OAG's office, you do your research and then you take a position, yes?
That's right.
Okay. And we agree that what you were doing was not a formal attorney general opinion, true?
It was not formal, that's right.
These are what you call informal letters or announcements, yes?
Yes. Informal opinions. I mean,
let's save us a little bit of time. I have a transcript of what you told the House Board of Managers. And what you told them was this AG foreclosure guidance was an informal letter or announcement, yes? True?
if that's what you're saying,
Is that what you said?
I don't recall. Again, based on my recollection of 402 and 418, those are the only two statutes that give the Office of the Attorney General express statutory authority to issue legal opinions.
And after you and Austin Kinghorn did the research and he explained to you his position on it, you talked to Ryan Bangert, true?
Yes.
And Ryan Bangert called you and said, well, that's not the right answer, true?
We prepared a draft and then provided that to Ryan Bangert, and then, yes, he called me and said that's not the right answer.
And Ryan Bangert told you General Paxton wants to stop these foreclosure sales, right?
Yes, he said we reached the wrong answer.
Yes. And so what you know secondhand is Ken Paxton disagreed with the result that you and Austin came up with, didn't he?
Yes, that's what.
And he has the right to do that, doesn't he?
Yes.
And he was elected to make those decisions, wasn't he?
Yes.
Did Ryan Bangert tell you, you know what, Ryan Vassar? There's two Ryans. I'll sign this so you don't have to ruin your career, Ryan. Did he tell you that?
No, sir. I don't recall.
Did he intimate that?
No.
Did he imply it?
No, it was basically a timing.
What do you mean it was basically a timing? Tell me what you mean.
We prepared the first draft. By the time Ryan had finalized the second draft, it was 11 o'clock at night or midnight, and he was talking with General Paxton, is my understanding. So I had gone to bed and wasn't available to sign it.
Were you happy to sign it?
I would have signed it.
You didn't avoid signing it, right?
No.
You didn't say, Ryan, I don't feel comfortable. Would you sign this instead of me?
No, sir. I didn't say that.
So Ryan Bangert didn't jump on the grenade, so to speak, and say, you know what, this is really dangerous, Ryan Vassar, I'm going to sign it. Did he?
Not that I remember.
Did Ryan Bangert tell you, Ryan, I totally disagree with what we're doing here, but I'm going to do it over my own strenuous objections?
I don't remember him saying that.
You worked on this opinion on Saturday night, right?
It was all day Saturday. Yes, sir.
But that wasn't even the only COVID opinion that went out that day, that Saturday, was it?
I'm not sure. I would have to go back and look.
Well, I'll put it in front of you here in a little bit.
I bet you will.
You do not have the first clue whether this informal foreclosure guidance stopped a single property foreclosure, do you?
I have no direct knowledge.
And you heard it secondhand from some Austin Business Journal article, right?
That's right.
Did you believe it? Did you believe it?
I had no reason to disbelieve it just based on the timing.
Did you do any research yourself?
No, sir.
Any investigation at all?
No, sir.
Just one problem. It's 100% false. Never happened. It's not true. It's pure fiction. Did you know that?
No, I wouldn't have had any reason to know that.
Your Honor, I believe this is a good time to stop for tomorrow if Your Honor is willing to conclude for the day.
Yes, court will adjourn for the day, 9 a.m. tomorrow morning.
Wow. Wow. Okay. Well, what do we say in conclusion to all that? All right. Well, I'll try to summarize his testimony today as best as I can. So his testimony in principle on direct was kind of essentially the same thing we've heard before. He was, high up in the leadership. In this case, like head of division, which I assume is like third in command or roughly equivalent there too. That he saw some things with respect to the hiring of this guy that were problematic, with respect to the issuing of the opinion that were problematic, and some other things that were problematic. And he did reasonably well on direct. Then on cross, in the first part of the cross, he came off as just evasive. The guy who's doing the questioning is really good in controlling the witness. He's really good in controlling the question. And he's like, that's not what I answered. Move to strike. I'll ask it again. Making sure that he gets the answer. Like, he's not letting him dilly-dally around, and like, he's keeping control of the witness, and he's doing a really, really good job of it. Right? So like, in the first half of it, he just comes off as evasive. In the second half of it that we saw, this guy's like reaching into a soul and destroying him from inside. And he goes through like article by article and shows, at least from his point of view, why they're not legally met, and sort of the elements are not legally met. And I'll reserve judgment on those issues. I'll reserve judgment because those are ultimately legal arguments at the end of the day, right? So I'll form my own legal opinions. Thank you very much, counselor. I'll form my own legal opinions, but I did appreciate that he was taking this guy to the woodshed and at least showing this guy like was unable to rebut, and he got him to accept his premises and stuff like that. It was really fascinating and wonderful to watch. And, and basically showing like he doesn't know anything, right? He doesn't know anything. And he jumped to all kinds of conclusions. And then, just with this like ultimate coup de grace of, you sent secret grand jury subpoenas using the government computer and then deleted the email to cover your tracks. That's not great. You shouldn't do that. You shouldn't send copies of the grand jury subpoenas to people who shouldn't get the subpoenas because they're secret. Yeah, so you're not supposed to do that. And yeah, that's not exactly ideal and wonderful. And he did this nice little thing, like, you're accusing Paxton of communicating like this secret file to people, but that's what you were doing. You were doing it. So like the whole thing with projection. Yeah. We also learned about self-licking ice cream cone, which was a nice little thing. So yeah. What would I say? What would I say about the whole thing? I mean, they're definitely instilling some doubt in my mind. I think is what I would say. They're definitely instilling some doubt in my mind. So they're definitely scoring some points for the defense that something is like off. And with the whole letterhead thing, which is just so petty. Like in the whole letterhead thing and all the rest of it, it's just so petty. And he's a lawyer, and he doesn't seem to know things or be well informed, and he's had all this time to prepare and he doesn't know things. It was, yeah. Yeah, we also learned the phrase. We also learned the phrase "no coincidences in Austin," which I refuse to credit. I'm sorry. I don't care how. I don't care about the saying. The saying will not be taken for the truth of the matter asserted. I think that what can be said is I think what can be said is I think these people genuinely believe that they saw something that they thought was problematic. But in the end, they acted in an informational dark way. And they acted in incomplete information. So, yeah. So that's what I would say. I would say that they, and as to the ultimate legal arguments, as to the charges, I'll reserve those decisions for another time. But I did appreciate his arguments about the legal sufficiency or lack thereof of various things. So. Yeah. The defense has made some very big promises about what they're going to be able to deliver in their case in chief, about what they expect to provide that will show that these people were ill-informed. And if Ken Paxton himself takes the stand, it will be truly fantastic and amazing. Help us understand as a layman how bad forwarding that info was. It's pretty bad. I mean, it's secret information and you're violating your own secrecy. You know, so you're acting at least as an ethics violation and probably in a criminal way. Yeah, as to whether or not he blew a couple charges out of the water, again, I will reserve judgment for that for another day. I can form my own legal opinions. Thank you very much. All right, so I'll reserve judgment on whether or not he blew those charges out for another day. So as to that, I hold it in abeyance. I hold that in reserve. And I'll come to those conclusions at a later time. I still want to hear more stuff. But there's definitely been some problems. $10 from England DG. Howdy Uncivil, just want to say thank you for broadcasting this and your insight. Super great stuff. Sandy gifted 10 gift memberships. Forbidden Biblical Knowledge said tip, yes, you are unqualified. Jules Buddha said, sorry for asking again. I was wondering, wouldn't their statements and witness statements be evidence once accusations of corruption was made? Well, maybe I don't understand your question, Jules, and you don't have to super chat me again. I'll pay attention to chat. And I'm sorry I didn't see your chat earlier, but obviously I'm a little tired, or I have been tired, and not necessarily completely cognizant at all moments, but I'll try to pay attention. Their observations are testimony. It is evidence. You know, eyewitness testimony is evidence. You know, the Attorney General did this. This is what I saw him do. This is how I saw him act. This is what I observed. I mean, that's all valid. You know, but it's like it only goes as far as you think it goes. And if there's other explanations for it, then, you know, so be it. Yeah, so I don't know if I'm answering your question, Jules Buddha, and I'll sit around for a second if you want to re-ask. If I was the prosecution, how would I go about trying to rehabilitate this testimony? For him, well, I don't know, because I don't know what other resources I have available. So I need to make a call as to whether or not okay. I need to know what resources I have available, but based on what I know, How would I rehabilitate it? Let me think for a second. I don't know. I guess just try to reemphasize, the stuff he did observe. It's like, because one of the things is like you had no evidence, like this idea like you brought no evidence to the FBI, which isn't strictly speaking true because they brought themselves, which is testimony. So maybe try to like go that way. I'm also way too tired to answer your question right now, Matt. Sleep and I have not had a good relationship last night. I apologize. My brain is not in ultra sharp mode. But like the fact that these lawyers are like, I really want to assume good faith. And maybe that's my failing. I really want to assume good faith. To the extent I have bias. Again, I have a generally positive opinion of my profession. I want to assume good faith. I want to assume that these people thought they were doing the right thing. Perhaps I want to assume I have a default assumption, maybe better way of putting it. I have a default assumption that these people did what they thought was right, that they really saw problems, that they really did something because they thought something was wrong and rotten in the state of Denmark. And they ultimately decided that things were problematic and they could no longer support it, and they thought that there was a problem. So I suppose that's my bias coming in, is that I want to assume that these are good people. And I don't know necessarily that I've seen that they're not good people in all that's been said about them, right? They have, the cross-examinations have illustrated, or attempted to at least illustrate, that they were that they didn't have a complete picture, that they were presumptive, that they were perhaps hasty in their judgment. But that's sort of what I think. They seem like good people. And yeah. Good intentions, but not very smart. But these people are like head of their class. Number one in their class in law school. Judicial clerkships. I don't have judicial clerkships. Baker's bots, partners. Like, they seem like they're hardworking and knowledgeable. So if like they're not smart, what does it say about me, Because I don't want to have too much of an inflated ego either. So I don't know. Let me take a look at the impeachment charges again. Let me take a look at the articles of impeachment real quick and see if I can say anything about them on a legal level. Article 1. While holding office as Attorney General, Paxton violated his duties of office by failing to act as a public protector of a charitable organization. Specifically, Paxton caused employees of his office to intervene in a lawsuit brought by Roy F. and John Cont Mitt Foundation against several corporate entities controlled by Nate Paul. Paxton harmed the Mitty Foundation in an effort to benefit Paul. While holding office, he misused his official power to issue written opinions. Caused his employees of the office to prepare an opinion and attempt to avoid impending foreclosure sales of properties belonging to Nate Paul or business entities controlled by Paul. Paxton concealed his actions by soliciting the chair of the Senate committee to serve as a straw requester. Are we going to hear from the senator as a witness? Furthermore, Paxton, that'd be interesting. Are we going to hear from the senator as a witness? And then, if so, does he still get to be a juror? Because that would be bizarro world, but, you know, it's political, so it's made up. Furthermore, Paxton directed employees of his office to reverse their legal conclusions for the benefit of Paul. I don't know. I'm way too tired to adjudicate this right now. How much faith do I have in the criminal proceedings succeeding in a real court? I don't. As to this stuff? As to these things? I don't know what the appetite is for such a thing. I don't know that they would try to go after him criminally, even though of course they could, but I don't know that they'd try. You know, it might be enough for them to that he's out of office and can't hold it again. But hypothetically, at least in principle, it's supposed to be the same legally. So if in the end of the day, if in the end of the day I conclude that he is guilty beyond a reasonable doubt, then, which is the standard I'm supposed to reach for the purposes of the impeachment, if at the end of the day I conclude he's guilty beyond a reasonable doubt, then as to the criminal process, I've already decided that issue too. They're one and the same. It's the same question. So if I say he's guilty for the purposes of impeachment, then as far as I'm concerned, his fate is sealed. So we'll see. We'll see. I suppose if we had to put this on a level of confidence right now, from like 0 to 100 on probability or certainty to convict, that's a good question. Can I even answer the question I just posed? On a scale of 0 to 100, where are we right now in terms of certainty? Well, are we more certain than not? Are we at 51%? No, I don't think so. Are we a probable cause? Sure, but probable cause is dirt easy. So probable cause is like 30%. So we're hovering around 30%. Yeah, that sounds about right. Let's call it 30%. So I'm 30% confident. I'll get back to you. Would I vote to convict today? Probably not. No, probably not. I am somewhat doubtful that I can close the gap from where I am to beyond a reasonable doubt. You know, if I'm at 30% right now, asking me, am I ready to convict, is asking me, are you at 98%? And I'm like, well, there's a lot of distance between 30 and 98. So I don't think I can close that gap right now, so I'm going to go with no. Are we sure, Josh? Because I think it's 2/3 to convict. It's pretty sure it's 2/3 to convict. I thought it was majority, and then I thought I read the rules and it was 2/3. So I could go back to the rules, but I thought it was 2/3 to convict, not simple majority. If it's majority, he's toast because they have the votes. If it's 2/3, then it's close. All right, let me schedule for tomorrow. Yeah, so they need 21. They need 21. And what did they have? 22? Because they had some 8s. Did they have 7s? I forget what their votes were on motions to dismiss, what the votes were. Did they have a 7 in there somewhere? So what are they at? 22, 23? So he needs to flip like 2 or 3 votes or something like that? Which, you know, is potentially very doable. Yeah, the 12 Democrats will vote to convict. Of course they will. But I don't care about that right now. Oh, well, maybe I should, because it is ultimately political. Although I'm trying to view it from a legal lens. So I don't care. I don't care. I'm trying to view it through a legal lens. Someone else can do political lens. Right? Which in this case is, what do my constituents want? What will get me reelected? Which I don't know the answer to that question. Because why would I? So I'll just view it for a legal lens. Yeah. They don't need to flip 9 Republicans. They need to flip 2 or 3, something like that. They don't need to flip 9. If they need to flip 9, they're fucked. I can't flip 9 votes. There's no way. Yeah. 12 plus 9 is 21, yeah. So they need 9 Republican votes. Yeah. That sounds right. All right, what's tomorrow? The 8th? And we're going to be here at 8:45 in the morning. They will impeach regardless of evidence? Maybe they will, Atlas. But for me and my house, we will try to make a decision based on the evidence in accordance with law. We'll try to make a decision based on law. Whatever they're going to do is their business. We're going to try to make a decision based on law. So that's what my mission is. We're going to try to reach a legal decision, like the lawyer that I am, and damn the rest. Because it's political, the fix may very well be in, but I don't give a damn. We're still doing it over here, baby. We'll be the last vestige. It'll be me and you guys. It'll be us. We will judge. And we will reach an opinion. Whatever it may be, whatever the truth may be, let the truth be done. If Paxton is guilty, so be it. If he's not guilty, so be it. Let us try our best to reach a just and fair verdict in accordance with law. And an honest and thoughtful assessment, checking our own biases, going back to our earlier discussion, checking our own biases as best we can, an honest and fair assessment of the facts as presented. Put aside our preconceptions. Judge it based on the evidence offered. For good or ill, we roll. We roll. All right, I'm going to sign off. B Fish and I love you, and we appreciate that you're here. And we will do what we can. And it should be very interesting when we get to the end of this thing and try to assess the verdict, which means truth. I've been Uncivil Law. Until later, my friends, I hope all is well. Cheers, my friends, and goodbye.